Next week.
My lord, this application, my lord.
Leave is granted.
Application, my lord.
Next week.
My lord, the execution date is 29th October, my lord. That's why I am praying for.
Next week.
Only, my lord, execution will be done, my lord. It issued in the lower court, my
You have
lord.
mentioned yesterday, we took mentioning it. No, call on the list.
Item number 1.
In this matter, I am appending for the response. 11 has not been delivered. It appears from the report and LCR not has been.
Yes,
received.
my lord.
Lower court report has not been. I am for the response.
Regarding respondent number 11,
Yes.
6 to 9 have been delivered.
Yes.
The rest were appearing.
Yes, my lord.
Probably 11, no information from the site. So, should you direct you to put in fresh deposits for 11? Or do you have instruction to appear for 11? Respondent number 11?
Fresh service out, my lord. Respond in.
Nobody is
respect of
appearing
this-
for respondent number
No,
11.
I am not appearing.
Then the appellant will put in fresh requisites for 11. From the office report dated October 27, 2025, we find that the trial court records have not yet arrived before this court, nor has any information regarding service of notice of appeal on the respondent number 11 been received.
Yes.
So accordingly, the appellant shall put in fresh requisites for service of notice of the appeal on the respondent number 11, insofar as the trial court records are concerned, the office shall, the learned district judge of the concerned district shall furnish a report as to why the trial court records have not yet arrived and ensure that the trial court records reach this court at the earliest. Such report shall be filed by the learned district judge within a fortnight from the date of communication of this order to the learned district judge. Office to take steps accordingly. Great.
But I'm led by Mr. Owen Banerjee.
এটা অফিসকে পাঠিয়ে দিতে হবে, অফিস ডিস্ট্রিক্ট জাজের কাছ থেকে রিপোর্ট চেয়েছি একটা।
Item number 2.
My lord, I beg to appear for declaration. My lord, at my instance, my lord, it has been come as.
I am for the statement.
Why is it appearing?
My lord, there was a direction for filing affidavit by the state in 2023. My lord, it has not been filed. Very short matter, whether 6.3 would be applicable, estate acquisition.
So the state has filed affidavit?
In main matter, my lord, affidavit has been filed. In supplementary affidavit, I have used an supplementary affidavit. If he, my lord, wishes to file, my lord, there was an order in 2023 to file.
No, the office report says no affidavit on opposition and reply have been filed. You have filed?
I have filed. It is in the record, perhaps, my lord. I have served him also. It is all with me. I have filed. He has filed, my lord.
So why have you mentioned it then?
My lord, he has not filed.
For hearing, my lord.
For hearing?
Yes,
My lord, he has,
Right now not possible.
my lord, what I say, my lord. Supplemented, my lord. Kindly see the last order dated, my lord. 22nd September 2023, my lord.
Yes.
I have used an supplementary affidavit. Initially, it was submitted and time was extended for filing, my lord, reply, my lord, opposition to the supplementary affidavit.
You filed that after that?
I have
Has
not
to-
filed, my lord.
He has to file, my lord.
Then?
My lord,
You won't file?
Not my lord. If not, if possible, my lord, if it is necessary, my lord, I can file. Otherwise, my lord, I hope that will not
a
be
very short
necessary.
matter, my lord, 6.3 would not be applicable because on the date of vesting, there was no factory. Because my lord knows West Bengal is
On learned senior counsel appearing for the learned additional government pleader appearing for the state submits that there might not be any necessity for filing supplementary affidavit as per previous prayer
opposition.
on behalf of the state.
My lord, opposition, my lord.
Supplementary affidavit.
Affidavit I have filed, he has to file opposition, my lord, to that.
Acha, affidavit no opposition. Supplementary affidavit no opposition. So next para, accordingly, let the matter be listed for hearing in the monthly list of November 2025.
Yes, grateful.
Item number 3.
My lord, I appear on behalf of the
My
respondent.
lord, I am for the appellant. My lord, my appeal was defective. My lord, the defects have been cured. My lord,
What is the matter?
my lord, suit for eviction and mean profit. My lord, arising out of a franchisee agreement. My lord, shop being run by the name Just Baked. My lord, commission not paid. I terminate the agreement and institute the suit. My lord, suit filed in 2017. My lord, there are
Suit
interlocutory
filed by you.
by me. My lord,
For?
my lord, for eviction and mean profits. Now, my lord, in the meantime, my lord, the Commercial Courts Act came, my lord, the specified value was notified. Thereafter, my lord, we have applied for transfer. My lord, the learned court below holds that, my lord, this is a commercial dispute, but my lord returns the plaint, does not transfer it. My lord, I am aggrieved only to that extent.
So what is the difficulty in presenting it before the appropriate?
My lord, I will have to perhaps, my lord, do pre-institutional mediation again. My lord,
Commercial
12.
Courts Act.
Moreover, my lord, the commercial court practice directions say that whatever was pending, my lord, as on date of notification of the specified value has to be transferred. It is only when a suit is instituted after, my lord.
You had applied for transfer.
Yes, my lord. Yes, my lord.
Section 15.
Yes, my lord. My lord, my
We'll
prayer.
modify the order and ask you to time. The limited grievance in the present matter is that the plaintiff stroke appellant had applied for transfer of the suit to the concerned commercial court in view of the intervening notifications in terms of the Commercial Courts Act, 2015. Whose of learned counsel for the appellant submits that Section 15 of the Act mandates that the pending cases shall be transferred automatically to the concerned commercial court having determination. Whose of next para, we find from the impugned order that the learned trial judge has, instead of merely transferring the suit to the appropriate commercial court, return the plaint to the plaintiff, thereby entailing consequences beyond the scope of Section 15 of the 2015 Act. Full stop. Upon hearing learned counsel for the parties, we find that there is substance in the contention of the appellant and the matter should have just been transferred to the appropriate commercial court having determination. Full stop. Accordingly, FMET 394 of 2025 is admitted and on consent of parties is being disposed of. Full stop. FMET 394 of 2025 is hereby allowed, thereby modifying the impugned order dated August 6, 2025, passed by the learned civil judge senior division at Shialda, district South 24 Parganas, in title suit number 91 of 2017 by directing the said suit to be transferred to the commercial court at Rajarhat. Full stop. The said transfer of papers shall be effected at the earliest, preferably within 4 weeks from the date of communication of this order to the learned civil judge senior division at Shialda, and thereafter be renumbered in the commercial court at Rajarhat, which will then proceed with the hearing of the suit in accordance with law. No address to cost. Can such and such, can one of 2025 stands disposed of accordingly as well. No address to cost.
Item number 4.
My lord, this is my appeal.
Yes.
My lord, firstly, my lord, we are sorry for our absence yesterday, my lord, and we are grateful that your lordships, my lord, have given us another chance. My lord, affidavit of service, my lord, if I may place on record.
You are appealing for the other side.
My lord, I appear for defendant number 2.
I
Who
would
is-
say respondent one.
One.
My lord, I am praying, my lord, for some relief today. May I just indicate, my lord, what the matter is? My lord,
Just there are two defendants, two respondents only.
two, yes, my lord.
Yes. What is the matter?
My lord, if your lordship just sees the cause title, the plaintiff, my lord, is propounding his father's will. He's the executor named in the will and he's filed an application for probate. The defendant number 1 is one sister who's opposing the will. She has withdrawn her consent to the will, contending that her consent was wrongly taken initially when the probate application was filed. And the second sister is supporting the plaintiff. So essentially one sister, one brother together, and one sister opposing the will. She feels the will is unfair. And my lord, the will has been registered. Now, my lord, there were shares held through HDFC Demat account, of which, my lord, the opposing sister, defendant number 1, was the nominee. 225 scrips. The value of those shares, my lord, is about 15 crores. As on, my lord, the date of the death of the deceased. So, my lord, I, as the executor, filed an application, my lord, in the nature of Order 39, Rule 1 and 2, my lord, for restraining the opposing sister from alienating those shares, my lord, contending that she is just a mere nominee and that, my lord, nominee doesn't become the owner. My lord, there's judgments, my lord, settling that, and that nominee is just a custodian, and ultimately the shares are to devolve as per intestate succession or testate succession. And my lord, the argument was that hypothetically, assuming that the will is probated, then all these shares would go to the other sister, because it says that all movables, etc., will go to the other sister. And assuming, my lord, for sake of argument, that the probate fails, my lord, then it's not the case that there's another will. So in that event, my lord, it will go 1/3 to each. So even, my lord, in the worst case, the brother and the sister who are, my lord, together contend that they'll at least get 2/3 of, my lord, the value. So, my lord, on these arguments, my lord, the learned judge injuncted, my lord, the opposing sister from alienating, my lord, these shares. But, my lord, if I place my application, my lord, the prayers were A, injuncting from, my lord, the shares from being alienated, B, injuncting the dividends from being alienated. Because dividends are about, my lord, 19 to 20 lakh rupees per.
Dividend part was not granted.
Dividend was not granted.
You are
So-
agreed with that.
Agreed with that. And, my lord, also, my lord, I must confess, my lord, the prayers were, my lord, in the nature of, my lord, the prayers in the Birla applications. My lord, if your lordship recalls, my lord, Justice Bhattacharya would perhaps connect with this. My lord, for, my lord, replacing me, my lord, for me as the executor to be named, I get voting rights in respect of those shares. Of course, my lord, these are not family companies. These are, my lord, blue chip entities, my lord. But nonetheless, my lord, prayers, if I just show the prayers,
That would be in the nature of letters of administration.
my lord, initially,
You
my
cannot
lord,
convert an injunction in the garb of an injunction. You cannot ask for letters of administration because you know the tastes are different, somewhat different.
my lord, protection.
Protection regarding injunction, we can think about the injunction.
Your lordship will just consider, my lord, the prayers that I
Your
played.
names, putting your names would be a bit mandatory in nature. We'll give you liberty to file an appropriate application for letters of administration for that, subject to hearing theirs.
My lord,
But
kindly,
regarding dividend, yes,
your lordship would just consider, my lord, the prayers that were, my lord, prayed for.
yes.
My lord, my petition, my lord, is at page 61, and the prayers, my lord, are at page 71. My lord, injunction restraining defendant number 1 from selling, transferring, alienating, encumbering, or otherwise creating third-party rights in respect of the shares of the deceased, which the defendant number 1 was the nominee, including but not limited to those shares which were held through the deceased HDFC demat account. Then, my lord, second, direction upon the defendant number 1 to disclose on affidavit all transactions. So, my lord, disclosure, my lord, is, my lord, it can't be, my lord, alienated from, my lord, injunction. My lord, it comes within the ambit of Order 39, Rule 1 and 2. My lord, I can place, my lord, Order 39, 1 and 2 to say all necessary orders which are, my lord, necessary for preserving, my lord, the subject matter of the suit, not just, my lord, injunction. My lord, if they have been operating, my lord, the demat account, the least they can do is at least disclose what transactions they've
Why
done.
1st June 2021? What happened on 1st June 2021?
My lord, that is, my lord, when the because up to 31st May 2021, I have the statements, and the deceased, my lord, had died round about that time. Now, my lord, next, the plaintiff be authorized to take over possession and custody. My lord, these are again the press C onwards, my lord, are, my lord, in the nature of the Birla press. And my lord, in prayer B, I also sought for particulars of dividends. And if your lordship will see the written objection that they filed, they have in one sentence stated that it is not 225 crores, 225 scripts anymore. And there have been transactions, the value is much less now. But they don't, my lord, clarify as to how much is it less by, what transactions, my lord, have transpired. And my lord, the dividend aspect, my lord, also, my lord, has not been granted.
Yes. What is your defense in the probate proceeding?
My lord, if you just kindly see the order of
No,
the
tell us what is your defense in the probate
my
proceeding?
defense is that, my lord, since 2020, 25th, 2001, my lord, overall control over his
What is the defense in the probate proceeding against the will?
against the whole defense is that, my lord, his consent was not given, and on that basis,
Your consent, irrespective of your consent, how do you challenge the will itself, execution of the will?
that has been challenged, my lord. The will
On what ground?
Will has been made, my lord.
This is not a classroom, ma'am. Please. This is not a classroom. Yes.
My lord, in this respect, my lord, this is the case, my lord. His challenge, my lord. The will.
You can take instruction from your client. Take instruction from your client. Your client is apparently ready with that.
May I say one thing, my lord?
Take instruction. No,
On the
no,
day
no,
of
no,
the
we are
impugned
getting-
order.
no, not now.
On the day of the impugned order,
First signature has been done to grant probate, my lord.
Very well.
On that respect.
Yes. What is your argument against this, the present prayer? Why shouldn't you disclose whatever transactions have been held? Because these are the subject matter of the will. It will
My
be
lord,
decided in the probate proceeding.
One entire submission has been made by my client, my lord, before the trial court, my lord, wherein, my lord, if your lordship kindly go through the order of the learned trial court, my lord, page 6, my lord, kindly see on it for a moment. But there is specific case, my lord. Defendant opposite party number 1 was under control of the plaintiff petitioner.
That's your case. Definitely, we don't have
Yes.
any qualms on. You can prove your case in the probate
Yes, my
proceeding.
lord. So that's
But in the meantime, we have to ensure that the dividends are not dissipated.
but that
If those vanish in the meantime, then what remains if the probate is granted ultimately?
there is also page 8, my lord, specific order, my lord, to restrain me, my lord, to take any steps. I am not given
Regarding the shares, you cannot transfer the shares, but the dividends also
that
you
has
have
been
to.
given, my lord. Transfer share,
No,
my lord, that act
The
of
dividends also you cannot transfer. You cannot withdraw the dividends. If
also
you withdraw the dividends, those will be dissipated. If ultimately probate is granted, what will remain in the estate?
so you should kindly direct the learned trial court to dispose of the case immediately, my lord. As early
Is it possible for the trial courts? Are there are servants? Is it possible for the trial court to do that? He's a
Rather,
judicial officer or she's a judicial officer.
but trial court has
They have their other duties also, rosters also, like us.
trial court also restrain the matter, my lord, restrain the matter to take
We will also restrain you from disposing of the dividends in the meantime. We'll do that. But regarding and accounts also, whatever has been transacted from 1st June, you file in the trial court.
That has been stated in the order scene, my lord. 1st June, my lord, I have no accounts, my lord, since 2021.
File an affidavit disclosing whatever has been done from 1st June. If nothing has been done, disclose that with the supporting documents. Do that. We'll only direct you that.
Yes,
We'll dispose of the appeal itself.
before the trial
We'll
court.
dispose of the appeal.
My lord, one
But
only
we won't give you control right now.
only one concern I have. I don't have a document to show it, but I know it has happened. On the day of the impugned order, when the impugned order was scheduled to be passed, shares was 1 crore, almost 1 crore rupees have been sold. We've learned this, my lord, from the concerned, my lord, bank, but my lord, we don't have any document, my lord.
No, we understand that, but whatever has been done will be disclosed by them in an affidavit, and they'll be guilty of perjury if they falsify their statements in the court.
My lord, I'll leave it to your lordship, my lord.
We'll do that. We'll dispose of the appeal itself. We are taking consent of both of you to dispose of the appeal itself. Why keep it pending here?
Yes, ma'am.
We'll express an expectation that the trial court, the testamentary court decides this as early as possible, but no timeline. 25
yes.
matter.
And your lordship will, my lord, give me liberty to make, my lord,
Letters of administration. Or what?
my lord, I'm
Make
the
what?
no, my lord, for my lord, my name, my lord, to be shown in all the companies as the holder of the share, as executor.
Not right.
This is not
Because my lord, those
not
prayers were
legal.
made, but those prayers, my lord, have been just rejected in one sentence.
No, in an injunction or order 39 rule 1 2, that is not.
No, but-
will permit you to file a proper application.
Yes,
Letters of administration. That is what you were saying. If you file that, they will have an opportunity to deal with that application also.
very well, my lord. Your lordship may just give me because
Only that opportunity, and trial court, if you file it, trial court will decide in accordance with
In
law
accordance with
upon
law.
hearing them.
Grateful, yes, my lord, no difficulty.
Yes.
It's just, my lord, I don't want this to be barred by res judicata. That's my only concern. Because these prayers were there, and
Right.
in one sentence,
Understood.
it's been rejected.
Understood.
That is-
Understood. And res judicata, does it? Anyway, at the interim stage, it may. At the same stage,
Take
it
a
may.
point of maintainability, then that goes on for 6 months, my lord.
The present appeal arises out of a probate proceeding. Push up in view of several questions, several arguable questions being involved, comma, the appeal is admitted. Push up on consent of the parties, comma, the appeal is taken up for final hearing and disposal. Push up next para. The plaintiff stroke appellant, comma, claiming to be the executor of the last will and testament of late Krishna Kumar Bhalotia, comma, took out a probate application which was initially consented to by both the sisters. Full stop. However, comma, you are respondent number 1.
Respondent 1.
Respondent number 1 subsequently challenged such consent and opposed the matter, comma, thereby turning the probate proceeding contentious, comma, giving rise to an original suit being registered. Full stop. Next para. In the said suit, comma, the plaintiff filed an application for injunction as well as other reliefs. Full stop. The nature of injunction, comma, inter alia, comma, was that the respondent number 1 shall be restrained from transferring the shares of the estate of the deceased testator, as well as from alienating the dividends in respect thereof. Full stop. In the injunction application, comma, the plaintiff stroke appellant further prayed that accounts be submitted from June 1, 2021 till date in respect of all shares of the deceased by the defendant stroke respondent number 1, in which the latter was the nominee. Full stop. Next para, that apart, comma, the plaintiff stroke appellant sought authorization to take over possession and custody of the shares of the deceased, of which the respondent number 1 was the nominee. Full stop. Next para, learned counsel for the appellant submits that although the learned trial judge granted injunction in respect of alienation of the shares, comma, the rest of the prayers were not granted. Full stop. Next para, it is submitted that in the event the estate is permitted to be dissipated by alienations and transfers by the respondent number 1, comma, the final outcome of the probate proceeding might be rendered academic and infructuous. Full stop. Learned counsel for the respondent number 2 supports the contentions and of the appellant and adopts those. Full stop. Learned counsel for the respondent number 1 submits that serious challenge has been thrown to the signature of the testator in the will in the probate proceeding itself. Full stop. That apart, comma, it is contended that injunction has already been granted by the learned testamentary court in respect of transfer of the shares, and comma, as such, comma, there is no scope of grant of any further order. Full stop. Upon considering the submission rival contentions of the parties, comma, we are of the opinion that mere restraint order in respect of transfer of the shares might not suffice, comma, since in the event the dividends derived from such shares are permitted to be transferred to some other account or alienated in any manner by the respondent number 1, comma, the final outcome of the probate proceeding might be rendered fruitless to an extent. Full stop. However, comma, in respect of the prayer of the plaintiff stroke appellant to acquire possession and control of the shares in respect of which the respondent number 1 is a nominee, comma, this court is of the opinion that such prayer is more in the domain of an application for letters of administration within the contemplation of the Indian Succession Act and does not, comma, stricto sensu, comma, come within the ambit of an injunction application under Order 39, Rule 1 and 2 of the Code of Civil Procedure. Full stop. The scope and ambit of the two provisions are different, and as such, comma, such prayer was rightly not granted in the injunction application. Full stop. In view of the above discussions, comma, FMAT 410 of 2025 is disposed of by modifying the impugned order to the effect that in addition to the injunction in respect of the shares already granted by the testamentary court, comma, we grant further injunction restraining the respondent number 1 from alienating or dealing with the dividends derived from the shares in respect of the estate of the deceased, comma, of which the respondent number 1 is a nominee, comma, till disposal of the suit. Full stop. Next para, that apart, comma, the respondent number 1 shall also file an accounts in respect of the said shares in the trial court within 4 weeks from date starting from June 1, 2025,
2021.
Sorry, 2021 till the date of filing such accounts and shall continue, full stop. Next para, it is made clear that nothing in the above order shall preclude the appellant from filing, shall preclude the parties from filing an application for letters of administration. You can also file letters of administration. Full stop. If so filed, comma, the learned trial judge shall decide the same in accordance with law upon giving opportunity to the other parties to contest the same duly. Full stop. Next para, it is further clarified that the merits of the testamentary suit have not been gone into by this court, and it will be open to the learned testamentary court to decide all issues duly in accordance with law, independently of the observations made above in the main testamentary suit. Full stop. No address to cost. Urgent certified copies. Before that, please add can 1 of 2025 is accordingly disposed of as well. এগুলো judgment form হবে এটার আগেরটা.
No, would your lordship just consider clarifying one thing, that the injunction, my lord, today, which is granted in respect of dividends, is for dividends received so far and dividends which may come in, because my lord, dividends keep coming in, my lord. on a regular basis into
So that
the estate.
injunction will operate still disposal of the suit means the dividends regarding the shares.
That would include the dividends already, my lord, gotten, because dividends have been accumulating for the past 2 or 3 years.
So we are passing this order today. We cannot do that. Previous will be covered by the accounts.
Right.
Status quo ante, that will be injunction ante. We are not granting that.
Then your lordship would, my lord, give me liberty that upon, my lord, me being given, my lord, accounts, I could, in furtherance of the accounts, I could take some necessary steps for
Accounts
protection
are
of the
filed for that
estate.
purpose. You can do whatever in the suit. We did not give you any liberty. Any liberty would be constituted as a right in the trial court.
Very well, my lord. I'm grateful. My lord. Grateful.
Item number 5.
Yes. This is the second occasion when none appears for the parties at the time of call. Accordingly, FMA 1335 of 2025 is dismissed for default without an order as to cost.
Item number 6.
For the appellant,
Move it.
I'm afraid for not this week, man.
No, refused. Move the matter.
I'm not in.
You did not appear yesterday also. Sorry, no time. What is the matter about? Either move it or we'll dismiss for default.
Kindly,
No time, sorry. We are burdened with a heavy list. We are not granting any adjournment, sir. Please move the matter.
kindly pass over, my lord.
Pass over for 10 minutes. Prepare yourself. Yes. Next. Dashmit Bada Vatagre.
Item number 7.
Well, I'm for the appellant, my lord.
Yeah.
My ad interim order refused
Yes.
by the trial court.
Is there any caveat, Mr. Kasimuddin?
We have not received any intimation. Lordship.
Yes. What is that?
If the property is at Canning Street, there was a lease executed between the lessor and the lessee in the year 2004. Now, in that lease deed, there was a permission granted to the lessee to induct tenants, sublet, etc. Lordship, I'll
You
show
are the
you.
lessee or the lessor?
No, I am the tenant. I was inducted tenant under the lessee. And there was a provision in the lease deed that you can induct tenant, you can allow
The parent lease deed.
in the parent
That
lease
they
deed.
can induct you.
Yes, yes, yes. That I've Lordship, will kindly come.
Right.
To page 35.
No, let us proceed on that premise
Right.
that was there. Then
Now, I was inducted in 2010. There I was continuing staying there. I'm paying rent, everything. Now this lease expired on 31st March 2025. Thereafter, I was informed by the lessee that I've surrendered my leasehold property to the original lessor. So you pay the rent to the lessor. Now the lessor is not
which lease expired? The parent lease.
the parent lease. I am a tenant under the lessor. So now when I approach the lessor, now there is a threat of disposition. She is not accepted. They are not
But your
accepting.
right goes with the parent lease. You cannot have a greater right than the your
Lordship, but
settled. Ask any law student, Mr. Kasimuddin. Ask your if any relative is in law, then ask him or her. You know it. You don't have any right apart beyond your.
no, but then there was a clause that Lordship, you can just see the clause for a moment. Lordship.
Show us your best clause. Start with that. Otherwise, you don't have a right.
Lordship, you kindly see page 35, Lordship.
Yes.
Internal page 4,
Yes.
clause 7, Lordship. I will write.
Yes, please.
The lessee shall be entitled to induct tenants in the newly constructed portion to a maximum of 8 subtenants on intimation to the lessors.
Any right of becoming direct tenant? No.
No, that is what they have stated. Then thereafter,
So what do you want now? You filed a suit.
we have filed a suit. I saw a declaration. Now I become a tenant under the original lessor.
How?
That is the declaration of short lordship, because we are saying that it was intimated. There was a permission granted to the lessee. And we sought protection that in the meantime, I should not be disposed from due process of law. Lords. That was my contention.
We'll reject your plaint from here. We'll spare you the agony of litigating for long years. No.
Lordship,
No
kindly see.
No interference. Yeah, we have seen having hard paragraph, we have seen. With or without your glasses, Mr. Kasimuddin, it's the same thing.
It's a difficult here, sir. Because Lordship, the issue is that
It would not change the situation.
the person-
Rightly, this is the correct finding.
the caretaker of the lessor, he was collecting rate. They were duly intimated.
We have no doubt that you were legally inducted. But now your right has expired. Prima facie notice.
Lordship, may kindly appreciate one thing, Lordship.
Just wait for their counterclaim.
What? Sorry, Lordship.
Just wait for their counterclaim. It is coming.
Let there be a contact claim. In the meantime, I should not be disposed without Lordship. Let us assume that I'm a trespasser. I saw Lordship's order. But even
That's the difference.
if Lordship
trespasser cannot claim an injunction. Yes, trespasser cannot be evicted without due process of law. We agree with that. But trespasser cannot enjoy an injunction against the main owner. Against the true
Lordship,
owner. You cannot get an injunction. You cannot get a positive injunction against in your suit. You cannot get an injunction against it. He cannot evict you without due process of law. He has to file an eviction suit.
Lordship, that is true, Lordship. But the thing is that for the 15 years staying there, the person is coming, collecting rent from the caretaker is coming, Lordship. This clause was there that I was to induct tenants. I've got a right to be there.
Agreed.
Staying there, Lordship. All the entire position is there, Lordship. I have not defaulted.
No, Mr. I'm sorry. The present appeal arises out of the ad interim refusal of injunction to the plaintiff stroke appellant. Full stop. The plaintiff stroke appellant claims to be a subtenant.
Lordship, can I not press my application?
No, not at this point. Subtenant in respect of the suit property. Full stop. The immediate lessor of the plaintiff, that is the lessee in the original lease, comma, had a right as per the plaintiff appellant to induct tenants in the suit property. Full stop. Next para, learned counsel appearing for the appellant places reliance on clause 7 of the parent lease deed between the original owner and the lessee to establish such contention. Full stop. Next para, it is submitted that subsequently upon the expiry of the parent lease, comma, the defendant stroke respondent sought to evict the plaintiff stroke appellant, for which the suit had to be filed and an injunction was prayed. Full stop. It is argued that even a trespasser cannot be evicted from a property without due process of law. Full stop. Hence, comma, since the appellant claims to be a direct tenant under the original lessor, comma, the learned trial judge acted without jurisdiction in refusing to grant ad interim injunction protecting the possession of the appellant. Full stop. Next para. However, comma, upon hearing learned counsel, comma, this court is of the clear opinion that the tenet of law that even a trespasser cannot be evicted without due process of law cannot be stretched so far as to entitle a trespasser to an injunction against the true owner. Full stop. Next para. Undoubtedly, comma, the position of law is settled that even a trespasser cannot be evicted without due process of law. Full stop. However, comma, the status of the present appellant is only through the appellant's lessor, that is the lessee in respect of the original lease, comma, the lease granted to whom itself has since expired. Full stop. Next para. It is another well settled proposition of law that one cannot give more than what one has, and as such, comma, with the expiry of the original lease, comma, prima facie the right claimed by the appellant through the original lessee has also expired, comma, thereby disentitling the appellant from claiming any right of possession in respect of the suit property. Full stop. Next para. Thus, comma, we do not find any illegality in the impugned order refusing to grant ad interim injunction in respect of the possession of the appellant in respect of the suit property. Full stop. Accordingly, FMAT 323 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Consequentially, Can 1 of 2025 is also dismissed. Full stop. However, make it clear that we have not entered into the merits of the main injunction application and stroke or the suit, and it will be open to the learned trial judge to independently decide on merits, the injunction application and the suit in accordance with law. No address to cost.
Grateful, Lordship. Next. So next matter, Lordship, I'm not pressing the application.
Item number 8.
Lordship, same. But I'm not moving this application, Lordship. Kindly grant that.
Learned counsel for the appellant submits that the appellants do not want to proceed with the matter. Accordingly, FMA 1563 of 2025 is dismissed for non-prosecution without any order as to cost.
Obliged, Lordship.
Item number 9.
And my lord, I am appearing on behalf of the respondent number 12 to
Yes.
21.
This is the matter, Mr. Rai. You said no affidavit.
My lord, upon instruction that Mr. Debojyoti Bhattacharya appearing for the
Late
state,
instructions. We had already taken up the matter yesterday. You were not there. Let us hear the matter. What is the matter? Who is for the petitioner?
I am for the petition.
Yes, move the matter.
Now the order has been passed in absence of the applicant in
my
merits.
lord, on
This is the
intelligence,
plea report I am taking. Can you turn to the order impugned?
10th of January.
Yes, my lord.
What was the nature of the order? Let us.
But
The set himself appeared there. Yes.
yes. None appears on behalf of the applicants in this way. Subsequently, it was held that the documents are considered and ultimately held
Oh, your application was dismissed on merits.
merits in absence of me.
Remand.
My lord, facts of the case is that, my lord.
Facts we are not concerned with the facts, but their case can be advised dismissed for default. In their
Section
absence.
16E of the President Tenancy Tribunal Act will cover the civil procedure code will apply so far the dismissal and also passing an order of expertise. If your lordship may I draw your lordship, there is a
Let us formalize it.
my lord, on intelligence, my lord, Mr. Siddiqui appearing for the learned AGP, he resigned from his,
Yes. Where is the book?
that is why, my lord, I pray for not today, my lord.
Refused. Yes.
16E. West Bengal Land Tenancy Tribunal Act.
The-
16E. I have only one subject to alert.
Yes.
So applicability of the code of civil procedure. And the judgment of the Honorable Apex Court is this. Maybe did it.
Give him Mr. Sheta copy.
Yes, yes. Next page at the top, my lord. However, the dismissal of the appeal on merits which is contrary to the aforesaid provisions, explanation thereto, under that sort ground alone the appeal is. But it's for your lordship, that is a
Yes, Mr. Shet, we are doing it. We are setting it aside, remanding it on merits upon giving them opportunity. The scope of the present challenge is limited. First up, the learned tribunal, the learned West Bengal Land Reforms and Tenancy Tribunal, second bench, dismissed on merit an original application filed by the present petitioner. First up, next para, learned counsel for the petitioner submits that the principles of Order 41, Rule 17 of the Code of Civil Procedure are applicable by dint of Section 16 within bracket small e of the West Bengal Land Reforms and Tenancy Tribunal Act, 1997 to an original application before the tribunal. First up, next para, heard learned counsel for the parties. First up, Section 16 within bracket small e of the 1997 Act categorically provides that the tribunal shall, for the purposes of the said Act, have the same powers as are vested in a civil court under the Code of Civil Procedure, 1908, while trying a suit, in respect of dismissing an application or proceeding for default or deciding it ex parte. First up, next para, learned counsel for the petitioner relies on an unreported judgment of the
so
Honorable.
it was reported, my lord.
Oh, acha.
At the top here.
Relies on the judgment of Benny D'Souza and others versus such and such, reported at 2024 within bracket 1 ICC 631,
Yes, sir.
where it was reiterated by the Honorable Supreme Court by placing reliance on Order 41, Rule 17 of the Code of Civil Procedure that an appeal cannot be dismissed on merits for the absence of the appellant. First up, next para, since a challenge before the tribunal has ingredients of an appeal, and even otherwise, it is well settled that even a writ petition cannot be dismissed on merits merely for the absence of the writ petitioner, we are of the categorical opinion that the learned tribunal acted without jurisdiction in dismissing on merits the original application of the petitioner uh, due to the absence of the petitioner. Full stop, next para. Accordingly, the impugned order suffers from jurisdictional error. Full stop. Hence, WPLRT 36 of 2025 is allowed on contest, thereby setting aside the impugned order dated January 10, 2025, passed by the second bench, West Bengal Land Reforms and Tenancy Tribunal in OA 1701/2022 within bracket MA 393/2023 bracket closed, about within bracket LRTT bracket closed, and remanding the matter to the learned tribunal for a fresh hearing on merits upon giving opportunity of hearing to both parties. Full stop. It is expected that the learned tribunal shall dispose of the matter as early as the roster of the tribunal permits. No address to cost.
Well, without entering into the merit of the case, my lord, if you
Is there any connected application here also?
no, my lord.
We make it needless to say, we make it clear that we have not entered into the merits of the matter, and it will be open to the learned tribunal to independently dispose of the case without being influenced in any manner on merits by any of the observations above.
Grateful, your lord.
Next.
Grateful, your lordship.
বইটা ফেরত। পাসওয়ার্ডটা দেখুন, বইটা ফেরত।
জাজমেন্টটা কি লাগবে?
Pass over item number 6.
The matter had been adjourned on the first call on the prayer of the petitioner, appellant. Full stop. On the second call, none appears on behalf of the appellant. Full stop. Accordingly, the matter is dismissed for default. Next. Sorry, you are late.
I was just saying outside, madam.
Yes, move the matter. Order taken. What is the matter?
My lord, the plaintiff respondent, my lord, filed a suit for declaration and permanent injunction.
There is no caveat.
No, my lord, there was
Yes.
no public.
Respondent filed a suit for declaration and injunction.
An injunction, my lord.
Yes.
My lord, on the date of moving the injunction application, my lord, my lord, the defendant number 1, who is the appellant herein, my lord, he appeared.
Declaration of what nature? Title?
No, my lord, that she is a tenant under me. In respect of, I am the lessee of one Chandni Bar. She.
Chandni Bar?
Yes.
Acha. You have derived from the movie, or?
No, it's near.
Oh, it's actually there. It must be there. Yes. Anyway, we are not interested in that.
Yes, my lord. Now, my lord, I am the lessee.
Yes.
Now, the plaintiff or respondent herein, my lord, she was one of the performers there who.
Your learned junior, instead of preparing himself, you asked him to prepare himself. Instead of doing that, he was running after you.
Not in this matter, my lord, actually. The advocate on record is not present to us.
He's your chamber junior?
No, my lord. I just requested him, my lord.
Forgiven. Yes, please continue from there.
So.
Claims to be a tenant under you. You were a lessee.
Yes.
He is a subtenant, admittedly.
Admittedly, she was running it's called the bandmaster. She was the bandmaster at that bar.
Acha.
Now, my lord, she preferred this suit.
Bandmaster as in musical performance.
Musical performances as well as my lord, dance performers.
Whatever. I mean, she's an employee. Does not claim to be an employee.
No. She.
Very well.
She has an agreement with me. She brings her troupe to perform there.
But she's claiming to be a tenant.
She's claiming to be a tenant because there is a one good, bad, indifferent, one rent agreement. So, I appeared. I prayed for time to file written objection.
To the injunction.
To that injunction. That prayer was allowed. Thereafter, they filed on the very same day. They filed one Water 6 Rule 17 application, my lord, for amendment of the plaint because the agreement date was wrong. That application was also allowed. Injunction granted, status quo granted, though time was given to me to file written objection.
Ad interim injunction must have been.
Yes, ad interim injunction given, my lord. Now the difficulty is that, my lord,
she is disposed before this.
I have documents to show, my lord.
But if she is disposed before the injunction application is even heard, you have got your time to get a written objection, file your written objection, and have the injunction application contested.
Kindly direct me to serve her, and your lordship kindly hear out this application, my lord.
No, the trial court will do that. Here only ad interim injunction has been granted. As in status quo has been granted.
Yes.
We won't interfere with that. Why should we interfere with that? Let there be status quo. If she is disposed in the meantime.
My lord, it is, my lord, the agreement was expired. New tenant is there. 2 subsequent tenants were there. I have agreements to show.
to that extent, my lord. She was only there for 3 months. Thereafter, she left there. And on the basis of that agreement, she has obtained the injunction order.
Trial court has held ad interim at the ad interim stage. Prima facie, there is that she is in possession, that is admitted.
Well, it is not admitted, my lord, because the opportunity was not given to produce those documents that she is not there anymore.
We won't interfere at the ad interim stage. You file a written
Well,
objection.
let me just serve in her presence, my lord. I will move this application.
Do that in the trial court. At the ad interim stage, there should be least interference.
Well, it is completely, my lord.
You say she's not even in possession.
Yes.
Have you annexed anything here?
Yes, my lord.
Show us.
My lord, kindly come to page 119, my lord.
Yes.
This is the leave and license agreement for 33 months, which I have executed on 5th of June 2025 to Sri Asif Iqbal, who is now presently running that, my lord, performing as bandmaster. This is the agreement, my lord. And he's already.
This is 5th June agreement.
5th June agreement.
Her agreement with you was on?
On 29th, my lord, just give me a moment, my lord. It is 25th September 2024.
You have to prove it's your onus to show that the previous tenancy was terminated. This is a paper only.
Yes.
Burden is on you to show that the previous tenancy was terminated before you could enter into another agreement. Today you are my tenant, right?
Yes,
you are there as a tenant. I enter into an agreement with your friend. That does not automatically mean that your tenancy is terminated or you are dispossessed. This per se does not prove that the previous, because the burden as per the Evidence Act is on the person who is asserting that it has terminated to show.
But she has also not shown a single scrap of the document except the document of, my lord, that agreement.
Sufficient.
That she was in
Sufficient.
And I can show your lordship that in February 2025,
You do not dispute the existence of the document. You say subsequently there has been this document.
There are two documents. On 10th February 2025, I have given somebody. She has also failed to run the, my lord, the.
Prima facie case, it's arguable. At the ad interim stage, this is arguable. We find there is an arguable case.
Give me an opportunity. Within a week, I will serve because there is only one plaintiff, my lord.
Do it there, not here.
My lord, kindly, my lord.
No, we won't convert ourselves into the suit court. Sorry. The present challenge is at the behest of a defendant in a suit.
One more thing, my lord, if you
Yes, yes.
My lord, I have annexed the documents that I am in possession. She only has the right to use that floor. My lord, kindly.
No, that will be decided in the suit whether it's a license for a particular purpose. That you may have a very good case because that was playing in our mind also.
I have Calcutta Corporation.
Have you annexed that the document relied on by them? Shows that.
Yes.
Shows
I
that.
have annexed that. That is at page A78, my lord.
Yes, is rent. Use the premises for restaurant and bar.
And my lord, kindly see point number 4, my lord, page 79.
Commencing from such and such period of 11 months.
27 September 2024.
Yes, but then you have to evict by due process of law. This is not.
My lord, she left the position. That's why, my lord, I have executed the other agreements and those persons are in position.
Ad interim, if ad interim was not granted, might be we won't interfere. If it was not granted, because as per this, the time has expired. But since here it has been granted, that's discretionary on the part of the court. It has been judicially exercised. We won't interfere in appeal. At the ad interim stage, less so. No, sorry. The present challenge has been preferred against the grant of an ad interim order of status quo in favor of the plaintiff stroke respondent number 1. Full stop. The plaintiff stroke respondent number 1, comma, claiming to be a tenant in respect of the suit property, comma, from where a restaurant cum bar is run, comma, claimed that a tenancy agreement was granted to her by the defendant stroke appellant. Full stop. Next para. In the said suit, apart from claiming declaration regarding her tenancy right, comma, the respondent number 1 also asked for permanent injunction protecting her possession. Full stop. In the suit, comma, an injunction application has also been filed for temporary and ad interim injunction to that effect. Next para, learned counsel for the defendant appellant argues that the defendant appellant was granted liberty by the learned trial judge to file a written objection to the injunction application, but, in the same breath, ad interim status quo was granted, despite the fact that the appellant is in possession of documents to show that the plaintiff stroke respondent number 1 has since been dispossessed, and that the license given to the plaintiff was for a limited purpose of conducting a musical band in the said premises. Next para. Upon a perusal of the documents annexed to the injunction application in connection with the present appeal, we find that an agreement for lease was entered into, a rent agreement was entered into between the present appellant and the plaintiff stroke respondent number 1 on September 25, 2024 for a period of 11 months. From a prima facie perusal of the said document, it transpires that the same created not a mere license of user, but a right to possess the property, albeit the tenure of such agreement having been expired in the meantime. In spite of the same, it is well settled that within the ambit of the law of evidence in India, a person asserting that a jural relationship of licensor licensee and stroke or tenant landlord tenant is to prove that such jural relationship has terminated and or the tenant stroke licensee has been dispossessed from the suit premises. Although the defendant stroke appellant seeks to place reliance on another subsequent leave and license agreement with a third party, per se, the said document does not prove that the erstwhile tenant, that is the plaintiff stroke respondent number 1, has been dispossessed. As such, since the learned trial judge adopted one of the plausible views while sifting SIF TING the evidence before it, by granting status quo at the ad interim stage in favor of the plaintiff respondent number 1, we are loath to interfere with such exercise of judicial discretion, particularly at the ad interim stage. Accordingly, FMA 1399 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Next para. However, we make it clear that we have not entered into the merits of the matter, and it will be open to the learned trial judge to decide independently the injunction application as well as the suit without being influenced on merits in any manner by any of the observations made above. Next para. In the event the defendant appellant files his written objection to the temporary injunction application in the trial court within a fortnight from date, it is expected that the learned trial judge shall decide the injunction application itself within 4 weeks thereafter. No address to cause urgent certificate copies. Arakta line add kodi, can 1 of 2025 is also disposed of about.
Only one thing, defendant number 1 appellant, not defendant appellant.
যেখানে defendant বলেছি সেখানে defendant number. Thank you.
Item number 10.
I have a feeling for the appellant. I could not appear. I'm tendering.
No, it's so difficult.
This is an appeal.
Mr. Galib was there, yes.
Yes. This is an appeal.
Yes.
By the person whose predecessor was the owner of the property, rendering about 4 days. And his predecessor he got the property.
Take the microphone, please. Yes.
He got the property from his predecessor, from his father. Subsequently, there was a arrangement from the other co-owners. The property has been conveyed in favor of the predecessor of this present appellant. And all along, his name was appearing before the record of the BL and LR.
The other co-owners of your predecessor transferred their shares to your predecessor.
Yes, that P1, that the title deed is there. But
all along he is enjoying the property.
Yes.
He was ailing for a considerable period, and he made and published a will during his lifetime.
Private respondent. Private respondent.
Private respondent service হয়েছে?
There are two private respondents, sir.
হয়েছে? কোথায় affidavit of service হয়েছে? May I file this?
They have been served. Private respondent.
Track report থেকে? কোথায়?
Just check up the track report.
Yes. দেখো May I play the?
Yes, check up. No, unnecessary.
Yes, sorry.
Just check up for the
private respondent number কত?
7 and 8.
7 and 8. 7 and 8. নামগুলো দেখো ওই রিসিটে। চিঠিটা কোথায়? চিঠি কোথায়? নাম্বারটা
come back tomorrow. We'll take
Yes,
the
madam. Then I will not waste my
just not today for
No, no. দেখি না উপরে দেখি কোনটা?
served.
Yes.
13.
Acha, we are passing it over.
Yes.
You check up.
Yes.
Pass over thak. Ported. দুটো তিনটে ম্যাটার পরে আবার ডাকবো।
Item number 11 with 12.
11 and 12, my lord, I beg to represent the petitioner.
I am for the respondent and the original applicants.
Right.
Now, my lord, before my learned senior friend start,
Yes.
I must tell the court that one of the respondent, the original died.
Fund is the
Respondent number
details.
14,
Fund is the details.
my lord.
Learned counsel for the for the respondents submits that which respondent has died?
14, 1-4.
That respondent number 14 has died in the meantime. Full stop, next para. The learned advocate on record for the respondents shall furnish the date of death and the particulars of the heirs and legal representatives of the deceased respondent to the learned advocate for the appellant petitioners in writing by tomorrow. Full stop, next para. Appropriate steps, leave is given to the petitioners to take appropriate steps for substitution of such heirs. Full stop. Let the matter go out of the list for the present with liberty to the parties to mention for inclusion as and when such substitution is application is filed.
Next one is
You
also
mention
same.
the substitution application, we'll list it along with this and
Next
dispose of
one is
process.
also same.
Next one also
11,
same.
12.
Can it be next week
I'll
instead
check.
of go out of list? It's like we are facing contempt.
আচ্ছা, very well. তাহলে go out of the list না করে let the matter stand adjourned till November 10, 2025.
Mine.
2025.
Fine. Grateful to it.
And rest service are complete.
Affidavit of service filed today be kept on.
Number 13.
Well, I have checked up.
You have checked up? No, after 13 we'll call
Yes.
you. 13 who is appearing?
Yes, my lord, I am appearing for the petitioner, my lord.
Yes, Mr. Mondal.
My lord, the petitioner, my lord, the appeal, original application was admitted in the year 2019.
Early hearing.
Yes, my early hearing. My lord, the facts, my lord, on the last occasion, my lord, the learned tribunal directed the government representative to file opposition. There is no factual dispute. Since 2018, they never prayed for. On the last occasion, they did not pray. Only my lord, for opposition. There is no necessity. Kindly see the question on which ground the prayer for the prayer for correction of the record of rights was rejected, my lord. My lord, one in nutshell, I am stating the facts, my lord. One Gurupada Pal was the Uttar Simana Dakoldar, was it in the dispute plot, and in the CSR ward, in the RS record of rights, my lord.
No, we are not going to the facts, Mr. Galib. Repeated opportunities were given to you.
Both are my lord guilty of this non-appearance.
No, my lord,
No.
offense.
Affidavits.
And LCR already arrived.
Time of hearing, my lord. Hearing was not taken up.
We'll give you a fortnight's time, Mr. Galib, to file your opposition there, objection there.
Written
Before the tribunal.
affidavit in opposition.
Affidavit in opposition before the tribunal. You'll get 1 week time to file your reply. We'll direct it to be disposed of by December.
Yes, my lord.
Since ACR has also arrived.
before the tribunal.
Yes, I find, my lord.
Then it's all right, yes.
Kindly.
The innocuous prayer made in the present application is for expeditious disposal of an original application which is pending before the tribunal since 2018. Full stop, next para. Learned counsel for the petitioner submits that repeated adjournments were given to the government pleader to file written affidavit in opposition to the original application, whereas learned senior government advocate submits that both parties had taken adjournments before the tribunal. Full stop. It is also submitted on behalf of the state that the records are already before the tribunal and the matter can be disposed of expeditiously. Full stop. Accordingly, WPLRT 162 of 2025 is disposed of by directing the respondents to file their affidavit in opposition to the original application bearing OA number 3158 of 28, OA 3158 stroke 2018 of LRTT within a fortnight from date before the tribunal. Full stop. Reply, if any, shall be filed within a week thereafter. Full stop. The learned tribunal shall dispose of the original application as expeditiously as possible by shifting back the date, the next date fixed, and positively dispose of the same in accordance with law by the end of December 2025. No arrest to cause charges certificate.
Lordship.
Ever pass over.
Pass over item number 10.
The service has been affected.
Has been affected?
In response.
Yes. Move your matter. What is?
Private respondent is-
What is the matter?
Now, this is an application, or two applications were filed before the, first of all, before the BLRO and before the LRTT, whereby my prayer has been rejected.
What prayer?
On the prayer for deletion of the name of the private respondent, in the record of rights. And
No, you say your predecessor's name was appearing all along.
Yes, that-
When did the private
See,
when did the private respondent's name come in?
private respondent name is coming in the LR record.
Achha.
And at a situation when my predecessor's name was there, he made a will in favor of me and my two sons. During pendency, after his death, and during the pendency of the probate proceeding, and after getting the probate, when I went there for mutating my name in the record of rights, I find his name is appearing in the record of rights.
But
And in that juncture, good, bad, indifferent, civil suits were filed. And thereafter, these proceedings has been initiated before the BLRO as well as before the appellate authority. And both the authorities rejected my prayer on the ground of res judicata. And my contention before your lordship is this: it is absolutely fraud. Because of
what is their stand, the private respondents? How do they claim right?
They claim right, my lord. There is a Orpon Nama executed by their her mother in favor of him. The entire property. He is adjacent owner of the property. This property is and the property of the private respondent are adjacent. They are claiming they have a Orpon Nama executed by his mother in favor of her. And
Whose mother?
The private respondent mother.
How are they related to you?
No, nothing. But we are the adjacent owner.
Your predecessor had a title deed in his name.
My predecessor, yes. My lord will kindly come. Not only that, he has the record of rights in RS as well as I do not have the CS record.
Let us see the impugned order. What has been held?
Only res judicata. Since the civil suit is pending, court will forum will not interfere. And
Civil suit is pending.
Yes, two civil suits.
Your suit or their suit?
My suit, one suit has been filed by myself for declaration, and his suit is also.
No, 15th March 2024 is the impugned order.
No, order is on
1st August.
2020.
Kindly comes to page 99, lordship. That is the impugned order.
Another thing is this,
1st August 2025.
last
ওটা সার্টিফাইড কপি করেছো এটা
99.
So the
Facts has been narrated in the first page, my lord, during LR operation.
the DLLRO held, the appellate authority held that the block land reforms and land reforms officer shall what was held by the
Kindly comes to page 98.
Nine-
DLR's order.
yes.
95 it starts from.
That impugned is
Kept in abeyance till the civil
because of
suit.
pendency.
What is wrong?
yes.
Uh,
That
right
is the
issue.
crux.
But
That is the
only
crux.
thing is that my contention before your lordship, since it's a fraud, no notice of service has been.
LLRO cannot decide these points. It's subject matter of a civil suit, rightly done.
That is the crux. That is the crux.
If there is lordship is aware of this.
We are also aware that if it's sub judice before civil court, and even if it was not no.
Res judicata will not operate when there is a.
Res judicata, what is the question of res judicata? Who says does not say res judicata?
Am I tantamount to that, my lord?
Not at all. Res judicata is a completely different concept. Res judicata is there is a conclusive finding by a court and another court is bound. It is not said that it's res judicata. Kept in abeyance until disposal of the aforesaid.
Kindly see
This is a perfect thing to do for
PLLR
the
also said the same tone. Kindly see 97.
same thing.
PLLR's
Regard to, my lord,
ordering portion.
I have not been given notice. Even.
Now, PLLR disallowed the application. That was wrong.
That should not be. But
Appellate
PLLR
authority
is
not
correct.
prescribed.
In abeyance. In abeyance.
No.
If there is a forum,
Learned counsel for the petitioner submits that the learned tribunal acted without jurisdiction in dismissing the appeal of the petitioner against an order whereby the appellate authority under section 54 of the West Bengal Land Reforms Act 1955 kept in abeyance an appeal preferred by the petitioner against an order whereby the block land and land reforms officer within bracket BL and LRO dismissed the petitioner's application for correction of records of rights. For next para, the petitioners claimed that the petitioners became the owner of the property in dispute by virtue of a will executed by their predecessor in interest. The said predecessor in interest, comma, according to the petitioners, comma, came in possession, in exclusive possession of the property and became the owner of the property upon his co-owners having transferred their shares in favor of the said predecessor in interest. Next para, the BL and LRO, comma, while deciding the matter, comma, disallowed the application for correction of records of right in view of the land in question being sub judice in two civil suits pending between the private respondents and the present petitioners. Next para, the appellate authority, that is the DL and LRO, comma, Nodia, comma, while hearing the appeal against the said dismissal, comma, observed by an order. What is the date? We can't read this date.
That is the last
4th of December.
Lordship.
Or 14th of December.
Lordship. Page 98.
Page 98, what is the date?
98. Date is
14th or 12th?
17/8/2020.
14/12.
Yes. By an order dated December 14, 2022, comma, kept the appeal in abeyance until disposal of the pending title suits. Pending title suits, comma, bearing number 85 of 2021, comma, 88 of 2022 and 50 of 2022. Next para, the tribunal dismissed the challenge against the same by observing that the appellate authority was justified in so keeping the appeal in abeyance. Next para, upon hearing learned counsel for the appearing parties, comma, we find that the appellate authority was justified in keeping the appeal in abeyance till pendency of the suit. The petitioners, comma, in the proceeding before the BL and LRO, comma, had raised disputed questions of title and urged fraud, comma, which questions can only be decided by a competent civil court upon taking detailed evidence and cannot be decided by the BL and LRO. Next para, As such, comma, the appellate authority was did not have any other option but to wait for the disposal of the civil suits which are already pending before this competent civil court before deciding the appeal, either way. Full stop. Next para. Hence, comma, we do not find any reason to interfere with the impugned order of the tribunal, whereby the order of the appellate authority was sustained. Full stop. Accordingly, WPLRT 158 of 2025 is dismissed on contest without any order as to costs. Full stop. We make it clear that we have not entered into the respective contentions of the petitioners and the private respondents, and it will be open to both parties to urge all points involved before the competent civil courts. Full stop. After the disposal of the suits, comma, subject to the outcome thereof, comma, the petitioners will be at liberty to revive the matter before the appellate authority, that is the DL and LRO, Nodia. No orders to cost. Thank you. Next.
Lordship, at one place, Lordship used the word appellate authority kept in till pendency, not till disposal. At one point, till your Lordship used the word till pendency. It is till disposal.
Of
At
what?
one point in the dictation, Lordship has used at one point.
Same thing. During pendency?
No, till pendency, Lordship used. Till disposal.
না না ওখানটা না আরো আগে বলেছি কোথাও
একটু আগে
till pendency
till pendency
till disposal pendency to disposal. Thank you.
Lordship.
Item number 40.
For the respondent.
Yes, Mr. Jana, what is the matter?
My lord, my lord, at the outset, my lord, the affidavits in opposition were affirmed.
Were affirmed previously. Copies were given to him. Why?
It was not done, my lord. And I'll tell you, my lord, this was affirmed in 2018.
On?
2018.
Should have given copies to him.
My lord, barred by limitation. My lord,
There is no limitation in filing opposition.
my lord, and this affidavit barred by limitation aid of the application. My lord, kindly listen.
What is your contention? Why are you opposing the substitution?
I'm not opposing. I'm not opposing. Kindly seize my affidavit. My lord, the application preferred by him is bereft of particulars. The particulars have been provided.
So you have furnished the particulars. Give a copy to him.
I had served the copy of my lordship by speed post.
Please go through this, Mr. Jana.
Yes, my lordship.
You did not give the particulars of the heirs. They have given the particulars. They are helping you out. Please come to page 6 of this. Do you agree that these are the heirs? Please go through this.
I can't find any reply, my lord.
You don't agree that these are the heirs. If these are the heirs, then don't file a reply and waste time. Please wait. Don't waste time, Mr. Jana. If you feel that these are actually the heirs, there are no other heirs, then there is no need of filing any reply. We'll allow you a substitution upon directing these persons to be added. Mr. Jana, you are looking at something. We are speaking to you. Please come to page 6 of the opposition.
I have filed my evidence of service. I have also filed the evidence of service, my lordship.
What?
Application for substitution only for my lordship.
Page 6 টা দেখুন।
In your petition, you have said
Page 6.
Page 6 টা দেখুন।
পেজই নাম
দিয়েছি। নামগুলো ঠিক কিনা just
পেজ নাম নেই তো কোনো পেজেরই নাম দেয় পেজের নাম্বারই দেয়নি
where will permit you to file reply.
দেখুন স্যার পেজের নাম্বারই দেয় মে আই ইন্ডিকেট মূলত পেজের নাম্বার কোথায়
এই তো এই যে এইটা দেখুন এই প্যারাগ্রাফ 8 দেখুন
Paragraph number 9.
No, he is relying on a will.
Yes. It's a suit for probate. Probate granted, my lord.
এই যে এইটা দেখুন
The appeal, the executor dies. A previous order, my lord. Yes, my lord, correct. The previous order, my lord, takes up 24th of June 2009. There was a direction, my lord, since the executor had died to substitute legatees. Now he says legatees are Jyotirmoy and Jagadish. Now they have also expired, so their heirs should be brought on record. So that's what I provided.
Mr. Jana, if you are not competent to deal with yourself, we can provide you legal aid advocate. But you have to, you cannot waste time like this. Right? So you have named two legatees. Those legatees have also died. These are their heirs.
Yes, my lord.
So you agree that page 6 contains the right names? We should direct these people
My
to be.
lord, kindly see this can number 8799 of can 6 paragraph 6 kindly see this, my lord. Substitution application is paragraph 6, page number 8.
Yes, paragraph 6, yes.
Yes, my lord. That on 11/8/2016, the applicant by petitioner have to come to knowledge at first evidence.
Yes, you have said he has left behind Jagadish Sahu and Jyotirma Sahu.
Yes, my lord.
And their sons, respond numbers 2, 3, and 4.
Yes, my lord. See.
Now, Jagadish and Jyotirmoyi have also died in the meantime. That is,
Yes, my lord.
so who are their heirs? Have you named them in your application?
Yes, named them, but there's no address.
Yes, my lord.
Where have you named them?
Param 8 is that the Jagadish Sahu died in test January 24, having behind his window, namely the Dipali. Then he Sahu.
What are their particulars? Where are their particulars? Their addresses, everything?
Yes, my lord. List of dates kindly.
In the application, where are their particulars in your application? Their addresses.
Yes, I have served this affidavit of service, my lord.
That affidavit of service.
আমি এই ডেটই তো পাঠিয়ে দিয়েছে এই ডেটই।
আরে আপনার অ্যাপ্লিকেশনে আসুন আপনি মশাই। আপনি বাংলায় ফিরে আসুন, আপনাকে ইংরেজিতে বলতে হবে না। আপনি আপনার অ্যাপ্লিকেশনে কোথায় অ্যাড্রেস দিয়েছেন? Here there.
আমি স্যার এইভাবে সার্ভিসের সমস্ত ডেট দিয়ে দিয়েছি।
এফিডেভিট অফ সার্ভিসে কি করে ডেট দেবেন? এফিডেভিট অফ সার্ভিস মানে আপনি সার্ভিস করেছেন, তার ট্র্যাক রিপোর্টটা অ্যানেক্স করেছেন।
ওই ডেটটাও দিয়েছি মাই লর্ড।
এফিডেভিট অফ সার্ভিসে কোনো ডেটের কোনো ব্যাপারই নেই। আপনার সাবস্টিটিউশন অ্যাপ্লিকেশন শুনুন মশাই শুনুন, আপনারা না এই যে সময়টা নষ্ট করেন কোর্টের, আপনারা নিজেরা মামলা তো করতে পারেন না, নষ্ট করেন সময় কোর্টে, তারপর গিয়ে বাইরে বলেন, ইউটিউবে গিয়ে বলবেন যে কোর্ট সময় নষ্ট করে, সময় নষ্ট হয়। আপনারা এই যে সময়টা মহামূল্যবান নষ্ট করছেন, অন্য লোকেরা তো সাফার করছে। আপনি আমার কথাটা শুনছেনই না তো, আপনি বলে যাচ্ছেন এফিডেভিট অফ সার্ভিস। এফিডেভিট অফ সার্ভিস মানে কি মাইকে বলুন তো একবার, মাইকটা নিন।
কম্পিউটার সার্ভিস করেছি স্যার প্রুফ।
তাতে কি করে আমরা জিজ্ঞেস করছি যে এয়ারদের কথা বলেছেন সাবস্টিটিউশন অ্যাপ্লিকেশনে, তাদের অ্যাড্রেসটা কোথায় দিয়েছেন প্যারাগ্রাফ 8-এ?
এই অ্যাড্রেসগুলো ঠিক কিনা জজ?
এই অ্যাড্রেসগুলো ওনারা ওনাদের অপোজিশনে দিয়ে দিয়েছেন, তা আপনাকে সাহায্যই করেছেন, তো সেই অ্যাড্রেসগুলো ধরে তারা আমরা অ্যালাউ করে দিই আপনার অ্যাপ্লিকেশনটা?
ইয়েস মাই লর্ড, অ্যাড্রেসগুলো কারেক্ট।
তাহলে আমরা অ্যালাউ করছি আপনার অ্যাপ্লিকেশন এই এফিডেভিটের ভিত্তিতে।
ইয়েস মাই লর্ড।
ইন পারসন করাও চাই, মামলাটা বুঝতেও পারবে না, সময়টা নষ্ট। লিগ্যাল এড অ্যাডভোকেট দিতে চাইছে সেটাও নেবেন। An affidavit in opposition filed today be kept on record. Full stop. In fact, comma, the purported affidavit in opposition is in effect in aid of the substitution application filed by the appellant, comma, since the appellant omitted to give the particulars of the heirs and legal representatives of the two deceased legatees, namely Jyotirmoyi and Jagadish. Full stop. Next para. Upon hearing learned counsel for the respondents as well as the petitioner appearing in person with leave of court, comma, we find that the application is substantially informed, comma, read in conjunction with the affidavit in opposition thereto. Full stop. Accordingly, can 8799 of 2016, what is the current number?
Current would be can.
Yes, within bracket, at present, can 6 of 2016, না এটা উল্টো করে দিয়ে দিন, can 6 of 2016 within bracket old number can 8799 of 2016 is allowed, thereby directing the heirs and legal representatives of the respondent number 1 as mentioned in paragraph number 8 of the affidavit in opposition and paragraph 9 of the affidavit in opposition to the said application as respondents in the appeal. Full stop. The office shall carry out the necessary corrections to the cause title of the memorandum of appeal at the earliest in terms of the above order. Any other application is pending? আপনার আর কোন অ্যাপ্লিকেশন পেন্ডিং? এইটাই। তাহলে এইটা হয়ে গেলে তাহলে আপনার কি পেপার বুক প্রিপেয়ার্ড হয়েছে? আমি আপনাকে তাহলে ডিরেকশন দিই আমরা যে আপনি স্পেশাল মেসেঞ্জার কজ দিন, ট্রায়াল কোর্ট রেকর্ড। নেক্সট প্যারা।
Call for LCR, my lord.
LCR, हाँ. The trial court records be called for by special messenger at the cost of the appellant, comma, which shall be deposited এক সপ্তাহের মধ্যে কষ্টটা দিয়ে দেবেন, which shall be deposited within a week from date. Full stop. Next para. The upon arrival of the records and the same being examined and found to be complete, comma, notice of appeal shall be served directly on the appellant Sri Nirmal Kumar Jana as well as the learned advocate for the respondents. Full stop. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is made ready for hearing. Full stop. The appellants shall also put in postal costs and due requisites for service of notice of appeal on the substituted respondents within a week from date. Special messenger cost আর পোস্টাল কস্ট আর রিকুইজিটস গুলো জমা দেবেন যাতে সাবস্টিটিউটেড রেসপন্ডেন্টের উপর সার্ভিস, আর সমস্ত ডিরেকশন দেওয়া রইলো, আপনি নোটিস পেলে পেপার বুক তৈরি করবেন। থ্যাংক ইউ। নেক্সট
Item number 15 with 16.
Item number 15 and 16, I am for the respondent number 1. Now, my lord, this matter was taken up yesterday with your lordship. My lord, your lordship asked me to, my lord, intimate the appellants.
Yes.
My lord, I have a talk with the learned advocate on record. My lord, he said, in spite of several intimation to the client that the matter is pending adjudication, his client is not contacting with him. So at present, he has no my lord, interest over the matter.
We just dismiss for default. This is the second occasion should we record these conversations?
Yes, yes, your lordship can.
This is the second occasion when none appears for the appellants at the time of call, although the respondents are represented through their learned advocate. Mr. Rai, your name cannot be recorded without your junior. On the last occasion,
My lord,
last occasion it was done.
Oh.
Anyway, full stop. Next para. Learned senior counsel appearing for the appellants submits that as per the request of the court, attempts were made to intimate the learned advocate appearing for the learned senior counsel appearing for the respondents. Intimation was sought to be effected on the learned advocate appearing for the appellants. However, comma, the said learned advocate indicated that despite repeated reminders, his clients are not contacting him, and as such, he is not inclined to appear in the matter. Full stop. Next para. As such, comma, it is evident that the appellants are not interested to move the appeals or the connected applications. Full stop. Accordingly, FA 139 of 2009 along with can jaja cost title ache, as well as FA 379 of 2009 along with can such and such are dismissed for default without any order as to costs. Full stop. Interim order, if any, stands vacated.
The lower court record,
the trial court records have come.
And I think it has come because it's an old appeal.
The event the trial court records have arrived before this court, comma, the same be sent down immediately to the trial court.
Item number 17.
Your Lordship, in this matter, I am appearing on behalf of the appellant.
What is the matter?
There are two applications, CAN 4 and CAN 5. CAN 4, I have filed an application for recalling the order dated 13/4/22 passed in FA number 236 of 2010, whereby the appeal stood dismissed. And CAN 5 is an application for withdrawal of money which has been deposited in terms of order.
Then first the restoration has to be heard. But ma'am, you have to serve a copy on the other side because the respondent was present on the last occasion when it was dismissed for you. Serve a copy of the applications on the appellant. Sorry, on the respondent. The appellant stroke petitioner shall serve copies of CAN 4 of 2024 and CAN 5 of 2024 on the learned advocate appearing for the respondent and file.
Only one. It
Yes.
has already been served, but affidavit of service has not been.
No, advocate is you have served on the advocate.
No, advocate is not
No, Ranjit
receiving
Kumar
the copy, so I have served upon the respondent.
you file an affidavit of service then.
I will file
এটা
it.
এটা 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 এটাকে ফেরত দিয়ে ওনাকে ফেরত দিয়ে দিন।
Lordship, only is withdrawal of sum of rupees 50,000, which was
What
deposited.
only? They have a right to oppose.
No, actually,
Restoration application is first there.
Lordship, only one indulgence. The subject matter was challenging the eviction decree.
And this the one which you showed merely shows the postal receipt, not the acknowledgement card or track report.
But this is
No, we are directing to serve.
okay. Yes, Your Lordship. Then
যেখানে ছাড়লাম ওখানে
listed on Monday.
can 4 of 2024 বললাম তুমি নাও ওটা ও নিচ্ছিল The appellant petitioner shall serve copies of can 4 of 2024 and can 5 of 2024 on the learned advocate appearing for the respondent, indicating that the applications shall be listed next on November 4, 2025, when a receipt in that regard shall be filed by the petitioner.
Grateful to Your Lordship.
Serve a notice because we have directed, now they will accept.
Yes.
Just file the receipt on the next date and we'll take up the matter 4th of November.
Great.
We're not putting it on 3rd because that will be the combined list.
No issue.
Yes.
Grateful to Your Lordship. Bow down to Your Lordship.
Item number 18.
I'm for the respondent number.
Both are for respondents.
My lord.
Kaustuv Banerjee and Riya
Kaustav, my
Kundu.
lord. Kaustav.
You are Kaustav, sir.
My lord, I'm for respondent number 2, my lord. Earlier question, the appellant didn't appear, my lord.
No, they are not appearing consistent. We find from the order sheet that on August 26, 2025, none had appeared for the parties. Full stop. On October 27, 2025, as well, comma, none appeared for the appellant, although the respondent number 2 and 4 were represented by their respective counsel. Full stop. Even today, comma, at the time of call, comma, the said respondents are represented, whereas the appellant remains unrepresented. Full stop. Accordingly, FAT 333 of 2014 and can 3 of 2025 are dismissed for default without any orders to cost. Interim order, if any, stands vacated. Mr. Mahato is there.
Yes, I'm.
We'll come back in.
Item number 19 with 20.
আপনার আজকে লিস্ট যতটা পারি খালি করে দেবো এগুলো নিয়ে সব ডিসমিস করে দেবো। This is the second occasion when none appears for the parties at the time of call. Accordingly, FAT 487 of 2014 with CAN 5 of 2025 and FA 9 of 2015 with CAN 4 of 2023 are dismissed for default without any order as to cost. Interim order, if any, stands vacated.
Item number 21.
I for the respondent, my lord. 21, Mr. Mustafi Rahman is appearing for the appeal and
Is there?
Mustafi Rahman. He is on legs before.
No, start the matter. No time, sorry.
My lord, kindly.
Yesterday,
the
my
matter.
lord. Yesterday, my lord, the matter has taken up by
Yes,
my
yes,
lord.
yes.
No one appeared for the my lord applicant.
We are granting time, no. No
Kindly
further
grant
time.
a short passover, my
No
lord.
passover. We are dismissing for then.
My lord, kindly see.
Either remove the matter or do we dismiss it?
My lord, I'm not.
What is the matter about?
My lord, the partition suit, my lord, the order passed, my lord, the decree passed, my lord, in preliminary form, my lord, challenging that, my lord, the defendant prefer the, my lord, appeal, first appeal, my lord.
What are CAN 3 and 4? 3 is for stay.
My lord, 3 for stay, my lord, can 3 stay.
And 4?
My lord, no copy has yet been served, my lord. My lord, kindly see the order, my lord, 28th July, my lord, kindly see the order, 28th July, my lord. Paragraph 4, my lord.
Yes.
They have stated, my lord, some
have
of the
died in the-
respondents have died, my lord. Paragraph 4, my lord.
Hmm.
They have stated, my lord, some of the respondents, my lord, died, but no steps have as yet
What
taken.
steps have you taken?
No copy has yet been served, my lord.
We are passing it for 10 minutes.
My lord.
If you don't come, we'll dismiss the matter for default.
My lord, deeply
Lock, stock, barrel, everything.
Item number 22.
My lord, 22, my lord, I am for the respondent, my lord.
But I am for the appeal.
Yes.
My lord, my application, CAN 2 of 25, my application, my lord.
Yes.
Now, my lord, in this application, now the short point of filing the appeal, my lord, in the Railway Claims Tribunal, we were awarded a sum of money on the ground. My lord, the claim application was originally filed against the railways is on account of non-appropriation of freight charges. Because, my lord, because railway promised us that on a specific route our goods will be delivered, but railway delivered it in a shorter route. But railway charged us on the larger route, my lord, and on that difference, my lord, we got a decree got an award from the RCT, from the Railway Claims Tribunal. Now, my lord, subsequently the railways had challenged this matter before the Honorable High Court, my lord, and the first appeal was registered. Now, my lord, in the meantime, since there was no stay in this matter, my lord, and they had not taken any steps in the appeal, the executing court proceeded, and my lord, an amount of rupees 4 crore 85 lakhs is now lying deposited with the Railway Claims Tribunal. Now, my lord, when we are going to withdraw the money, railway is saying that since there is an appeal pending, you cannot withdraw the money. So, my lord, by filing this application, my lord, I pray that your lordship may allow me to withdraw the money subject to whatever happens in this appeal, my lord, on an undertaking. And, my lord, do you expedite the hearing of the appeal?
Well, the disputes between, my lord, two central government organizations. Appellant before your lordship is Southeastern Railway, and, my lord, the respondent before your lordship is Steel Authority of India Limited.
You transfer from pocket to pocket.
Well,
Right pocket to left pocket or left to right, whatever. Whichever is more leftist, you transfer to them.
No, but kindly consider whether this claim is justified or not. The passing of this order.
You have not obtained a stay from 2015. You must have advised your junior before coming into court. There is no stay. You have not even applied for stay for these. So how many years? 10 years, for a decade. So therefore, they are entitled to get that amount. You cannot withhold that amount. And what about the records and you have not?
Also, they have not filed the paper books also.
Then why is the railway doing like this?
I understood.
My lord, in a slew of matters, railway is doing these kind of things, and my lord, the matters are coming up. Slew of matters, railways has done, and an amount of this.
Anyway, was there a previous direction for calling for the records? Or,
no such
yes, my lord, because the appeal has been admitted, my lord.
No, appeal is admitted is different.
No such directions.
We'll pass the directions right now.
Filing a paper book given, no such direction was given, my lord. So we have to produce certain evidence also, my lord, on record.
That you have to file your application for that, you know that.
Because kindly also consider the whether the claim was justified or not, or whether the order passed by the London Tribunal passing their claim, the differential freight charges was justified.
No, that will hear in the main appeal.
Yes, on merit. If your lordship kindly hear
No,
the
no,
on
stay, the stay application was filed, you never moved it.
There was no stay.
Yeah,
That's the reason why it was deposited in the RCT, man.
Because it was
stay application which
Because had the stay been moved here, my lord,
Not
the amount would have been deposited over the Registrar General.
for the before the executing court, my lord, we have deposited 4 crores and odds.
85 lakhs, my lord.
4 crores 77 lakhs and odds.
85 lakhs
85
something.
lakhs,
there.
35 lakhs.
Whatever is the amount deposited, they'll withdraw it. Because it has been executed, in fact. They have already deposited in terms of the award. So they will withdraw that, will permit them, and will direct you to prepare a paper books and the other directions. The present appeal has been preferred on behalf of the Southeastern Railway against an award passed by the Railway Claims Tribunal, Kolkata bench. Full stop. Next para. We find from the records that till date, no order of stay has been passed in connection with the appeal, although the appeal was preferred in the year 2015. That is about a decade back. Full stop. Next para. Learned counsel for the respondent, Steel Authority of India Limited, submits in support of Can 2 of 2025 that in execution of the award, an amount of rupees 4,85, 35, 433 oblique dash has already been deposited by the appellant railway authority before the tribunal. However, despite there being no stay, the tribunal is not permitting the respondent to withdraw the amount. Upon hearing learned counsel for the parties, we find that in the absence of any stay and since execution has virtually been effected, there cannot be any impediment in release of the awarded amount in favor of the respondent. Accordingly, Can 2 of 2025 is allowed, thereby directing the tribunal to release the deposited amount of rupees 4,85,035, 4,84,85, 35, 433 oblique dash in favor of the respondent. Next para. However,
subject to financial security.
However, such amount shall be released in favor of the respondent, that is the Steel Authority of India Limited, subject to the Steel Authority of India Limited furnishing appropriate security to the satisfaction of the tribunal. Such release shall be effected within a fortnight from the respondent approaching the tribunal in that regard. Next para. The trial court the records of the tribunal shall be brought before this court by special messenger at the cost of the appellant, to be deposited within a fortnight. Within a fortnight from date, the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the records on the learned advocate for the appellant. Next para. In view of the appearance of the respondent to its learned advocate, service of notice of the appeal on the respondent is dispensed with. Liberty to the parties to mention the appeal for inclusion in the list for the purpose of hearing as and when the same is made ready for hearing.
My lord, only one thing. My lord has permitted me to withdraw 4 crore 85 lakhs along with the interest that has been accrued, because if it has been
যেটা বললাম 4 lakhs যেটা বললাম along with interest, amount figure টা যেখানে আছে withdraw করতে, along with interest, if any accrued upon deduction of statutory charges. Thank you.
Item number 23.
23.
It's my application.
23, I'm for the defendant.
এটা পরে পাসওয়ার্ড টাকা। Oh yes.
It's my application, my lord. Yesterday, your lordship has noticed that whether in the garb of
we noticed something against you. We forgot that.
That's why, my lord, it's my duty to point out.
Yes, please point.
My junior informed me that your lordship is of the view that in the garb of this application for repairing, whether a reconstruction is being prayed for. Lord, may I just, Lord, impress upon your lordship, Lord, this is a suit for partition initiated by my client. My father died, 3 of my sister and my mother. inherited the property 1/4 each. One sister and mother gifted not their respective share to me. So now I am a 3/4 share. My learned friend is not of 1/4 share. But I am the one of the sister who is not residing in the the dwelling house.
You are
He
a
is married.
respondent. You are a respondent in the appeal.
I am respondent in the appeal.
Yes.
So accordingly, they my learned friend's client took out the defense with regard to that though one of the sister is not mentally sound and the mother was not in a position to give the property in my favor. But no material evidence produced. That's why the suit decreed in preliminary form. Now this appeal. Now it's the dwelling house of my our ancestral property rather. Whatever the improvement that I will do, that is for the annual to the benefit of all the parties. It's not that it is something that there are other properties. The dwelling house, if your lordship takes up the schedule.
Let us come to the schedule. Please read
Yes,
out the
yes.
schedule, Mr.
Yes,
Mukesh.
yes, yes. First, your lordship kindly takes up the schedule of the plaint. That your lordship. May I just hand over to your lordship?
No, we will find it from the decree.
Yes, the plain schedule your lordship will get. There are other properties, but so far as regards.
Yes, this is only regarding the house.
House, yes. So the house is the ancestral
Schedule
property. which
A is dismantling of artificial stone.
Yes, now I am coming. Page 4.
Para 10, yes.
Yes. This the flooring of the house is become so dilapidated. It needs urgent repair. I will not claim any equity. It's about our ancestral house which will be repaired. And without
Yes, but
claiming any equity.
we find all dismantling.
No, thereafter I have mentioned that
Please read out the ABC are dismantling of everything.
cutting roads, yes.
D is MS reinforcement for reinforced concrete work in all sorts of structure, all sorts of structures. These are very vague. Woodwork indoor, panel shutters, plaster of wall floor with sand and cement mortar. What about this? This is not a complete sentence. Plaster, you will plaster the wall floor after removing after dismantling it.
No, RC, the dismantling of
H is also dismantling. I is wooden fixtures to be removed. J is outside pending is also required. So you dismantle the floor, the walls, everything, wooden fixtures, and you plaster them.
And also roof.
We don't understand this.
whatever this has not couched in a proper manner, I must say.
File a supplementary affidavit.
Yes, I will indicate that whatever I not only dismantling, I will
Because this is all about
yes, yes.
A, B, C,
understand
and
that
H are all dismantling.
Yes.
Right? Regarding the mantling, we don't find anything.
No, I understand.
We find only D, MS reinforcement for reinforced concrete work in all sorts of structures. Does that mean anything?
Yes, yes.
Acha, next is woodwork in door and window frame fitted and fixed. In a door and window fixed, where you have removed dismantled the floor and everything. And then panel shutters. What will you do with the panel shutters? No sentence.
I understand. This I will recast in a fight.
Windows are there, my lord. There is no necessity of any panel shutters, my lord. Door and windows are already
So, and we'll also have an inspection.
Yes.
At your cost.
Very well.
But first we want to, because this application is subject to rejection at the outset.
I shall specify.
We find from the schedule given in paragraph 10 of the present application for repair that the same is vague in nature and primarily speaks about dismantling of the building standing on the suit premises, suit property. Puts up next para. However, learned counsel for the respondent stroke petitioner insists that the petitioner wants to develop the property and to revamp the condition of the same. Puts up, it is also submitted that such repair work would only inure to the benefit of all the co-sharers, subject to the outcome of the appeal. Puts up next para. Since the schedule is extremely vague as to what constructive repair work is sought to be done by the petitioner, on the prayer of the petitioner, we grant the petitioner liberty to file a supplementary affidavit, upon furnishing advance copy to the learned advocate for the appellant stroke opposite party, indicating the exact repair works to be undertaken by the petitioner. Full stop. Such affidavit shall be filed within a fortnight from date. Within how much time? Within a fortnight from date. Full stop.
position, my lord, if required.
Achha, very well. Response thereto, if any, shall be filed by the opposite party No, a composite affidavit in opposition to the application as well as the supplementary affidavit shall be filed by the appellant opposite party within a week thereafter. Full stop. Reply, if any, shall be filed within 3 days thereafter. Full stop. The application shall next be listed on November 25, 2025.
I'm grateful.
Pass over item number 21.
21, I am for the appellant, Lordship. Lordship, the CAN 4 has been listed, Lordship. The CAN 4 has not been served upon them, Lordship.
Why not served? And CAN 5 has not been listed. CAN 5.
CAN 5 has been disposed. It was a substitution application that has been allowed. So,
CAN 4 is order for 27.
Yes, CAN 4 is imputed.
What is CAN 3?
CAN 3 is a stay application.
This appeal is against what?
My lord, CAN 4 disposed of, my lord. My lord,
CAN 5 dispose of. 5. 5 he is saying dispose of.
That appeal against a decree of a suit for partition. Suit was decreed.
Preliminary degree was passed.
Yes. Preliminary degree was passed. Ex parte. That is our challenge.
Yes, CAN 5 was allowed by Justice Shane's division bench.
Yes, on
CAN 4, you should have given a copy to them. In any event, we will direct them to give a copy. This is order for 27. We will direct this to appear along with the appeal. You use your affidavits in the meantime. And 5 is for recording death of. Sorry, 5 has been allowed. 3 is, you said?
3 is for stay application.
Stay application. Stay will pass the usual order. The final degree proceedings will continue. No final degree will be drawn up.
Actually, there is an order of final degree. Yet it has not been drawn up completely.
We'll restrain it from.
Grateful. I am grateful.
My lord, limited period, my lord. One of these. Stay, my lord, for a limited period.
Why limited period? If the final degree is drawn up, the appeal will be rendered infractional.
Hearing, my lord. For the appeal, my lord, hearing at a specified time, my lord. Appeal should be heard, my lord.
We'll direct ourselves to hear it within a limited period.
The appellant, directed to the appellant, my lord, to prepare the paper book.
Even without your saying, we'll do that. CAN 4 of 2025 is an application for production of additional evidence under order for 27 of the Code of Civil Procedure. Full stop. The petitioner shall serve a copy thereof on the learned advocate for the respondent. Full stop. The application, that is CAN 4 of 2025, shall be heard along with the appeal. Full stop. Affidavits, if any, shall be exchanged in the meantime. So next para. CAN 3 of 2025 is disposed of on contest by directing the learned trial judge to carry on with the final degree proceedings. Full stop. However, the learned trial judge shall not draw up any final decree in the suit from which the present appeal arises till disposal of the present appeal. Full stop. Next para. In view of the appearance of, you are for respondent number
1.
In view of the appearance of respondent number 1 through his learned advocate, service of notice of the appeal on the respondent number 1 is dispensed with. The other defendant should be served partition suit. The appellant shall deposit postal costs and requisites for service of notice on the remaining respondents within a week from date. Full stop. The trial court record shall be called for by special messenger at the cost of the appellants, also to be deposited within a week. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of arrival of notice of the trial court records. From within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for hearing as and when the same is ready for hearing.
Great.
Next.
Item number 24.
My CAN 3, my lord, has to be heard. My lord, this is an application for expunging the name of Amitabh Panda, is the appellant number 1B, because other legal heirs, my lord, are already on record. My lord, he was.
Anybody is appearing for the other side?
Notice of appeal. Milord, notice of appeal, Tolovana, special messenger cost, all were put in the year 2022.
TCR has come.
LCR has come.
So what about the paper books? You prepare the paper books.
Milord, one thing regarding the merit of the appeal, if your lordship would kind enough whether paper book is necessary, this is an appeal from a preliminary degree passed in a partition suit. If your lordship would kind enough to come to Milord page 6 of the impugned judgment, because I would be praying Milord for leave to file afresh. Milord, kindly see page 6 of the impugned judgment.
কোন মাইকে শব্দ হচ্ছে? Somebody's mic is getting scraped. You're probably কিসের শব্দ হচ্ছে এটা? ভুতুরে শব্দ? আমাদের কি না নেটে কানেক্ট করা রয়েছে নাকি? এটা তো হাওয়ায় শব্দ হবে না তো। শব্দটা কোথা থেকে আসছে? কিসের শব্দ হচ্ছে? কোথাও কাকে ফোন করছে? কন্টিনিউয়াস হয়ে চলেছে সব এটা। Yes, Mr. Bhattacharya.
6 Milord, kindly see the last two paragraphs. It is settled proposition of law that the case of the parties must be specifically pleaded and proved. So there cannot be any proof in absence of specific pleadings. Thus, undoubtedly, the instant suit remains bad for partial partition, and all Ejmali lands of the co-sharers have not been brought on common hotspot. Also, the suit is bad for non-joinder of necessary parties. All the co-sharers of Ejmali properties have not been included in the suit. Milord, this was the ground. Milord, Milord, kindly allow me to file a fresh suit. Milord, this is not bad. Milord, this is suit for partition. Milord, I have checked up, Milord. There were admittedly in CS recorded other co-sharers, Milord, that they are. This is the only ground for dismissal.
The other side has to be there.
I can give a notice and come back. Kindly allow scan 3.
We'll just dismiss the appeal. We'll allow your application, dismiss the appeal. We'll say that this will not debar from filing.
Liberty.
Not liberty. We'll say it will not preclude you from filing a fresh suit.
On the same self cause of action, Milord. That's
শুধু দেখুন partial partition আর non joinder ground dismiss করেছে আর কোনো ground নেই। Can we record your submission on that?
Definitely, I have talked with the client.
Can 3 of 2025, can 3 of 2022 is allowed, comma, thereby directing the name of opposite party number 1, capital B, Amitabh Panda, comma, who has died in the meantime, comma, to be expunged, comma, since his heirs are already on record as parties to the appeal. Full stop, no address to cost. Full stop, next para. Learned counsel for the appellants submits that although there were previous directions for service of notice, comma, paper books, comma, etc., comma, the appeal can be disposed of on a short point, full stop. Learned counsel, comma, on instruction, comma, submits that it is a fact that the suit filed by the partition suit filed by the appellants, comma, from which the present appeal arises, comma, was bad for partition and non-joinder of all the co-owners as parties to the suit. Full stop, next para. Upon a thorough perusal of the impugned judgment, comma, we find that the only grounds on which the partition suit of the appellants was dismissed was that it was bad for partial partition, comma, since all the Ejmali property of the co-sharers had not been brought in the common hotspot, and that the suit was bad for non-joinder of all co-sharers, comma, who were necessary parties. Full stop, next para. Thus, comma, in any event, comma, the present appeal does not have any merit. Full stop, next para. Even otherwise, comma, since the suit was only dismissed on the technical grounds of partial partition being not permitted and non-joinder of necessary parties, comma, the dismissal of the suit cannot preclude the appellants from filing a fresh partition suit upon impleading all co-sharers and bringing within the hotspot of the suit all properties common to the co-sharers, more so since the cause of action for filing a partition suit is continuing in nature. Full stop. Accordingly, FA 56 of 2019 is dismissed, thereby affirming the impugned judgment and decree dated April 21, 2018, passed by the learned civil judge, Senior Division, Second Court at Kontai, District Purbo Medinipur, in title suit number 56 of 2009, with the observation that nothing in this judgment and stroke or the impugned judgment and decree shall preclude the plaintiff stroke appellants from bringing a fresh suit on the self-same cause of action by impleading all co-sharers as parties to the said suit and bringing within the hotspot of the suit all the joint properties belonging to the co-sharers. Full stop. There will be no order as to cost. A formal decree be drawn up. তার আগে একটা লাইন অ্যাড করে দিও, there is no other application pending.
Only three. No.
আচ্ছা, আর কিছু অ্যাড করে দরকার। A formal decree be drawn up.
The lower court's record be sent down department.
Judgment form. The trial court records, একটা লাইন অ্যাড করে দাও, the trial court records be sent down immediately.
Item number 25.
My lord, in this matter, I am for the petition. And the matter is laid by Miss Pompibos.
Mr.
Miss Pompibos. I'm praying for not this week.
No.
my lord.
Yesterday also crime was granted, no further time. Either move the matter or dismiss for non-prosecution.
My lord, yesterday I have already prayed for not this week, my lord.
We refuse that. We granted not today.
No, I am prayed for not this week, my lord.
We are not granting it.
My lord, apology. My lord, she is suffering from medical injury, my lord. She is suffering from.
Say that. As if it's a matter of right for you. I am praying for not this week. I say that you have refused, that you have granted only not today. Again, you are insisting.
My lord,
You are very sorry, counsel. You bring the file. Where is the brief?
that I don't have, my lord.
If you don't have the brief, you don't have the right to ask for time. What is your locus standi? You are the chamber junior of Ms. Bose?
Chamber junior, my lord.
Chamber junior is without the brief?
My lord, she is suffering from vertigo problem and.
So what?
I don't have the brief, my lord.
He may have vertigo. It's not a matter of your right, sir. She may have whatever. Why shouldn't the junior be prepared with a brief? And you're going on answering questions?
My lord, I don't hear actually.
This is the second occasion when adjournment is sought on behalf of the appellant. The matter is dismissed for non-prosecution without any order as to cost. Interim order, if any, stands vacated. Next.
Item number 26.
I don't know, 26 education.
Yes.
My lord, I am for the appellant, my lord. My lord,
What is the matter?
my lord, matter is my lord, refusal of grant of probate, my lord. My
What
lord,
is the application for?
application, my lord, on limitation application, 618 days delay, my lord. I have filed on
Serve a copy.
My lord,
You are for the other side?
No, 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 my lord. This is a non-contentious proceeding, my lord.
Oh.
Only, my lord, very short point, my lord, it has been refused. My lord, there is a miscommunication in between advocate and the client.
Let us see the impugned
Yes,
judgment.
yes, yes, my lord. Only two attesting witness has not been produced, my lord. Registered will, my lord, everything, my lord. My lord, memo of appeal, my lord, it has been annexed, my lord. Kindly see the impugned order, my lord.
Why didn't you produce the witnesses?
My lord, my lord, at instance, my lord, I have said, my lord, there is a miscommunication in between advocate and that is the reason, my lord. But attesting witnesses are ready, my lord.
What is the ground for delay?
My lord, delay, my lord, I have stated, my lord, that ground. There is a miscommunication, my lord, kindly see.
What have you stated?
Yes, my lord, page, my lord, page 2 onwards, my lord.
No, the other heirs.
There is no other heirs, my lord.
Oh, you are the only heir?
Yes, my
And you are the executor and the legatee?
executor.
What is the ground? Let us see.
Yes, my lord.
After the probate case was rejected, you got upset mentally.
My lord, I could not get, my lord, the news that my case has been rejected, my lord.
Please come to
Thereafter-
para 4 and read it out.
The plaintiff appellant 6 months, mentioning silent and probate. But I do not know anything. I was almost silent after my probate case was rejected. I was very upset. Yes, my lord, I have stated, my lord, many things, my lord. There is also
You have stated,
main-
you have not stated too many things. Para 3, you say you are given advice, no learned advocate.
Para
No,
3 onward, my lord. I
Sorry,
have-
no. You are not diligent.
Para 3 is also there, my lord. Learned
Read out para 3
Yes, my
in the
lord.
microphone.
That the plaintiff appellant states that no learned advocate, anyone else has been given me any advice on what to do the next in the case. I had no idea that what to do in the next. That is why I could not. My lord,
Is this a ground?
my lord,
You were careful enough, you were diligent enough to file a probate case.
my lord,
You
next
knew
time-
that you had to approach an advocate to file a probate case. It was dismissed. You did not ask the advocate what to do next.
my lord,
Nobody advised you. Who will advise you?
my lord, next line, my lord. I am completely ignorant of the case.
You are ignorant of the case. Your own probate case, it was dismissed. If you are ignorant, you are totally
My
negligent.
lord,
Sorry, no.
my lord, attaching with ready, my lord, very.
No, no, no.
kindly, my
Ready
lord.
too late. 800 something days.
No,
600,
600, 600, my lord.
2 years delay. No.
But I can file, my lord, another supplementary affidavit regarding the limitation application. But kindly, my lord, give.
No, no. We can allow it, but you have to, we'll impose exemplary costs. Exemplary costs. Otherwise, no.
Very poor man, my lord. There is my lord, miscommunication with the advocate
No,
and
no.
the and probate is
Miscommunication between whom?
advocate and the lower court advocate and the client, my lord. Poor allegation.
Give a notice to the lower court advocate. We'll hear him also. You have cast the entire blame on the advocate. Advocates are not there to
No,
take
but-
blame of their clients
no, no.
without being heard.
That-
Give a notice to the trial court advocate. Sorry, no. This is not done. And this is very flimsy.
Two attaching witnesses are ready, my lord. If your lordship, my lord, under order for
What is your small business you are running?
business form? Yes. My lord, small business, I do not know. Key business.
What is the small business you are running?
Key business.
Everybody feels his business is very small. If you ask Mr.
Agriculture produce, I am selling the agricultural produce, my lord.
Do you know which companies sell agricultural produces?
No, no, no. my lord.
Should we name some? Reliance sells agricultural
Yes, my lord.
produce. Tata has agricultural produce outlets.
But very small, my lord. Vegetable seller, vegetables and other agricultural crops has been sold, my lord. By them.
কি করি বলুন তো প্রবেট মানে তো একজন মৃত মৃত লোকের ইচ্ছেটা আছে কিন্তু মানে কত খারাপ ভাবে হ্যান্ডেল করেছো কি বুঝুন যে আর্টিস্টিক উইটনেস দেন টোটাল কস্ট দিয়ে দিই 10,000 টাকা কস্ট দিতে বলি লিগাল এড সার্ভিস পশ্চিমবঙ্গ লিগাল এড সার্ভিস দিতে করে একটা কস্ট
Order no.
The present appeal has been preferred against the dismissal of a probate case by the district delegate at Kalna. Full sub next para. In the application for condonation of delay bearing can 1 of 2024, comma, it has been indicated that the petitioner, comma, who runs a small business, comma, which has been indicated to be the business of selling vegetables at the time of hearing, comma, was unaware of the steps to be taken for against the dismissal of the probate case. So moreover, comma, it has been indicated in the application that the petitioner was not in a financial condition to prefer any challenge. Full stop. Although the reasons furnished in the condonation application are unhappily drafted, comma, we can appreciate the agony of the litigant in the sense that even the uncontested probate case of the litigant, of the petitioner, was dismissed merely for non-production of attesting witnesses of the will. Full stop. Next para. That apart, comma, we cannot be unmindful of the fact that after all, comma, in a probate proceeding, comma, it is the last desire of a deceased person which is being sought to be honored. Full stop. Next para. In the event we shut out the litigant at the precincts of justice, comma, ultimately the last wish of the deceased testator would go unfulfilled. Full stop. Moreover, comma, keeping in view the fact that a probate decree stroke judgment is in the nature of a judgment in rem, and the laches of an individual litigant, comma, be he the sole legatee stroke executor, comma, ought not to come in the way of lending fruition to the fruition fruition to the express desire of a testator. Full stop. In such view of the matter, comma, can 1 of 2024, can 2 of 2024, sorry, can 1 of 2024 is allowed, comma, thereby condoning the delay in preferring FAT 559 of 2019, comma, on condition that the appellant deposits costs of rupees 10,000 with the Calcutta High Court Legal Services Authority within 1 month from date. Full stop. Next para. It is made clear that the event of such non-deposit, comma, the appeal would stand automatically vacated. Now, the above order shall stand automatically vacated, and the appeal will be deemed as time barred. Push up. Next para. Can 2 of 2024 is an application for production of additional evidence. Push up. Next para. The petitioner contends that the petitioner has all along been ready with the 2 attesting witnesses of the will in question and wants them to depose in the probate proceeding. Full stop. Accordingly, we allow can 2 of 2024 and permit the petitioner to have the 2 attesting witnesses of the will adduce evidence in connection with the probate proceeding. Full stop. Next para. In view of the above order, comma, FAT number 559 of 2019, comma, which is even otherwise uncontested, comma, is allowed, comma, thereby setting aside the impugned judgment and order dated judgment and order within bracket deemed decree bracket close dated December 4, 2017, passed by the learned district delegate at Kalna, comma, district Purbo Bardhaman in probate case number 24 of 2011, and remanding the matter to the district delegate for a fresh consideration upon granting opportunity to the appellant to adduce evidence of the attesting witnesses of the will and any other witness, comma, if the appellant so deems fit. There will be no arrest to cost.
But any time maybe frame, my lord, within 2 months or 3
You have got enough. Deposit that amount with the Calcutta High Court Legal Services. এটাও জাজমেন্ট ফর্মে, কিন্তু ডিগ্রি হবে না। কিসের আওয়াজ হচ্ছে ঝড়ের মতো?
Grateful to your lord.
Thank you.
Item number 27.
Yes.
In this matter, I am for the appellant.
Yes, Mr. Math.
Pursuant to my earlier direction, my lord, I sent copy of the applications, my lord, to the respondents. My lord, so far the heirs of respondent number 2 is concerned, those articles have come back with endorsement, my lord, returned left. My lord, I have finding out, my lord, a proper address. My lord, kindly give me, already I have got it, it is Barwipur. My lord, kindly give me some more time so that I can, my lord, come back with all the service.
No,
Time, my lord, kindly grant.
no, but you have to then furnish the new addresses,
Yes,
current addresses.
yes, yes.
So you will let it go out of the list for the present. You furnish the new addresses, because otherwise you there's no use. You can applications we take. Learned counsel appearing for the appellant stroke petitioner submits that some of the postal articles sent to the respondents came back with the endorsement double inverted left. Full stop. Learned counsel seeks some time to ascertain the current addresses of the said respondents. Full stop. Next para. Accordingly, let the applications go out of the list for the present, with liberty to the appellant to mention for inclusion in the list as and when the appellant is able to ascertain the current addresses of the of all the respondents. Thank you.
Item number 28.
Not my application. Yes. Well, there are three applications, my lord. Can 2, 3, and 4, my lord. Can 3, my lord, the appellant number 1 has died. So can 3, my lord, is the application for substitution of the legal heirs after setting aside amendment. Additional prayer is that the legal heirs now have been able to, the delay is attributable to the massive accident suffered by the present applicant, my lord, who has lost his, ultimately, there has been amputation of his thumb and middle finger. So he was in hospital for a substantial period of time. He could not prefer the application. And number 2, the second prayer in the application is that these legal heirs, the wife and children of the appellant number 1, they are not cooperating with the appellant number 2. So they may be transposed as respondents in the appeal. And can 2 is the application for under section 5 for continuation of the delay. And can 4 is, my lord, there is another application. The other appellant, my lord, appellant number 3 is also not cooperating with the appellant number 2. So therefore, he may also be transposed as a respondent in the appeal.
The challenge is against?
Partition suit dismissed on the ground of partial partition.
So can 4 is that transposition of 3?
No, but yes, can
Yes. Transposition of 3.
No.
First, we'll have to hear can 3, which is substitution after setting aside amendment.
Yes.
Can 2 is an application for continuation of delay in filing. Can 3. What is the delay?
My lord, the delay is there is, my lord, 289 days, I suppose, my lord, by reason of the hospitalization of the applicant.
You are appealing for the other side?
Yes.
My lord.
So what about this hospitalization and all?
My lord, we do not oppose anything. We just want a short period for the paper books to be filed and the matter to be heard.
There is already an order. We have not yet received my instructions. We have not yet received
transposition, but difficulty is transposition. Then where you also have to serve notice on the other appellants.
I have already served, my lord, all excepting one has returned as
no, the appellants also you have served.
Yes.
Oh, because that has to be served.
Yes.
For seeking transposition.
Yes.
You are appellant number 1.
I am appellant number 2, my lord. Appellant number 1 has died. Jogabandhu has died. I am Shaki Gopal Ghosh.
And I am for the respondent number 1 only. Bhuvaneshwar.
So respondent number 2 has to be served, and respondent number 3 has to be served.
Yes.
No, the notice of appeal. Can 3 affidavit of service filed today be kept on record? Full stop. Can 3 of 2025 is an application for substitution of the heirs and legal representatives. Who are the heirs? There are other heirs also.
No. My lord, the wife and 2 children, my lord, I have given the names, my lord. This is kindly comes to page 4 of my application, my lord. Anjali Ghosh, Srimati Anjali Ghosh, my lord, wife. Srimati Purubhi Mal,
yes.
This is the daughter. And
so they also have to be served then.
Lordship. I have sent, in fact, but fresh service.
That is this application.
Lordship.
Of the heirs and legal representatives of the deceased appellant number 1, namely Jagabandhu Ghosh. Full stop. Next para. Can 2 of 2025 is an application for condonation of delay in preferring can 3 of 2025. Full stop. It transpires from the explanation given, the averments made in can 2 of 2025 that during pendency of the appeal, appellant number 1 Jagabandhu Ghosh died intestate on May 1, 2024. Full stop. The present petitioner, that is the appellant number 2 Sakshi Gopal Ghosh, GHOSE, had suffered from a serious accident and had to be hospitalized, and ultimately his thumb and middle finger had to be amputated. Full stop. As such, we find sufficient explanation for the delay in preferring can 3 of 2025. Full stop. Accordingly, can 2 of 2025 is allowed, comma, thereby condoning the delay in preferring can 3 of 2025. Full stop. In view of the reasons as set forth above, comma, which are common and overlapping with the explanation given in can 3 of 2025, comma, can 3 of 2025 is also allowed, thereby directing the heirs and legal representatives of the deceased original appellant number 1, comma, as described in paragraph number 3 of can 3 of 2025 to be substituted as respondents in place and stead of the said deceased appellant number 1 Jagabandhu Ghosh. Full stop. Next para. The office shall carry out the consequential corrections to the cause title of the memorandum of appeal accordingly at the earliest. Full stop. Next para. Can 4 of 2025 has been filed by appellant number 2 alleging that the appellant number 3 is not willing to carry on the appeal. The appellant number 3 is not interested anymore in the carriage of the appeal before this court. Full stop. Accordingly, comma, can 4 of 2025 is allowed, comma, thereby directing the transposition of appellant number 3 to the category of respondent. Full stop. Can 4 of 20, no order as to cost. Next para. The office shall also carry out the necessary consequential corrections by depicting appellant number 3, Sri Kesto Chandra Ghosh, as a respondent in the memorandum of appeal. Full stop. The appellant, the service of notice of the appeal on the respondent number 1 is dispensed with in view of appearance of the said respondent through his learned advocate. Full stop. The appellant shall put in due requisites for service of notice of the appeal on the respondent number 2, comma, on the substituted respondents, namely Srimati Anjali Ghosh and Srimati Purabi Mal, and the transposed appellant number 3, namely Sri Kesto Chandra Ghosh, within a week from date. Full stop. Next para. The trial court record shall be brought by special messenger at the cost of the appellant number 2, comma, who is the sole continuing appellant, comma.
But LCR has arrived.
Oh, it has already been.
LCR has arrived. Notice has not yet been served upon us.
Trial court record record shall. The continuing appellant number 2 within bracket now, comma, the sole appellant bracket closed shall file the requisite number of paper books within 8 weeks from the date of service of notice of notice has been served.
No.
Within 8 weeks from the service of notice of arrival of the trial court records on the learned advocate for the said appellant. Full stop. Liberty to the parties to mention the appeal for hearing, inclusion in the list for hearing as and when the same is ready for hearing.
One humble preamble. Your Lordship has mentioned 2 names as this is here. There is the third here,
Anjali and Purabi.
And Srimati Jhuma Ghosh, at page 5.
Anjali Purabi jekhane bola and Srimati Jhuma Ghosh.
Lordship.
Thank you.
Great. Applications are disposed of.
Yes, we have already disposed of while on the go.
Lordship.
Yes.
Great.
Much obliged.
Thank you.
Item number 25.
I'm for the appeal. This is my application.
1 to 7 was dispensed with.
Yes, my lord, I am for the respondent 1 to 7.
But you have not filed your Vokalatnama, the office says. You appeared, we dispensed with service, but you have not filed your Vokalatnama.
I have already been filed, my lord, at the.
You resolved the issue with the department because the entry number of the Vokalatnama, please give to the department.
At the time of my lord, the clerk was Mr. Manos.
And
Filed the Vokalatnama.
What about postal cost? You haven't put in the postal cost for effecting service on respondent numbers 8 to 9 and 17 to 20. The application for this application?
Application for restoration, my lord. Recalling the order, my lord.
When was it dismissed for default?
It was dismissed on 16th June. What a very unfortunate situation, my lord. After recess, while I was present before.
This is
In the order, there is a direction, resume, my lord.
No, this application is within time.
Yes. My lord,
What happened after recess? Why didn't you appear?
actually, my lord, after recess, my lord, I went to have some lunch, my lord. And in a matter was taken.
You generally take your lunch after the recess, not during the recess.
During the recess, during the recess. My lord, matter was taken up.
You went to lunch, we took up the matter during recess.
Yes, well, I mentioned before lordship, but lordship refused, my lord. But in the meantime, matter was
We took up the matter during recess.
My lord,
We took up the matter
No.
during. So you,
I went
you are
to-
having lunch even after the recess.
I went within the recess. I went, but after coming, wearing the being roped, my lord, I could not.
You have to
appear.
take less time in taking your lunch. We go to the other building, take lunch, and come back within that time.
My lord, but I said, my lord, what happened actually?
Yes, you are allowing the recall. Restoration
Yes, my
application.
lord, there is a resume, my lord. There is a direction
I'm
for
but
paper.
one sentence.
Have
my
you
lord.
stated that you are having lunch?
Yes, yes, my lord, I've stated.
Have you stated
I've
that?
stated. But what the fact I've stated. But actually,
He is entitled to his lunch.
actually,
Yes, you are opposing this application.
Yes, my lord.
We'll restrain you from having lunch today. On what ground are you opposing it?
Yes, my lord, there is a resume. There is a direction, my lord. Paper book direction.
no, that I shall do, my lord. What why I have
Order
paragraph
I'm
7.
telling.
What I have why I have preferred this application. There was an application for injunction, which was long pending. Your lordship has been pleased to direct.
No,
the
no, this was the
faculty-
second instance of dismissal for you.
My lord,
You are having lunch on the earlier occasion also.
No. My lord, your lordship disposing the can 3.
This was the second occasion when you were absent.
Yes. My lord, can 3, where there was injunction application, lordship directed the both sides to maintain status quo. My lord, status quo was prevailing, but since the can was dismissed, my lord, they are again raising the construction.
Oh, the can was dismissed for default, and you have also not prepared the paper. You have not put in the postal costs also.
Well, I shall do everything.
No, you are directed by that order itself
Millard,
to put
Millard,
in
Millard,
requisites. You have
Millard,
not put in.
Millard,
Why should you allow this application?
Millard, I shall do it.
No,
Why-
can 3 has been dismissed for default for good. No.
No, Millard, why I'm submitting? In absence of injunction application, they are
You
raising.
were absent on that date. On that date, we not only dismissed that application for default, appeal has been kept pending. We also directed you to put in the postal
Millard,
cost within a time.
Millard, I shall do it, Millard, because it is coming from.
Why didn't you do it already?
I'm saying, Millard, this is coming from legal aid. There are processes to do it, Millard.
This is a legal aid matter.
Legal aid matter. That is why it is taking time, Millard. Well, I'm kindly restore the status quo order, Millard. Otherwise, construction has been going on, Millard.
My lord, construction has already been on 2 months.
Status quo will be restored as on today then.
Yes,
But what is the status we don't know. You have to satisfy us. Otherwise, tomorrow you will file an application that they are
But
violating.
one brother is saying he has made construction. I shall again start the construction. This is the thing.
Long
No, we don't know what is the status quo today. They say that the construction has been completed. How do you know that
completed construction by one brother? Another is saying I shall start against Millard. I have stated in my application, Millard. I have stated in my application. Whereas only status quo will only save Millard.
Status quo is the worst possible order. We don't know the status and we pass status quo orders. What is the status? How do we know? You produce some document, you file a supplementary affidavit or photographs or something. We want to be sure about what is the status. We want to keep it on record.
Till then, a restraining order may be passed, Millard.
No.
Because they are trying to make again construction over there, Millard. But kindly consider one thing, Millard.
We'll revive the injunction as on today.
Yes, my long back.
As you lordship pleases, as you lordship.
Long back.
Any further
has
construction may
already
be
completed.
wasted, Millard.
There is no new ground, no successive ground.
Any further construction may be needed, Millard.
Learned counsel for the petitioner submits that the matter comes from the legal aid services, and as such, we take a lenient view in favor of the petitioner in that regard. Full stop. Next para. From the explanation furnished in the application, we find no fault of the petitioner in not being unrepresented on the relevant date when the application was dismissed for default. Accordingly, can 6 of 2025 is allowed, thereby recalling the order dated June 16, 2025 and restoring can 3 of 2020 to its original file and number. Push up the injunction order is revived as on today till disposal of the appeal. Full stop. Next para. The injunction order granted in connection with the same is revived as on today and shall continue till disposal of the appeal. The appellant shall, the time for filing special messenger cost for bringing the trial court records is extended for a week from date. Please do it. Week from date. Full stop. The time for filing postal costs and other requisites for service of notice of appeal on the respondent numbers 8 to 16 and pro forma respondent numbers 17 to 20 is also extended for a week from date. Full stop. Next para. The office, since learned counsel for the respondent numbers 1 to 7 submits, contrary to the office report that he has already filed wakalatnama on behalf of the respondent numbers 1 to 7, the office shall give a notice to the learned advocate appearing for the respondent numbers 1 to 7 for the purpose of ascertaining as to whether actually such wakalatnama has been filed. Full stop. Next para. The earlier direction regarding preparation of paper books is retained. Full stop. Liberty to the parties to mention the appeal as and when the same is ready for hearing. The office will give a notice to you. You yourself go to the office and just produce the entry slip of your wakalatnama or the filing number of the wakalatnama.
I have no, I have forget I have lost where I am kept entry slip. I forget.
You have lost your filing number of the wakalatnama.
Yes, my lord. Fresh wakalatnama is to
File a fresh wakalatnama.
Yes, my lord.
How soon can you do that? How soon can you file a fresh wakalatnama?
From the party information party called my lord from the
আরেকটা লাইন অ্যাড করে দাও। In the event no wakalatnama has been filed previously, learned counsel having instruction to appear for respondent numbers 1 to 7 shall file a fresh wakalatnama, file a wakalatnama on behalf of the said respondents within 3 weeks from date. 3 weeks.
Yes, my lord.
It's you are not doing a mercy to the court.
Yes,
unless you do that, it will proceed ex parte against your clients.
Yes, my lord.
Call on the next matter.
My lord, there is an injunction application, my lord.
Yes. ন্যাকাপনা হচ্ছে। টাইম দিচ্ছি ওকালতনা ফাইল করার জন্য, ফাইল করেনি, বলছে ফাইল করেছে, তার এন্ট্রি নাম্বার নেই। যখন বলছি ফাইল করতে তখন বলছে যে আমার চিন্তা করে দেখতে হবে কবে ফাইল করবো। ন্যাকাপনার সীমা নেই। Yes.
May I please, your lordship?
You may.
Here was the applicant of number 1 and 2. My respectful submission.
Please use the microphone, Mr.
My respectful submission before lordship that the incidents which prompted me to file this canned application for vacating and modification of the order which your lordships has passed on 14th May 2025. The first point,
we think this will take some time. We'll continue after the recess. We'll continue after the recess.
Item number 30, we got
Sorry, I was late in a meeting. Yes.
Yes, my lord, in this matter, I am for the appellant.
What is the, yes, you are saying something?
For the appellant, I am paying for not to.
Why?
The learned advocate record is in another court.
On the previous occasion also it took time.
No, move the matter, move the matter.
Well, I would be appearing in application number 3, can 3 of 2020.
What is the application about? The appeal arises out of what?
Application for recalling, modification.
Arises of judgment
And
and degree
vacating.
passed by the trial court
What judgment degree?
in suit for partition.
Preliminary degree?
The final day.
The application is for what?
For lordship, vacating of interim order, vacating of interim order. That was this, and
What is the interim order?
whatever lordship, your lordship will pass the order on 14th May 2025. What happened, lordship? Why I am prompted to file this application on the mainly two grounds that they filed this application earlier by misrepresentation
My lord, may I
suppression of-
shortcut?
and
My lord-
suppression of material facts. What happened, lordship, and also the order which they obtained, they passed by your lordship, granting stay, they have dispossessed the petitioner because of the can application from their residence of house and
No, stay of further execution case was stayed by that order. So why are you seeking for a vacation of that? The appeal will become infructuous if the execution case is not stayed.
My lord, may I place my lord application
he-
shortcut? Then it would be better, my lord.
Let him place his.
lordship, what happened? Only
Please take the microphone a bit.
on the ground of lordship, they lordship persuaded with the passing order on the basis of they have not focused the misrepresentation and suppression of material facts.
What
That-
material fact?
I am saying.
No, what material fact was?
That material says the earlier one application, their application was heard by the division bench on 14th, 24th, 22nd April 2024.
In connection with the same appeal?
Same application,
The application?
same application.
What happened in that?
That the lordship, after prolonged hearing on twice occasion, the lordship was declined to pass any order of stay, and usual normal order was passed for preparation of paperwork. This much. But
Was the stay application disposed of by the
no,
lordship?
lordship. That's I am coming to.
Ad interim stage does not bind the final stage.
The whatever lordship, honorable court was not in position to record the inadvertent mistake. Not recording their application was disposed of. Taking advantage of that order.
Can 1 of 2023 was pending when it was passed, when you passed our order. So then at the ad interim stage, no stay was granted. That does not mean that at the final hearing of the stay application, stay won't be granted. Two are different stages. Court may not pass stay order at the ad interim stage, but at the final hearing of the stay application may very well pass a stay order.
Lordship, only, Lordship, I am relied on two decisions. One decision, Lordship, recently passed by your Honorable Supreme Court. That's why I am placed forward before Lordship. Why and ad interim, in what stage ad interim order can be modified and
There is no question of modification. Where is the previous order? You have annexed those also.
Lordship?
You have annexed the previous orders also, where the stay was refused to them.
It is within 5 your Lordship's.
In my-
Lordship's file is very, I mean,
My lord, in
haphazard.
my application that is annexed.
Please.
I'm sorry, my lord. I'm sorry.
Yes. Should have annexed.
I have annexed to your Lordship's order.
You are relying on certain previous rejections, so you won't annex those orders.
As because this is Lordship.
When was it rejected first? Give us the date.
22nd April.
22nd April 2024.
অর্ডার গুলো এটাতে একটা তো সাজানো থাকে সিরিয়ালি তো ভীষণ অসুবিধা হয়। একবার সামনে যাচ্ছে, একবার পেছনে যাচ্ছে। কোথা থেকে পাবো এখন যদি এগুলো? প্রত্যেকটা অর্ডার বলছে আলাদা করে খুঁজে পাবো।
May I place
মাঝখানে মাঝখানে
may I
অফিসের
place
order. No, we have got it. 22nd April, yes, Justice Tandon.
Lordship Tandon's order.
Trial court records we called for. There is no question of any rejection of stay. Stay was not even considered at that stage.
Huh.
Directions were given.
Direction, only direction.
So what?
Lordship.
There is no reasoned order of dismissal or refusal of ad interim stay.
No, not that, Lordship. Against that order, Lordship hard in length, but finding no merit in the stay
We
application.
don't know from the order. We only it is not even recorded in the order. The order only records directions for paper book and special messenger cost.
Lordship. This is order says so.
Order does not say anything else. There is no refusal of ad interim order. Nothing regarding ad interim order.
Ad interim order not a.
There is not a single line devoted to refusing the ad interim order of stay. And at the final disposal of the stay application, we granted stay. There is nothing in this order to say that why no stay has been granted at that stage. Nothing.
But Lordship, one more, Lordship.
Sorry, you have no case. We'll hear the other vacating applicant. Yes.
My lord. Thing is that, my lord, my first submission will be allowed. By
His application, your application is
my
can
application
three.
is
Can three.
Can three, my lord.
Can two.
Acha,
My application.
Yes, can three. Yes. What is your case?
My case is, my lord, by practicing fraud upon this court, my lord. Order.
What is the fraud? That is what we are asking.
The fraud means, my lord, application was heard out by the previous page, that is on 22nd April 2024.
Yes.
My lord, the learned advocate who was appealing for the appellant was supposed to file the affidavit of service before your lordship, my lord, when the matter was taken up on 14 May 2025. But my lord, very cleverly, the affidavit of service prepared earlier, that was submitted before your lordship, and by practicing fraud upon this court, my lord, has obtained
Copy
the
was not
expert.
served on you.
No, my lord, no, never.
Affidavit of service was filed. Must have been.
My lord, that was affirmed before 1 year, 1 month ago.
So then, therefore, service was effected on you.
1 year back.
It's your duty after that to look after the matter whether it's appearing in the list.
No, my lord.
Publication in the list is
When,
public
my lord,
notice.
same application. It was hard in length. I have, my lord, pleaded in my paragraph number 4, my lord.
Yes.
Your lordship take trouble, my lord. Bottom 4 lines, my lord. Division of Justice, the said application was hard in detail for 24 minutes and 52 seconds. As is reflected in the proceedings recording in videotape available in YouTube. Even, my lord, if your lordship.
Whatever may happen in YouTube, whatever we comment during the hearing of a matter does not form a part of our formal record. I am very sorry to say that. And it's unfortunate that being an advocate and officer of the court, you're relying on YouTube video to say that it's the hearing might have continued for 24 years. We are not bothered with that. Hearing is not the final order. We are sorry, very sorry to say this.
My lord.
The final order, the formal expression of adjudication is only the ordering portion. Whatever order is passed in court and is signed by us, that is the only order which is passed.
My lord.
And I'm sorry to say, we don't find anything in the order of Justice Tandon after that hearing of 24 hours or 24 minutes that a single line has been devoted to say that they are not entitled to stay and we are refusing ad interim order. Nothing of that sort.
My lord,
Sorry.
my lord, same application.
A court may take
Same
24
application.
days even to hear. Self-same application.
Same application, my lord.
Obviously, the self-same application, we are not speaking of any other application.
But there was no reflection as regards.
Our
that the
stay application is
exhibition-
heard at the ad interim stage, even if it's for 24 days. One court may take 24 days to come to the same conclusion, which another court takes 24 seconds.
My lord.
We are not bothered with that, sorry.
My lord.
But our order, which is on record, is only thing which is a formal expression of an adjudication, which is our expression of our adjudication. The order of the bench, you are saying, heard it for 24 minutes, 52 seconds, is dated 22nd of April 2024. This is the entire order, which does not reflect a single line to say why ad interim is refused. If no adjudication is, if there was an adjudication, this is the reason we are refusing ad interim stay. Then we can look into many other aspects of the matter. Even if that was so, even if suppose ad interim was refused at that stage, it's very well settled that at the ad interim stage, whatever order is passed is not binding at the final stage.
My lord.
So
that is true. Very true.
Where is the question of suppression?
But my lord, that affidavit of service purpose.
You got a copy of that application 1 year back. It was your duty to look out for this when it appears in the list. And often matters appear from the department also. They are sent.
My lord, your lordship knows better than me, my lord. Only my lord.
There is no suppression on their part.
Accidental omission of recording judicial proceeding, my lord. Nobody can take advantage of.
What is the accidental omission here?
I mean, sir, my lord, application should have been disposed of. Actually, but the judges were so hairy because, my lord,
judges were so.
hurry at the time of because court when
That they
court was
forgot to write
rising-
the order.
Court was rising, my lord. Didn't time, my lord, perhaps
We
it
are
was-
not bothered with whether court was rising, whether court has a bad throat, or court was in a bad mood, which we are all perpetually in. We are not bothered with those things. Whatever goes into our order is our expression of adjudication. Even if the judge looks ruffled or looks very handsome or very ugly,
But my
does
lord,
not reflect in our order.
as soon as
The
that
order is what we pass, and the order of Justice Tannen and Justice Prasad does not devote a single line to say that this is the reason for which they are not entitled to ad interim stay. And even if ad interim refusal was there, that is not binding at the final stage. But here that is also not there. YouTube video, we don't look into YouTube videos, sir, to look at the orders of courts. Sorry.
My lord,
That is by laymen,
my
not
lord-
by practitioners in courts.
My lord, when the application was moved, another advocate, they have changed the counsel in the second
what?
time and got down.
Whoever advocate appeared, whoever the litigant remains the same, the order is what has been passed in open court. That is the only order we have to look into. What transpired in that court, we are not bothered about. Whatever is reflected in this order is only what we will see. And that binds us.
But my lord, as soon as they got the order from your lordship's court, my lord, the appellants become more violent, and now their activities are prejudging us. My lord, we become prejudiced because now they are taking law in their own hand. My learned friend, my senior
You
friend,
are taking law in your own hand because this appeal is pending. You are executing the decree. So we have granted stay of the execution. Their becoming violent has nothing to do with our stay order.
my lord, in that application, there is no whispering as to the execution. The application is in another footings. And
Do you deny that there is an execution case?
no, never. The execution is pending.
They have prayed for stay of the operation of the decree. We can mold the relief and definitely can grant stay of the execution, connected execution. What are you saying?
My lord,
This is a
my-
ground under Order 13 and Rule 4.
My lord, always my lord can pass the order.
You will execute the decree and the appeal will be rendered infructuous during pendency of the same. No.
My lord, without serving us, my lord, we didn't get any
You
opportunity.
were served 1 year back. You chose not
1
to.
month back, my lord. We are under the impression because
You are citing certain judgments, Mr. Chaudhary. Cite those judgments.
Lordship, kindly see paragraph 16, 17, and 44 and 45. What is the observation?
24 minutes, 52 seconds hearing হয়েছে সেটা।
Paragraph 16, 17.
Please give the citation so that the other parties can.
2016,
2024 6 SCC 267. 2024 6 SCC 267. Paragraph 17.
Paragraph 16, 17,
Acha.
and also paragraph 44 and 45.
Let us come to the proposition. Yes, 16, 17.
17, Lordship, where interim order to be modified or vacated.
Place it.
Lordship, I am placing.
Which portion you are relying on?
Lordship, I am go through the paragraph 17. The
Yes, it-
High Court- paragraph 17, page of Lordship.
Read
page-
it.
Eh?
Read it. Read the paragraph.
Paragraph 16, Lordship, page 286.
Go on.
Where a High Court, when the High Court are always empowered to vacate or modify the order of interim relief passed after hearing the parties on the following amongst other grounds. If a litigant, it is not applicable in our case. 72 is very much applicable. The High Court finds that the order of interim relief is granted as a result of either suppression or misrepresentation of material facts by the party in whose favor the interim order was has been made. And next, 17.3, the High Court finds there is material change in the circumstances requiring interference with the interim order passed earlier. And
How is this applicable in your case?
Yeah, that is applicable 72 and 73. That is it, Lordship kindly.
Is it applicable in your case?
Applicable, Lordship, yeah. This is, I may be wrong. It is
No, you may be right also. We may be wrong, but how is it applicable in your case?
Like, I am harping on this point that this misrepresentation.
You are harping on this point. How is it applicable in your case?
They have not.
If you apply this,
Uh,
if you apply 17.3, that is precisely what happened in their favor. When the ad interim order was not granted, execution case was not there. It was not even mentioned by any party. Subsequently, you levied execution. Therefore, urgency arose. Therefore, 17.3 goes in favor of in their favor for grant of stay. 17.3 says the High Court finds that there is a material change in circumstances requiring please. The High Court finds that there is a material change in circumstances requiring interference with the interim order. That material circumstance change is the levy of execution. Therefore, initially there was no ad interim order. This supports their case that subsequently, since execution was levied, rightly stay order was granted.
Sir, what I mean, this material changes, that is, they have forcibly dispossessed the allotted portion of the applicant. This is, I am think.
How can they forcibly dispossess? See, we have granted stay of execution of a final decree of partition. How does that order enable them or permit them to dispossess you or to become violent, become volatile? That is a separate cause of action. We have stayed your execution case so that you cannot execute the stay, execute the decree till disposal of the appeal. This is the only order we have passed. We have not allowed them, we have not granted an injunction permitting them to become volatile, as it says, or to dispossess you, or anything of that sort. We have only stayed the execution case. Whatever else they have done, you can file your applications, independent applications for restraining them. We shall decide that in accordance with law. That has nothing to do with the stay of the execution case.
Another lordship, paragraph 44 and 45 lordship. Now I am under impression that the order which has been the material change of circumstances indicating that the disposition.
Your disposition does not have any bearing. The stay of execution does not have any bearing on your disposition. That is an independent cause of action. You can file whatever application you like. We are not here to advise you. But that does not have anything to do with our stay of execution case order. And what other judgment you are citing?
Same on judgment, paragraph 44 and 45. Procedure to be adopted by High Court while passing interim order of a stay.
That is
of
44.
proceedings.
44.
44,
not 42.
lordship.
Yes.
Paragraph 44. At the same time, we cannot ignore that once the High Court stays a trial, it takes a very long time for the High Court to decide the main case to avoid any prejudice to the opposite parties while permitting ex parte. This is ex parte order. The ex parte ad interim order.
This is ex parte ad interim order. This says that High Court normally grants time-bound ex parte ad interim orders. This was not an ad interim order. The stay application was decided. This is an interim order. Stay application was disposed of and execution was stayed till disposal of the appeal.
Lordship, I respectfully submit subject to your lordship's correction that at this stage of interim order, possibly
no, this says ad interim order.
Ad interim
It
order
was the order of which you have sought vacating. That is not an ad interim order. Here, let us see the order. Can was disposed of finally. It was not an ad interim order. We also grant ad interim orders for a limited period sometimes. But this does not say that it's mandatory for High Courts. High Courts have full power to do whatever span of time they want, choose to grant stay. This is a general observation by the Supreme Court. Generally, ad interim ex parte orders should be granted for a limited period. And this was not an ad interim ex parte order. This was a disposal of the application itself. Rather, at the ad interim stage, this could have been applicable when the previous order was passed. But when we hear the final application finally, then we can pass an order till the disposal of the appeal, and we do.
Till disposal of the.
Sorry.
But my lord, perhaps my lord, your lordship's order, my lord, that application is still pending, not disposed of.
Please come to paragraph 6 of that.
Paragraph 6, till disposal of the appeal.
Till disposal of the appeal.
Read paragraph 6.
My lord.
Read it. It's in English. Please read it.
Accordingly, can one of 2023 is allowed, thereby granting stay.
Anything else is required?
Nothing is required.
Allowing is not disposal.
Till disposal of the till disposal of the appeal.
And it is probably going on for 24 minutes, 52 seconds also.
My lord,
and you will say that after 24 minutes, the judge was rising or was angry and therefore refused my prayer.
No,
that is not what is to be seen. Our written orders are to be seen, sir.
My lord. My lord, since lower court, trial court records have already arrived, my lord.
We'll dismiss both these vacating applications with exemplary costs because both the grounds are fully frivolous. There is neither any suppression of material fact nor any material change. And this judgment is totally inapplicable to this case. So we'll impose costs on your vacating applications for wasting the question.
My lord,
And
can,
you'll give
my
the
lord,
pay the cost to the appellant.
my lord can hear out the entire appeal, my lord. Because
We'll definitely not. Why should we?
Lordship, in that event, on my respectful submission, we will Lordship, then another pair in the said application to, we have come to know from the department that already LCR has come appear this before the department. And
All the respondents are appearing.
all the respondents?
No,
You have put in the requisites for service of notice on all the respondents.
I have not.
Let us check up the records.
My second prayer is that to expedite the hearing of the appeal.
Definitely we will do that.
Yeah.
But how?
And-
What is the
and
stage?
preparation of paper.
Records have already come.
Yes. Already come. We have come to loan from the department. The trial court record is
Just check whether all the respondents have been served.
Lordship, that is, it is within their domain.
Advocate clerk instructed me to file all requisites upon all respondents.
All has been deposited. But we have to ascertain whether the appeal is ready for hearing. We'll ask for a report from the office whether the
Yes,
office is
yeah,
ready
yeah.
for hearing. And as soon as notice is served on you, we prepare the paper books within a limited period. We'll direct that.
Lordship.
Can 2, yours is can 2.
Yes, Lordship.
Can 2 of 2025 and can 3 of 2025 are separate vacating applications, comma, seeking vacating of the order of stay dated May 14, 2025, passed in connection with can 1 of 2023, filed in the present appeal. Full stop. The present appeal arises out of a final decree of partition. Full stop. By the order dated May 14, 2025, comma, can 1 of 2023, comma, a stay application filed by the appellant, comma, was allowed, comma, thereby granting stay of all further proceedings in title execution number 5 of 2025, pending before this learned civil judge, bracket senior division, bracket close, third court at Paschim Medinipur, district Paschim Medinipur, till disposal of the appeal. Full stop. Next para, learned counsel appearing for the petitioner in can 2 of 2025 contends that there is limited scope of vacating or modifying an interim order granting or refusing relief. Full stop. It is submitted by learned counsel that the stay application, comma, which was allowed by the order which is sought to be vacated, comma, first came up for previously came up for hearing before a coordinate bench on April 22, 2024, when the coordinate bench had refused to pass any order of stay. Full stop. Next para, it is submitted that by the said order, the division bench had merely passed directions regarding preparation of paper books and other directions to ensure that the trial court records are brought to this court and the appeal is otherwise made ready for hearing. Full stop. Learned counsel relies on High Court Bar Association Allahabad versus State of Uttar Pradesh and others, reported at 2024 6 SCC 267. Full stop. In the said judgment, comma, the Honorable Supreme Court held, comma, inter alia, comma, that the High Courts are empowered to vacate or modify an order of interim relief passed after hearing the parties on the following amongst other grounds, comma, one of which was, if the High Court finds that the order of interim relief is granted as a result of either suppression or misrepresentation of material facts by the party in whose favor the interim order of stay has been made, and if the High Court finds that there is a material change in circumstances requiring interference with the interim order passed earlier. Full stop. Learned counsel appearing for the petitioner submits that the petitioner has been unlawfully dispossessed from the suit property, comma, which furnishes a material change in circumstances requiring the order in question to be vacated. For sub next para, learned counsel appearing for the petitioner in Can 3 of 2025 reiterates that the appellants obtained the order of stay dated May 14, 2025 by suppressing material facts. Full stop. Next para, it is submitted by learned counsel for the petitioner that when the stay application was initially moved on April 22, 2024 before a coordinate bench, the said application was heard in detail for 24 minutes and 52 seconds as reflected in the proceedings recorded in videotape available in YouTube and the cause list dated April 22, 2024 of the said court. Full-stop, it is submitted that even after such detailed hearing, the court refused to pass an ad interim order of stay, and as such, the said refusal ought not to have been varied by this court. Full stop. Next para, it is further submitted that the appellant obtained the order dated May 14, 2025 by filing an affidavit of service which was affirmed about a year previously. Full stop. Next para, thus, the petitioner in Can 3 of 2025 did not have any current notice at the relevant juncture of the pendency of the application. Full stop. Next para. As such, it is reiterated that the application be allowed and the stay order dated May 14, 2025 be vacated. Full stop. Next para, learned counsel for the appellants controverts all the allegations made by learned counsel for the petitioners and submits that there was no suppression of material fact at any point of time. Full stop. Next para, learned counsel for the petitioner in Can 3 of 2025 adds further that taking advantage of the stay order, the appellants have turned violent and are taking law in their own hands. Full stop. Next para, the very premise of the vacating applications is dehorse the law. Full stop. Next para, the proposition laid down in High Court Bar Association Allahabad Supra is not applicable in the circumstances of the present case. Full stop. The alleged change of material circumstances in Can 2 of 2025 is that the petitioner therein has been allegedly dispossessed by the appellants. Full stop. However, such alleged disposition, even if the same were to be true, does not have any connection whatsoever with the order of stay dated May 14, 2025. Full stop. By the said order, the court had merely stayed all further proceedings in an execution case arising out of a final decree of partition and had not permitted any disposition or anything else. Full stop. Next para, rather, the stay of the execution proceedings was intended to prevent unlawful disposition or change of status quo in respect of the property pursuant to the decree which has been impugned in the appeal, to save the appeal from being rendered infructuous. Full stop. Thus, the cause of action for vacating pleaded in Can 2 of 2025, that is alleged disposition of the petitioner therein, has nothing to do with the stay order and cannot furnish a ground for vacating the same. So next para, rather, the other proposition laid down in Allahabad High Court Bar Association Supra to the effect that if there is a material change in circumstance requiring interference, an earlier interim order may be modified, inures to the benefit of the appellant in the present case. Full stop. Even if the coordinate bench taking up the stay application earlier had refused to grant an ad interim order of stay on April 22, 2024, there is no reflection in the said order of any such refusal to grant stay. Full stop. Rather, comma, the order dated April 22, 2024 revolves entirely around directions being passed for preparation of the appeal for final hearing. Full stop. Thus, comma, it cannot be said that any particular ratio was laid down or reasoning given for refusal of ad interim stay, which was reversed by the order dated May 14, 2025. Full stop. Rather, comma, what was not pointed out to the court or reflected in the order of the coordinate bench dated April 22, 2024 was the pendency of an execution case, comma, which was in fact, comma, the change of circumstance which ought to have prompted the court to grant an order of stay when the matter was next taken up on May 14, 2025. Full stop. In fact, comma, the number of the execution case, comma, which is title execution case number 5 of 2025 itself shows that the same had not yet been levied when the order dated April 22, 2024 was passed, comma, therefore, the said filing of the execution case furnished a change of circumstance which prompted the court to grant an order of stay when the stay application was taken up for final hearing. Full stop. Next para. In any event, comma, any order passed at the ad interim stage does not operate as res judicata at the final hearing of the connected application. Full stop. Learned counsel for the petitioner in Can 2 of 2025 has also relied on paragraph 44 of Allahabad Bar Association Supra, which is also not German. Full stop. The said paragraph merely expresses the opinion of the Supreme Court that to avoid any prejudice to opposite parties, comma, while granting ex parte ad interim relief without hearing the affected parties, comma, the High Court should normally grant ad interim relief for a limited duration. Full stop. First, comma, by the order which is sought to be vacated, comma, the stay application itself was disposed of and the respondents, comma, despite service chose not to be present. Full stop. Thus, comma, it was not the ad interim ex parte stage that was happening when the order dated May 14 was passed, 2025 was passed. Full stop. Secondly, comma, the ratio laid down by the Supreme Court is more of an advisory nature and not a mandatory proposition of law set in stone. Full stop. Next para. Moreover, comma, in the absence of any ground for refusal of ad interim stay in the previous order of 2024, comma, there could not be any occasion for this court to vacate or modify any previous order at the final hearing of the stay application on May 14, 2025. Full stop. Next para. The other ground of suppression harped upon by learned counsel for the petitioner in Can 3 of 2025 also does not hold water. Full stop. Next para. The affidavit of service, comma, even if affirmed 1 year earlier than when the matter was finally heard, comma, indicated clearly that copy of the application had been served on the respondents. Copy of the stay application had been served on the respondents. Full stop. The publication of a matter in the cause list of this court is deemed to be public notice of the matter being pending before the concerned court. Full stop. Thus, comma, it was for the respondents to be vigilant as and when the copy of the application for stay was served on them. Full stop. Next para. We do not find any suppression on the part of the appellants on such score. Full stop. Next para. The petitioner in Can 3 of 2025 has also alleged that the appellants have become double inverted violent, double inverted clause, after the order was passed. Full stop. We are unsure as to what violence is being spoken of. Full stop. Even if any such violence was shown on the part of the appellants, comma, we do not find anything to connect between such violence and the order of stay of execution of the final degree of partition, which has been challenged in the appeal. Full stop. Next para. Thus, comma, on the whole, comma, both the vacating applications are palpably frivolous. Full stop. Accordingly, Can 2 of 2025 as well as Can 3 of 2025 are dismissed with costs of rupees 10,000 each full stop, the petitioners in each of the applications shall pay cost of rupees 10,000 each to the appellants within a fortnight from date. Full stop. Next para. Insofar as the appeal is concerned, comma, we find that there were already previous directions for preparation of paper books. Full stop. We are informed by learned counsel for the petitioner in Can 2 of 2025 that the trial court records have already arrived before this court. Full stop. Accordingly, we direct the office to issue notice immediately of the arrival of such records on the learned advocate for the appellant. Full stop. The appellants, comma, immediately after getting such notice, comma, shall commence preparation of paper books and as per previous direction, comma, shall file the requisite number of informal paper books within 4 weeks from the date of such notice being given to the learned advocate for the appellants. Full stop. Next para. Subject to the service of notice of the appeal having been completed on all the respondents and the appeal being otherwise ready for hearing, comma, leave is granted to the parties to mention the appeal for inclusion in the list for the purpose of final hearing.
Lordship, I am
Sorry for indulgence,
I-
only one, my lord.
Next.
In your lordship's order, my lord, on 14 May 2025.
to submit yourself affidavit of
Affidavit my lord.
Service.
in
What
pa-
is this?
Copy of the application also can.
What is this?
Can application, copy of the
Affidavit
can. Evidence.
Affidavit of service.
Lordship,
My lord, in your lordship's order, my lord, on 14 May 2025, my lord, the appellant mentioned that the can 1 was not moved earlier. Kindly have a look, my lord. Kindly text down. Next.
Responsible submission.
Item number 31.
Kindly reduce the cost of lordship. Kindly pay lordship.
No.
Poor,
Yes. Who is appearing in 31?
My lord, I am for the.
What is the
Next
matter?
question. My lord, on the last direction of the coordinate bench, my lord, I have service of copy to the.
And I am for the response.
My lord, except my lord, respondent number 11, everybody has been served.
11 has not been served.
I'm appearing for,
11 also.
no, only 1 and 2, respondent number 1 and 2.
Other,
11 contested in the court below.
no, expertise, my lord.
11 is refused.
No, it is 8. Other are my lord, delivered.
No, what about 11? 11 contested in the trial court.
No, expertise dismissed, my lord. 11. 1 to 3, my lord, contested in the trial court.
Very well. So,
Delay of 266 days, my lord.
the appeal is against what? Final degree?
No, partition should.
Preliminary degree of partition.
Partition.
How many days?
266, my lord.
Explanation?
Well, medical certificate, my lord, from the very
For
beginning.
266 days.
Well, the mother of the petitioner, my lord, the mother of the appellate, appellate number 3 is the mother of the appellate number 1, 2, and 3, my lord. Before, my lord, the passing of the order, for the last 1 year, my lord, entirely, my lord, time is suffering for the medical, my lord. Huge expense.
Various old age disease.
Yes, my lord, from.
What sort of various old disease?
Sometimes.
Prescriptions does not say any diagnosis.
Up to July 2023, therefore all the family was in the hospital throughout
No,
this
my lord.
period.
Three, my lord. Only 3 is in the hospital. He's the mother.
He was in the hospital.
Three.
Why couldn't 1, 2, and
3 are
4
the
file it?
Mother of my lord, the mother of, they are the daughter and son of.
The daughters and son were throughout these 266 days in the hospital,
No,
looking
no.
after their mother.
Ma-
Such devoted children would make any parent proud.
This is the, my lord, they are.
1, 2, and 4 were attending to their mother in the hospital all through, leaving their livelihood, everything.
Well, the mother was admitted. This is the.
Put before the, put on a plate which is palatable, something which is palatable. We cannot eat everything, whatever you give to us.
I know, my lord, but
1, 2, and 4 are so devoted to their parent that they were in the hospital looking after their mother for 266 days. Cook up some better story.
my lord, no, not 266 days. I have written there, my lord. Some they are.
What USG knee normal study.
No, no,
My lord, the
Profen.
medicine given was proceed, paracetamol.
no, there is a eye operation. There are abdomen pain. USG.
Pen 40.
No, not pen 40, my lord.
Not pen 40.
Several
Come
prescriptions.
to page 8.
Yes.
This is the first, my lord. Thereafter.
Show the worst possible when she was under the influence of the worst disease. Show us the prescription then.
My lord, page 10 USG whole abdomen.
USG, what is the result of the USG?
Thereafter, my lord, page.
USG, the report says normal study.
Page 12, my lord.
Page 12.
12 onwards, my lord.
Can't be read.
What is there in page 12? Read out. Sorry, no.
There is no diagnosis, my lord, stated, my lord, anywhere.
Hey, what is the diagnosis? Advice is ECG.
You know, this is one.
Take the blood pressure of any of the counsel or the judges. Or take an ECG.
17, my lord, also USG. Another.
Take an ECG.
Another USG.
You'll find worse cases. And most of us are on the verge of death probably then.
My lord.
If this is serious. And all the reports are normal.
The last abdominal pain and everything is there in the page 19.
What pain?
Abdominal pain, my lord. Abdominal pain, lower, upper abdominal.
Every day before recess, I have abdominal pain. And if the court continues after 3:30, I have more abdominal pain. A headache also. So, what is this? Page 19, immediately above the advice. This is your mother's prescription.
Oh no, this is a prescription.
Alcohol stopped 12 years ago.
This is the prescription of petition number, appellate number 1.
One was also in the hospital.
Fine.
You stopped alcohol 12 years ago and you are proud of that. You should have continued. Why did you stop? We will penalize you for that.
But in paragraph, my lord.
Your case is, in your application is that your mother was ill, right? So you have annexed a medical certificate of yourself.
Petitioner also, my lord.
What happened to the petition? Let us see. You're pleading on that?
No, my lord. I'm not.
Not pleaded.
This is not appellate number 1, my lord. It is not pleaded.
Yes. Thereafter, petitioner, no. Your illness is not stated, but your medical certificate is there.
Yes.
Fatty liver.
Fatty liver.
In addition to this, your lordship.
66. What is the worst disease that your mother suffered? We can't find anything actually. You please come to page 10, normal study, USG, normal study.
No diagnosis at all.
No diagnosis, not only that, diagnosis, whatever is there is normal. Calcium, brufen, pan 40.
Page 15 says proceed.
What sort of a...
Well, only medical certificate I have received, my lord.
You can't write a good story, you have become an advocate.
Well, they are taking up to July 2023. Thereafter, they.
I practiced story writing throughout my career as an advocate, and now I have started creative writing.
Well,
when you don't know the law, you write creatively.
Well, up to July 2023, my lord, there is a.
Give something better to us, please. We cannot allow this. Our conscience does not permit. Calcium.
If your lordship kindly sees page 7. Page 7.
Page 7, what is it?
Kindly see who is affirming the affidavit, Robindranath Sarkar.
Who is he?
Another son, not Dipankar Sarkar, whose affidavit is there, nor mother's. Therefore, my lord, if he was, and he says.
No, they say that they were looking after their mother.
They were looking after the matter, but kindly see, Robindranath Sarkar says that I am very well acquainted with the facts of the case. Therefore, either Kajol or Milord Dipankar was not acquainted with the facts of the case. He could have Milord come and filed the.
No, we don't understand you. Two can be acquainted of the facts that 1 and 3 were looking after the mother, 1 and 4.
Yes, but Milord, kindly see, Robindranath, I am the petitioner.
Robindranath is 2.
2.
So they say in their application 1, 2, and 4 were looking after 3, the mother. So 2 may be acquainted that 1 and 4 were also looking after the mother.
If Milord Robindranath Milord is filing, he could have filed it within time also. Because he says, I am.
No, he was looking after his mother. That's why he could not file. That is the ground here.
That is the ground.
There is no. We cannot allow everything. 266 days is not quite. I mean, valuable rights have accrued in their favor.
And my lord, 2 months, my lord, they took to take to Calcutta, come to Kolkata and ready for.
2 months to come to Calcutta from where?
My lord, up to July 2023, my lord.
2 months from Islampur to Calcutta, it takes 2 months.
Up to July 2023, my lord, there is a prescription. Thereafter, my lord, they take the.
There is no prescription. Sorry, we can't find a single prescription which says.
Dipankar's prescription is on June 2023, not July 2022. Degree is
admitted to hospital. Where is the regarding hospitalization? Where are the papers? Discharge certificate or anything of that sort? These are only you went to the outdoor and OPD patient cards. No, show us. We are interested to know where she was hospitalized. All are OPD patient cards. OPD, do you know the meaning of OPD?
Yes, my lord.
What is that?
Outpatient, my lord.
Outdoor patient department. So, when were you, admitted to the hospital? Ticket for outdoor patient. Page 16. All OPD patient cards. What is the hospitalization? You are guilty of perjury. You are guilty of perjury.
So this is the legible copies, my lord, they have served, my lord, to me.
These illegible copies have also become legible now. You have had an USG, which is normal. No, sorry. It's a credible dose. হ্যাঁ কয়েক মাস ঠিক আছে 166 বছরের কাছাকাছি আর একেবারে মিলছে না
Order passed, my lord, on July 27th, my lord. Thereafter, my lord.
The present application bearing can 1 of 2025 is an application for condonation of delay in preferring the appeal. First of the delay is of about 266 days, even as per the petitioners. First up, there is absolutely no explanation in the application as to what prevented the petitioner numbers 1, 2, and 4 from preferring the appeal in time. Full stop. The only ground cited is in paragraph 4, which says that the petitioner number 3, the mother of petitioner numbers 1, 2, and 4, a senior citizen and an elderly person, was admitted to the hospital and was suffering various within old age, disease, and under continuous government treatment up to July 2023, and the entire family was spending their time for such medical treatment. Full stop. Next para. However, from the annexures to the application, we find that only certain checkups were conducted in respect of petitioner number 3, that too at the outdoor patient department of a government hospital. Full stop. One ultrasonography report has been annexed, which shows that petition number 3 was normal. Full stop. Certain prescriptions indicate that regular, over-the-counter medicines were occasionally prescribed to the petitioner number 3, which relate to usual illnesses attending every human being. Full stop. Next para. We also do not find a single document to show that the petitioner number 3 was ever hospitalized or admitted in the hospital. Full stop. Next para. As such, there is absolute lack of parity between the annexures to the application and the pleadings made therein. Full stop. It is well settled that although the period of delay is by itself not important, the quality of the explanation offered is. Full stop. In the present case, we find that there is absolute dearth of plausible explanation for the huge delay of 266 days in preferring the appeal. Full stop. Next para. Accordingly, we are unable to accept the contention of the petitioners. Full stop. Hence, can 1 of 2025 is dismissed on contest without any orders to costs. Full stop. Consequentially, FAT 335 of 2023 is dismissed as time barred. Any other application is there?
No, my lord.
We did not file a stay application or anything else.
Already dismissed, my lord. It is dismissed. So there is no stay, my lord.
Next.
Item number 32.
For the respondent,
Yes.
Partition should.
My lord,
My
I am for
clients
the
are
petition.
plaintiffs.
You are the respondent.
I am the respondent here.
Your application.
One, my application, another, her application.
What is your application?
My application to PPR paperwork, my lord.
That we'll look into, and the other is stay.
Other is stay as
My lord,
required.
This against what?
I am praying for not to.
No time.
That's because senior
No time.
late for he was feeling unwell, my lord, and
You move the matter.
he has come, but my lord, he
You
left
move
for
the matter. What is the file? You are without a brief. You don't appear without a brief.
Senior counsel, my lord.
My lord, partition shoot in between
He
the
has come, but
3 brothers.
No, they have challenged a preliminary degree.
The preliminary.
We will pass the usual order. The Proceedings will continue, but no final degree will be drawn up.
That is passed, my lord.
That order is passed.
my lord.
But that was at an ad interim stage.
Yes, my lord. My lord, but his application is, my lord, because to stay this proceeding, that one Shopon, he was the defendant in the suit. He executed on will, and now they have filed the
Probate matter.
proceeding that is pending. My last occasion, the previous,
No. Can one was disposed of
that is disposed of.
with the direction to proceed,
Yes,
but
my
not pass any final degree? Another stay application.
Another application to stay this proceeding because probate proceeding is pending before this honorable court.
Oh, stay this if it first appeal.
My lord.
Yes, my lord.
My lord, but the my lord,
Anyway,
please-
they're asking for time. Let them have, because before we, I mean, the order may be adverse against them. So let her have a chance.
this appellant.
We'll just adjourn it for the day.
Yes,
And adjournment is sought on behalf of the appellant. Let the matter stand adjourned for the day. But tomorrow, ma'am, please come prepared. If your client, if your senior is not there, you have to move, or whoever has to move the matter. Probate application was filed after the passing of the trial court degree.
Already degree.
Item number 33.
We find from the order sheet that on July 8, 2025, the matter was adjourned on the prayer of the appellant. Full stop, next para. Thereafter, on August 4, 2025, when the matter was called on by a coordinate bench, the appellant was not represented, nor any accommodation was prayed for on behalf of the appellant. However, the coordinate bench directed the appellant to serve copy of the application for condonation of delay, along with a copy of the memorandum of appeal on the respondent by speed post with acknowledgement due within a week from that date. And in the event the respondent is not represented on the adjourned date in spite of service, the application for condonation of delay, it was observed, would be heard in the absence of the respondent. Full stop, the appellant was also directed to file an affidavit of service on the adjourned date. Full stop, the plaintiff was directed further to file a compilation of pleadings and documents filed before the learned trial judge upon prior service to the respondent. Full stop. However, even today, at the time of call, none appears to move the application. Full stop, next para. Accordingly, can 1 of 2025 is dismissed for default without any order as to cost, consequentially, FAT 422 of 2023 is dismissed as time barred, no order as to cost. Next.
Item number 34.
I appear for the appellant.
Yes. What is the matter, Mr. Kundu?
My lord, there are two applications.
Section 5 is still to be allowed.
Yes, section 5.
Appearing for the first time.
Lordship.
Then I will direct you to serve.
Lordship.
Will direct you to serve both the applications and the memo to Expedited.
And the memo also.
The appellant shall serve copies of both the applications bearing can 1 of 2024 and can 2 of 2024 along with a memorandum of the appeal on the respondent indicating that the applications shall be listed for hearing on November 17, 2025 when an affidavit of service shall be filed by the appellant.
Lordship.
Item number 35.
My lord, in item number 35, Advocate Mr. Milanundi appearing on behalf of the petitioners is sick, my lord. My lord, come to the court, my lord. Therefore, my lord, I'm praying for not today.
I am appearing for the respondent. Respondent small 1 and 2.
Till now it's 50-50. You prayed for adjournment once, they have prayed for adjournment once. So they get another chance. On 4th of August 2025, adjournment prayed for by the petitioner. On 19th of September 2025, on the prayer of the learned advocate for the respondents, the matter was adjourned for the day. Angshunath Chakravarti's name is recorded.
Change brief, Milad. Change brief, Milad. Yes.
So therefore 50-50.
I won't stand in the way.
So now the balance still in your favor. This is the last chance they get. An adjournment is sought on behalf of the appellant. Full stop, as a last chance to the appellant to move the applications. The matter is adjourned for the day. Tomorrow you have to move the matter, sir.
Grateful.
Don't be so grateful. You won't be so grateful tomorrow. Come prepared in the matter if your senior is not there.
My lord, my lord.
Give your appearance now. Only your appearance.
My lord.
Item number 36.
Yes.
Madam, for the review applicant, but I'm praying for not today.
No, no. You are sufficiently competent. Move them aside.
Respondents, your
My lord, the
lordships.
brief is with my learned senior, my lord.
Nothing doing. Nothing doing.
1 day of accommodation, my lord, only. Only 1 day of accommodation.
You have to tell us what the matter is about. Even if the brief is review. Adjourning for the day.
Grateful.
On the prayer of the petitioner, the matter is adjourned for the day. So it is made clear that in the event the petitioner does not move the matter on the next occasion when it is called out for hearing, the matter may be taken ex parte in the absence of the petitioner.
Item number 37.
My lord, in 37, I seek indulgence to appear online. In
Yes.
37, my
Yes.
lord, I am for the appellant. My lord, there was direction to serve some advocate, but his wakalatnama and address is not there. So may I serve the respondents opposite parties directly and come back after 4 weeks, or as
Yes.
it pleases lordship?
Yes, learned counsel for the petitioner submits that in view of the advocate for the respondents not being traceable, comma, the petitioners seek to serve copies of the application directly on the respondents. Full stop. Accordingly, the petitioners are directed to serve copies of Can 1 of 2024 directly on the respondents, indicating that the matter shall be listed next on November 24, 2025, when the petitioner
My
shall
lord.
file an affidavit of service to that effect.
My lord, can it be first week of December? Can it be?
Very well. Thale December 2nd, December 2, November 24, na December 2, 2025. 2nd December. Miss.
Deeply grateful, lordship.
Thank you. Thank you.
Okay.
Next.
I take leave.
For the response.
I'm
Yes.
suffering for the appellant, my lord. I am led by Mr. Orjit Bordhon, my lord.
Mr.
Orjit Bordhon.
You are sufficiently going. Move on. You are for the other side. Yes.
My lord, this is the last order, my lord. May I?
This is a stay application.
Yes, my lord. Application for appropriate order, my lord.
Last order we have. Fero didi. Dipankar. Ferot. Yes.
This is my affidavit of service, my lord.
Impugned order was passed on erroneous interpretation of section 42. What is the matter about? Arbitration একটা দাও দীপঙ্কর arbitration ওইদিকে চলে গেছে ওখানে কি রাখা রয়েছে কেন ওখানে একটা arbitration একটা রাখা রয়েছে এখানে নেই তো আরো এক্সট্রা কপি
I am for the plaintiff appellant, my lord. Suit for my lord.
এইখানেই ছিল তো সামনে arbitration একটা পাশে ছিল লাল বই ওখানে একটা আছে
Yes. And suit for my lord, declaration, partition, and dissolution of partnership, my lord.
Yes.
May I read the ordering portion, my lord?
Yes. Ordering portion of the impugned decree? Yes.
Judgment, my lord.
Your suit?
Yes, my lord. And the internal page, my lord, 9, my lord.
ওনারটা আমারটা ওইখানে রাখা রয়েছে ওখানে কে রাখলো ওকে ডাকো আদালকে ডেকে আনো ওইটা Yes, what about this? Section 7 Principal Civil Code of this was an application under what provision? Before the trial court, it was under which provision? It was a regular suit.
Yes, my lord. Suit for partition, declaration, and dissolution of partnership.
Yes.
Suit was dismissed, my lord, on the ground of, my lord, jurisdiction point, my lord.
Why doesn't the court have jurisdiction according to the trial judge?
I am reading, my lord. Page 9, my lord, internal page 9 of the judgment.
Page 9, yes.
At this stage of discussion, no, before that, my lord, in this agreement, also it has been specifically mentioned that it will also be a partnership at will, and no specific date has also been mentioned for its termination. Fascinate.
Yes. No specific date for termination. Yes.
Fascinating to note that the above mentioned point number 17 regarding the referring the matter to the arbitration has been virtually reproduced in the partnership deed of Messrs. Mondal Stores. At this stage of discussion, I feel it is pertinent to mention section 7 of the Arbitration and Conciliation 1996. According to subsection 1 thereof, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship
There was a previous application under section 9 or something before
No,
any
no.
other. What sort of a judgment is this?
Only there is a partnership agreement, my lord, and there is a clause.
It's an arbitration clause, maybe an arbitration clause. They did not file any section 8.
No.
George. What sort of a judgment is this? You set aside it right now. In view of the short conspectus involved, comma, we take up the appeal itself for hearing. Full stop, next para. By the impugned judgment and decree, comma, a suit filed by the plaintiff stroke appellant inter alia for declaration, comma, partition and dissolution of a partnership firm, a dissolution of a partnership was dismissed on the ground that the same was barred under the Arbitration and Conciliation Act 1996. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find that the impugned judgment is not only based on absurd logic, but is palpably dehorates the law. Full stop. The learned trial judge proceeded on the premise that since there was an arbitration clause in the partition deed between the parties, comma, the provisions of section 42 of the 1996 Act apply, and in view of the same, comma, the suit is not maintainable before the civil court in its present form. Full stop. Next para. We are at an utter loss as to how the learned trial judge could come to such findings. Full stop. The learned trial judge referred to section 42 of the 1996 Act, which is on an entirely different footing than that construed by the learned trial judge. Full stop. Section 42 pertains squarely to applications coming within the purview of the 1996 Act and stipulates that where, comma, with respect to an arbitration agreement, comma, any application under the concerned part of the 1996 Act has been made in a court, comma, that court alone shall have jurisdiction over the arbitral proceedings, and all subsequent applications arising out of that agreement and the arbitral proceedings shall be made in that court and in no other court. Full stop. It is nobody's case that any previous application under the 1996 Act was filed before any other court, comma, nor was the suit, comma, which has been dismissed by the impugned judgment, comma, was an application under the 1996 Act. Full stop. Next para. Furthermore, comma, there was no application filed under section 8 of the 1996 Act by the defendants. Full stop. It is well settled that the arbitrability of a dispute between the parties, comma, being based on consent, comma, it is open to the parties to waive the said arbitrability and choose to subject to the jurisdiction of a civil court. Full stop. In the absence of a specific application under section 8 of the 1996 Act, comma, there is no scope for the civil court to relegate a matter to arbitration. Full stop. Next para. We find from a cursory perusal of the impugned judgment that the same proceeded on an entirely erroneous and tangential premise by treating the suit to be not maintainable in view of the application of sections 7 and 42 of the 1996 Act, which are not applicable in any manner of imagination to the present suit. Full stop. Thus, comma, the impugned judgment and decree are patently erroneous and ought to be set aside. Full stop. Accordingly, FAT 153 of 2025 is allowed on contest, comma, thereby setting aside the judgment and decree dated
23rd December.
December 23, 2024, passed by the learned civil judge, senior division at First Court at Uluberia, District Howrah, in title suit number 122 of 2017. full stop, uh, full stop na, and remanding the matter to the learned trial judge for a fresh adjudication in accordance with law on merits in the light of the observations made above. Full stop. It is, however, made clear that this court has not entered into the merits of the respective contentions of the parties in the suit, and the learned trial judge shall proceed with the hearing of the suit in due process of law by framing issues and giving opportunity of hearing to both sides. No order as to cost. Any application is there? Can 1 of 2025 is still pending? Yes. Can 1 of 2025 stands disposed of accordingly? It a judgment form hobe ye. What did you tell your client after this matter came to you?
Kindly fix a time.
But not only section 42, section
42 section
7 and thereafter section 2E1.
2E, yes, we forgot to mention that.
The definition of court.
Time limit, we are not very confident that we get justice if we frame a time limit and it is hard by this court.
Difficult.
Better no time limit.
Well,
Yes.
I'm getting to it.
Thank you.
Item number 39.
In item number 39, I am appearing for the appellate lordship.
Yes.
I am led by Mr. Ron Banerjee lordship. Due to his personal difficulty, he has to left court today. I am praying for only not today, lordship.
No, you have a brief. Without brief, no adjournment is being granted today.
I have the brief.
Bring out the brief. Why are you hiding that? What is the matter about?
The matter is that, lordship, we have challenged initially the learned trial court granted the decree of divorce. We have appealed that order before this honorable.
You are the
court.
wife.
I am the wife, lordship.
You are challenging the divorce decree.
I am challenging the divorce decree, lordship. I have filed an application.
One for stay, one for maintenance must be.
The stay application has been disposed of by your lordships.
All right. Now
And
maintenance.
The maintenance application is pending. On the last occasion, your lordship has directed
Yes.
to service through the workplace of the respondent of the opposite.
You are
party,
appealing for the
lordship.
respondent.
My
May
lord, Nirendra Narayan Rai is
May I
appearing
just file the
for the
affidavit of
respondent.
service?
So what?
My lord, I have just asked for, to pray for adjournment, my lord.
No, Nirendra Rai's name does not have a magic in this court. Why is he not here? Did you direct you to file affidavit of assets?
No, lordship.
You have to file affidavit of assets now as per the Rajneesh versus Neha judgment. We direct you to do that.
The lordship grants us a week's time. We shall file.
Within a week you can file your.
Within a
Very
week
well. Can 2 of 2025 is an application for alimony filed by the appellant wife in connection with an appeal against a divorce decree obtained by the respondent husband. Push up next para. In terms of the judgment of Rajneesh versus Neha, affidavits of assets have to be filed by the parties in connection with such applications. Accordingly, we direct the appellant to file her affidavit of assets within a week from date and serve a copy thereof on the learned advocate for the respondent. Next para. The respondent shall file his affidavit in his composite affidavit in opposition to the alimony application as well as the affidavit of asset of the appellant wife within 3 weeks thereafter. The respondent shall also file his own affidavit of assets along with the same. Advance copies of the affidavit of asset as well as the affidavit in opposition of the respondent husband shall be served on the learned advocate for the petitioner. The petitioner shall file her composite affidavit in reply thereto within a week thereafter. The matter shall be listed next in the monthly list of December 2025.
Lordship, may I just seek only one indulgence of your lordship?
Yes.
In the application, although I have pleaded one order and one website copy, although the Excel sheet has been attached, the way it has been obtained, that has not been attached. May I just come back with a supplementary affidavit annexing only these 2 documents? One is an order of the land.
Should have said that at the outset. Prothom line ekটু এক করে দাও তো প্রথম line. On the prayer of the petitioner is granted leave to file a supplementary affidavit to can 2 of 2024 or 5?
25, Lord.
2025. A copy thereof shall be served on the learned advocate for the respondent. আর তারপরে যেখানে affidavit in opposition বলেছি একটা জায়গা থেকে composite affidavit in opposition to the সেখানে composite affidavit in opposition to the uh, alimony application as well as the affidavit of asset of the appellant wife and the supplementary affidavit of the appellant. মানে অপোজিশনটা হবে কম্পোজিট অপোজিশনটা হবে টু ওর অ্যালিমনি অ্যাপ্লিকেশন প্লাস অ্যাফিডেভিট অফ অ্যাসেট প্লাস সাপ্লিমেন্টারি অ্যাফিডেভিট পুরোটার কম্পোজিট অ্যাফিডেভিট হবে থ্যাংক ইউ
Great.
ইয়েস
Item number 40.
Lordship, in item number 40, I am appearing for the opposite party, Lordship. In this matter, your Lordship has grant the petitioners an interim order till disposal of the can application.
till when
Till disposal of the can applications, Lordship. Initially,
we'll give them a last chance none appears for the
Your Lordship, may I just indicate
Yes.
the first order passed by Honorable
Justice Sen, yes.
Justice Sen.
Oh, not represented, we may vacate the interim order and dismiss the appeal.
In the second last order, Lordship, on 21st of August, the similar order has been passed, Lordship. Yet there is any representation
21st of August order is not with us 21st of August order কি হলো
passed by Honorable
হঠাৎ
Justice
মাঝখান থেকে অর্ডার মিসিং হয়ে যাচ্ছে কেন 21st of
Honorable Lordship.
no we have to find it 21st of August order. কপি ঢোকাইনি তাহলে দেখো আগে পিছে দেখো থাকবে কোথাও 21st of August
21st of August 2025, Lordship. May I?
yes give a copy
Kindly pardon me, I have only one copy, Lordship.
no you are not supposed to we are supposed to have that order
Paragraph number
নেই
4.
আপনার ওটার কপি আছে 21st August এ there is no copy in any of the files of the order this is a server copy
Lordship, I have obtained it from the server, Lordship.
server copy তুই ওটা দিচ্ছি we'll keep this on record then you take out fresh server copies for your use
Lordship.
none appears for the appellant at the time of call Full-stop. Learned counsel for the respondents points out that by a previous order dated August 21 2025 comma a coordinate bench had recorded that none appeared on behalf of the appellant even on second call and that in the event the appellant was not represented on the next date of hearing it shall be presumed that the appellant is not interested to proceed with the matter. Full-stop. Subsequently, when the matter was next called on for hearing before the said bench on September 16 2025 comma again the appellant was not represented nor any accommodation was paid for on behalf of the appellant although the respondent was represented. Full-stop. The learned coordinate bench recorded that in the event the appellant is not represented on the adjourned date the bench may vacate the interim order and dismiss the appeal. Full-stop. Since even today comma none appears to move the application comma which is the application for stay
Lordship, interim order was passed in can application 4.
4 is the stay application what is can 5
Lordship, the both are not an application. This is both are the applications of injunction, Lordship. Both are injunction application. Can 4 and can 5.
এই তো তলা রয়েছে অর্ডার কি ফাইল খুঁজলেন রয়েছে তো অর্ডার দীপঙ্কর কোথায় দেখছো আমি তো পাচ্ছি তোমরা পাচ্ছ না কেন তাহলে আমি তো পাচ্ছি what was the interim order passed
Not to alienate the suit property and not to create any third party.
Very well.
interest.
accordingly comma in deference to the order passed by the coordinate bench on September 16 2025 comma we vacate the interim order granted earlier. Full-stop. We are not dismissing the appeal. We're just vacating the interim order.
As your
Vacate the interim order. Full stop. Let the matter go out of the list for the present. We are vacating the interim order and letting it go out of the list. We are not dismissing the appeal or the applications for default.
Great.
Let them come back with some application and we'll then.
Now, your lordship is taking the compilation on record, lordship.
কম্পাইলেশনটা আছে ওর যে দিল এক্ষুনি ওটা ফেরত দিয়েছে উই হ্যাভ দ্যাট অর্ডার অর্ডারগুলো একটু অ্যারেঞ্জ করে রেখে দিতে পরে
I'm grateful.
হ্যাঁ ইনজাংশন দিয়েছিল দিনের পর দিন আসছে না ইনজাংশনটা এনজয় করে জাস্টিস
Number 41.
41, Lordship, I am for the appellant wife, Lordship.
I am for the
Decree of divorce was passed by the court below.
There is a
That
delay
was-
of 279 days.
I have filed
Wait,
section,
move their
I already filed one section 5 application before your lordship. There is 279 days delay. That the paragraph number 3, 4 and 5 is the.
I would like to file my opposition.
opposition refused section 5 opposition
279 days delay, my lord.
let us see the
That the
ground
wife, Lordship. Before your lordship, the wife. Before
what is
your
the ground for delay
That the grounds for delay, the minor child for the football is the.
Nothing has been
Playing
annexed.
football, he was outside the, there is the match for the football, that's the participation is the long term. Kindly also consider paragraph number 4, thereafter the health issues also given lordship before, and the ex-party order was.
patient
by
with a minor son in Darjeeling for several professional football training but the camps don't permit the mothers to stay back
But the
Nothing
minor
has been
child
annexed.
cannot be stayed alone lordship, that's the issue, that's why he was supported by his
what is the age of the child you have not disclosed that
only 11, 12 years,
12 years child in
11.
football camp no
11, 12 years lordship.
let them file their
And
operation
kindly lordship consider that that is the situation lordship that they.
almost
may-
1 year you are engaged with your son's football training he's 12 years old
Contested the suit, my lord. She
No,
contested the suit. She filed written statement, she contested the suit.
But cross
yes but then the football training was not going on
Then the football training was not.
cross
no
examination.
that is the ground
My lord, that is
that
the,
may be a valid ground also
but my lord, what has happened, my lord, nothing has been annexed with the
Annex
section 5
something
application.
regarding those
Nothing has been annexed.
football training and all
I have,
with a picture of your son playing
Second
football
vote also took place, my lord.
yes, lordship.
and if necessary we'll call your son and see him take a shot
Yes, lordship.
which is directed at you no but there must be something annexed
Then also
Mr. Chatterjee is the architect of this what football training
we are both appearing before your lordship.
both of you take responsibility something has to be there on record professional football training at what level international and they allow the mothers to stay in the camp with the child for 1 year
No, not
no
for-
child will the child will leave football if the mother stays 12-year-old son's mother stays with him for 1 year in football he'll leave football
that the cross examination was not taken into consideration lordship, that
He has engaged some
on the
advocate
prayer
also,
of
my lord.
on the prayer of the respondent is granted leave to file affidavit in opposition to the file to both the applications together to the applications within a fortnight from date reply if any shall be filed within a week thereafter the applications shall be listed for hearing on November 24th 2025
No, instead of November, can it be November 25?
fortnight's time what opposition you don't know anything
My lord, 24, my lord. I have a medical difficulty, my lord. That is why, my lord.
more than 2 weeks
In my family, my lord, there is a scheduled one operation to be held on 20.
no we understand but one you write it tonight
No, my lord. On 24th, my lord, when the
oh
matter is
24th
Yes,
there is a
yes,
yes,
yes, yes.
26th thale.
26.
26
Yes.
Returnable date is 26
Great.
but we have indicated to you you have not used any supplementary affidavit so we will not permit you later on
Grateful.
then I am praying.
then means
I am praying for
what will you annex you don't have any papers
She will prepare, my lord. Now
I
she
have to
prepare
enclose
the
the
document.
documents lordship. I have to enclose. I am only the football certificate and others he was played before the supplementary affidavit to be allowed.
আচ্ছা
In the meantime,
ইয়ে করে দাও ওটা 2 weeks fortnightটা 3 weeks করে দাও আর
or 1 week.
উইদিন রিপ্লাইটা যা আছে তাই থাক আর রিটার্নেবল ডেটটা তাহলে ডিসেম্বর 2 2025 ডিসেম্বর 2 আর প্রথম লাইন একটা করে দাও অন দি প্রেয়ার অফ দ্য পিটিশনার the petitioner is permitted to file a supplementary affidavit to can what is the section 5 application can
Not
just check up section 5 Dipankar কোনটা
no number. In my file, no number is mentioned, my lord.
Can one.
can 1 to can 1 of 2025
Get
and serve a copy thereof on the learned advocate for the respondent.
Grateful.
Thank you.
Item number 42.
আজকে অদ্ভুত অদ্ভুত সব রাউন্ড আসছে। উড়িয়ে দিই, আগে উড়িয়ে দিই। প্রথম দিনই উড়িয়ে দিই। ঠিক তো, এইসব দিয়ে পুরো লিস্টটা ভরে রেখে দিই। Yes, item 42 দেখেছেন? 42. None appears for the parties at the time of call. আগের দিন দেখি। We find from the order dated September 10, 2025, that adjournment was sought on behalf of the appellant on the ground that the appellant wanted to engage another learned advocate. Full stop, next para. On September 17, 2025, comma, when the matter next came up before the coordinate bench, comma, the appellant was not represented. Full stop, the court directed an administrative notice to be served upon the appellant. Full stop. We find from the office report dated September 23, 2025, that as per the track consignment report of India Post, comma, the postal article was returned to the sender. Full stop. Moreover, comma, no wakalatnama has been filed by the representative of the sole respondent till date. Full stop. Next para. Thus, comma, since the administrative notice which was issued on the appellant at the address given by the appellant herself in the cause title of the memorandum of the appeal and her injunction application, comma, there is no scope of service of any further notice on the appellant. Full stop. Since the appellant is evidently not interested to proceed further with the matter, comma, FET Can 1 of 2025. Now, FAT 236 of 2025, along with Can 1 of 2025, are dismissed for default without any orders to cost. Interim order, if any, stands vacated. প্রথম দিন উকিল দাঁড়িয়ে বললে যে অন্য উকিল দেবে, অ্যাপেলেন্টের উপরই অ্যাডমিনিস্ট্রেটিভ নোটিশ ইস্যু হয়েছে, সেটা ফেরত এসছে রিটার্ন টু সেন্ডার ওর নিজের অ্যাড্রেস। আর কি করবে কোর্ট? সৌমেন্দ্র অনেক ভদ্রগুলো অ্যাডমিনিস্ট্রেটিভ নোটিশ ইস্যু করেছে।
Item number 43.
My lord, this is, I appear for respondent 1, Core 2 J.
Very well.
My lord, this is my application for.
Yes, sir. Restoration within time.
Within time. And this is the affidavit of service. Lord, my Can 1 was dismissed for default.
Oh, section 5 was dismissed for default. Excellent. সত্যজিৎ সবসময় একটা ফালতু ম্যাটার নয়। Anyway, what is your ground for not being present on that date?
Lord, actually, my lord, I was engaged in another court and the advocate.
Is it a good ground under order 17? And we are allowing this recollection.
No, only thing is it involves very short question and the appeal may be decided also.
But will you just allow the restoration first? In view of sufficient explanation for the absence of the appellant on the relevant date having been appellants on the relevant date having been made out, Can 3 of 2025 is allowed, comma, thereby recalling the order dated September 10, 2025 and restoring FAT 242 of 2025 along with Can 1 of 2025 and Can 2 of 2025 to their original file and number. What is the appeal about? There is a section 5, but
Yes, there is a section 5, my lord.
are you opposing the section 5?
I am.
But
There is a delay of 400 days.
Oh.
Lord, no, this is already, my lord, recorded in the order sheet, my lord. There is a, that is, my lord, SR report is there, my lord. There is a delay of 382 days.
382.
Not 400, 382. 382 days.
382.
Yes.
He says 400 something, you say 382, and you are so vociferous about it. What is the reason for the delay?
Reason is this, my lord, the appellant was incapable, my lord, as because of
Looking after his mother. Or
Yes.
now, father, they bring some variety.
My lord,
We are
no.
hearing looking after mothers and professional training of children and all these things. So bring some variety, otherwise your application is dismissed.
My lord, she was ill, my lord. That was
Use the microphone, Mr. Sene. You are very loud otherwise.
my lord. She was not well, my lord. That will be revealing from the prescriptions and medical records, my lord, which is starting from page 21 onwards, being annexed.
382 days, what sort of, more than 1 year, what sort of illness?
And Lordship, 4 appellants.
My lord, there is a
4 appellants. I find
there is a surgery, my lord.
All the 4 appellants?
only one appellant number 2.
There is only single appellant, my lord. That is deponent, my lord, who has signed this affidavit.
Naturally, you have signed because you had an alibi.
Yes, my lord. This
Yes. Sir.
Kartik Narayan Deo is my lord was.
What about the others? Why didn't they make the application, file the appeal? Only one person's explanation is given. That is not sufficient, Mr.
Lord, still, my lord, others are.
Others are what? What happened to you? Everything appears to be normal from page 27. Your whole abdomen is normal. This is a CT scan of whole abdomen.
Yes, yes.
See, nothing is dilated. Everything, urinary bladder normal, stomach normal shape and
Yes,
size.
That was.
It is in fact above average. Everything is normal.
That is found after 16th August 2024, my lord.
So what happened to you? Acha, fracture of right side of bony pelvis.
Yes.
So that happened on 17th of August.
17th August 2024. And
When
my
was
lord,
the decree passed?
decree passed on, my lord, that is,
22nd day of
22nd December 2022. What happened in between?
my lord, my lord, kindly have a look to the certified copy was applied on 23rd December 2022 and it was delivered on 7th February 2024 from the registry of the court below.
Oh. Let us see.
That is Annexure A, page 7 of my application for condonation of delay.
Tweeted out. Tweeted out. Subject গন্ডগোল আছে 22nd December. You managed it so that it is 2 years, no notified,
No, my lord,
no requisites are notified. Acha, 7/2/2024. From then on, you have given explanation. Let us see that explanation. And when do you file the appeal? 2025.
yes, and till August, 17th August 2024, I was under treatment. Till 16th August 2024, I was under
From when?
treatment.
From when? Because your limitation expired approximately in
90
May.
days limitation,
May.
May. And my lord,
From May, what happened? The first part of May, before May, it has to be.
my lord, his
Now there is a judgment of the Supreme Court. The entire period has to be explained, including the period when you were within limitation. But we are not choosing not to look into that. Don't cite that before us.
my lord,
Everyone will be gone then.
26th August, I was I was treated under the Jharkhand Government Medical College.
You are in Jharkhand. You are treated in Jharkhand. We understand in August. In May, your limitation expired. What were you doing from May to August? These 3 months. You have to give some explanation. Day to day, we are not wanting.
Lordship, another thing is, if my lord takes page 6 of the application, the affidavit has been affirmed by one Kartik Narayan Deo.
He could have.
Lordship, Dibakar Narayan Deo's prescriptions have been provided.
No, Mr. Sinha. Kartik Narayan affirms. What was he doing for all this time? No, but explanation is required only from February 2024. Because before that, he was getting that certificate.
Lordship.
And it is filed in June 2025.
Lordship.
My lord, the Kartik Narayan Deo is the power of attorney holder of the Shankar Narayan Deo. This is the general power of attorney, my lord.
So both of them are not Dibakar.
And
he filed in May 2025, 1 year after the limitation period. Clear 1 year after the limitation expired. There is no explanation, Mr. Sinha.
my lord,
What, my lord? I won't give the explanation.
I'm not on that, my lord. Actually,
We are on that. What is the explanation for this 1 year?
Till 16th August 2024, he was, the appellant was under treatment. And thereafter, my lord, the file has come, file has been sent by the, I have said so, file has been sent by the learned advocate of the court below to the present advocate on record. In or about November 2024, appellant, my lord, kindly come to the paragraph 4. In or about November 2024, appellants were able to contract Orghoraj Basu, the advocate of this honorable court, and have conference with the senior and cause further
No,
delay.
there is no explanation from May 2024. Not a single line.
My lord,
Not a single line. Your limitation expired as per your calculation from your certified copy in May 2024.
because the illness was, it was continuing. from-
Illness was retrospective. Retrospective illness. You fell ill in August with retrospective effect.
Lord, then I'm
And
praying
not
for-
even illness, your femur, your something pelvic girdle was probably fractured.
to take necessary instruction from the client and you-
No, you will take the instruction about what to do with the file after we pass the order.
No, my lord.
No.
My lord,
There is no.
my lord, on the ground of limitation, my lord, if the
Yes, on the ground of limitation, this appeal will be dismissed.
my lord,
If you are not clear on that. On the ground of limitation, this appeal will be dismissed.
give me a chance, my lord.
No, Mr. Sinha.
My lord, actually, kindly have a look, my lord, because this file has come from the Jhargram, my lord, and this was sent in the November 2024, and the appeal was filed.
We are not blaming you for that.
Appeal
Whenever the
was
file,
filed on 10th June 2025 because of this delay.
because this 1 year, 6 months, 8 months, what you are doing?
My lord,
No.
my lord, furthermore, my lord, this is the date of delivery date of making ready over this application on 7th February 2024. Actual date of received is not known to the present advocate on record. It is known to the particular advocate on record who is conducting the matter, my lord.
Maybe.
And there is my lord, if
Advocate and record has nothing to do with it. It is the client's fault.
my lord, if this appeal is being dismissed, my lord, my valuable rights will be curtailed, my lord.
Yes.
My lord,
Precisely.
precisely. My lord, I'm
It will be curtailed.
yes, my lord. Kindly, at least, my lord, the merit of the appeal could have been considered, my lord.
We cannot do that now.
My lord,
We cannot do that now.
otherwise, my lord, kindly give me a chance to get the certain explanation, my lord.
No,
Otherwise,
what explanation you will give?
my
Nothing.
lord, I will call the client and take the necessary instructions, my lord,
No,
on
no,
this.
no.
My lord, otherwise, my appeal will be, my lord, my lord, this is a partition suit, my lord, and the quantum of land has been which
Should
has
have come within reasonable time. The judgment was passed long back. No.
my lord, my lord, this is a partition suit, and my lord, the decree was passed curtailing the quantum of land, my lord. And if the
It's a continuing cause of no, this is against preliminary degree. A degree has been passed.
preliminary
So
decree,
now, no. Rights have their rights have crystallized.
my lord, kindly,
No. The appeal has been filed
my lord,
with a
kindly,
delay of about 382 days.
my lord, kindly
Which
give
of next para we find from the application for condonation of delay that there is no explanation given for a substantial period of the delay. Push up, the impugned judgment was passed on December 22, 2022. Push up, the certified copy was applied for duly on the very next date, that is on December 23,
yes,
2022.
that means the
Oh,
applicant
2022.
was intending
Push
to
up,
prefer an
the
appeal.
date of notifying the requisite stamps was February 3, 2024, which were deposited on February 5, 2024, and the certified copies were made ready for delivery on February 6, 2024. Full stop, next para, thus, comma, from the certified copy of the impugned judgment annexed to the memorandum, we find that the limitation period for filing the appeal expired in the early part of the month of May 2024, whereas the appeal has been presented before this court only on May 23, 2025. That is more than 1 year after the expiry of the limitation period. Full stop. The ground fund sought to be furnished in the condonation application is the fracture of a bone and consequential treatment of one of the petitioners in the month of August 2024. Full stop. Next para. However, comma, we do not find from the four corners of the application any explanation as to why the other four petitioners could not prefer the appeal in time. Full stop. Next para. Even with regard to the petitioner who had suffered from the fracture, comma, there is no explanation whatsoever for a substantial period between May 2024 and August 2024, and thereafter from November 2024 till the filing of the appeal in May 2025. Full stop. It is well settled that the quality of the explanation is germane for consideration of applications for condonation of delay in preferring appeals, although the period of time elapsed may not be so important. Full stop. Even going by such principle, comma, we do not find any explanation whatever for the substantial period of the delay in preferring the appeal. Full stop. Accordingly, can 1 of 2025 is dismissed on contest without any orders to cost. Full stop. Consequentially, FAT 242 of 2025 and can 2 of 2025, FAT 242 of 2025 is dismissed as time barred. Full stop. Can 2 of 2025, comma, as a result, comma, also stands disposed of without any orders to cost. Thank you. Next.
Item number 44.
এই যেগুলো দুটো হয়েছে আজকে সকাল থেকে, আরেকটা কে নিয়েছে মনে নেই। Yes.
This is my application, Madam. The appellate.
Yes.
By an order dated 18th of.
Nobody is appealing for the other side. This is for the first time.
No, this is not for the first time, Madam. There was an order passed by my lord. If my lord takes up the orders, order dated 28th of April 2025. Thereafter, my lord's order is that 7th of May 2025, wherein my lord, my lord's order dated 28th of August, 28th of May 2025. My lord, they were avoiding the service and the notice of eviction was passed, my lord. If my lord takes up the order of 20th of May 2025.
20th of May, yes.
Yes, my lord. If my lord takes up the last page number 5 of the order, my lord's order.
Delay was condoned?
Delay was condoned. The last portion, my lord, paragraph number 19, the appellant shall put in the postal cost and requisites of service of notice of appeal. Everything has been done. Thereafter, the order.
You're for the appellants?
I'm for the appellant, my lord. And thereafter, an eviction suit was filed, my lord, by the respondents hearing.
Eviction suit was decreed against you?
No, not eviction. This is an appeal against the grant of probate, my lord.
Oh.
The grant of probate. After the beneficiaries to the will, the probate was granted in favor of the respondent, my lord. He had preferred the eviction suit for recovery of cash possession. I had filed an application for stay, my lord. Justice Sen, my lord, the order dated has granted a stay. My lord, 18th of September 2025, my lord.
Stay of the eviction suit?
Stay of the eviction suit, my lord.
In connection with the probate appeal?
My lord, it's a suit for recovery of, if my lord takes up my scan application, my lord, once.
No, you're enjoying that stay?
My lord, enjoying the stay, my lord, it was for, my lord, if the order, the department shall also file report and learned counsel appearing on behalf of the appellant placed before us the notice of the City Civil Court, wherefrom it appears that the learned judge has fixed the matter on 28th of September 2025 for appearance. We had appeared in the matter. The appellant shall enter appearance on the date fixed without prejudice to the rights and contents, but no further proceedings shall take place without the leave of this court. This was the order passed by Justice Sen.
Because the eviction suit is based on the probate.
Based on the probate for recovery of cash possession. If my lord takes up can 5 once, the annexures.
So what are we hearing today? What is pending now?
My lord, this stay should be made absolute, my lord.
Can 5?
Can 5. Can 5.
What about service on them?
My lord, service, my lord's order is there, my lord. If my lord takes up,
No, pursuant to our order, you have filed an affidavit of service.
yes, affidavit of service was filed.
Was filed previously.
Yes, filed before Justice Sen. And before my lord also, the affidavit of service was filed. If
So
my-
why didn't we grant stay till disposal?
Till disposal of the appeal.
Why wasn't it granted?
My lord, since it was moved on that day and the next date was fixed on 22nd, we had moved the application on 18th.
When did Justice Shen's bench grant that stay?
My lord, 18th of September 2025.
Acha, so you want this order to be made absolute. No further proceedings shall take place without the leave of the court. You want this to be made absolute?
Yes.
No. In which order did you record that section can 5 you have already served?
My lord.
There is no order recording that.
My lord's order.
Yes.
If my lord order is dated 27th of May 2025 is there, my lord.
7th of May 25?
My lord.
That was on can 1, 2, 3.
Can 1,
Can
2,
5 had not been filed.
No, can 5 was not there. Hence we construe that the respondent is deliberately avoiding service and take up the application hearing.
Till then you have to attempt to serve
My
at
lord,
least.
I have served, but the affidavit of service is not there, my lord.
You have to file affidavit of service regarding can 5. There is no direction for service. You don't find anything. Justice Shen's order was the first order.
First order.
So we'll direct you to serve. The petitioner shall serve a copy of can 5 of 2025 on the respondent and shall file an affidavit of service to that effect on the returnable date. Full stop. Let the matter stand adjourned till November 17, 2025, when it will be listed next under the same heading. The interim order granted earlier shall continue till the interim order dated September 18, 2025 granted earlier shall continue till disposal of the application.
Item number 45.
Yes.
Can 1 is an application, my lord, and for condonation of delay, there has been a delay of 519 days.
You are looking after whom?
No, my lord, I am placing, my lord, the appeal itself because the merit of section 5 and merit of appeal, my lord, are the same.
I have to object, Your Lordship. I am for the response.
Yes.
Yeah, for the response.
Let me, my lord, kindly see, my lord, the memorandum of appeal, my lord.
Oh, expiry degree.
Expiry degree. Expiry degree.
Your Lordship, they have already filed one Order 9 and Rule 13 before the district court, and the delays of 519 days. They
have filed on Rule 13.
Yes.
Yes, they have filed Order.
And so what happened to that?
No, pending.
That is pending, Your Lordship.
Subsequent to filing of this appeal.
Your Lordship, the delays of initially the delays of 519 days. It is from their petition, Your Lordship, that they have came to know about the matter on 23rd of September 2024.
Did you direct you to file opposition to this?
No. This
We are directing to file opposition, disclose everything there.
My lord, only one thing, well, let me place, my lord. Thereafter, if your lordship so directs, my lord, I will be, my lord, let them file opposition. After
Opposition
that.
they have.
Yes, my lord, kindly, my lord. let me
500
place-
something days delay.
Yes, from the records, I will show, my lord, this has to be set aside on the face of it, from the records. I'll not go
Your
beyond
Lordship,
that.
the
Yes,
limitation has to be heard out first.
yes, I'm on the
Clear,
limitation.
on the limitation.
Kindly takes up the memorandum of appeal. Memorandum of appeal.
Yes, memorandum.
Yes, may I kindly see, my lord, the order number 2. That's why, my lord, I have annexed all the order sheets. My lord, kindly see order number 2.
Yes.
Kindly see 29th May 2023. My lord, it was transferred from the court of the learned district judge to FTC 2. Then, my lord, kindly see the next order.
Yes.
Order number 3, very important. Kindly see.
You are the wife or the husband?
I'm the wife.
Wife.
Even when, my lord, the child was born, the husband is both the parties are together.
That's your allegation.
Still,
She's
it was not in.
She's vehemently nodding her head. Yes.
Kindly see, my lord, order number 3 kindly marks the date 17th July 2023.
Yes.
Today is fixed for filing fresh steps by the petitioner. Hajira along with original postal receipt has been filed today on behalf of the petitioner is received is kept on record. Therefore, sometimes in between, my lord, from 29th May 2023 or and 17 July 2023, SR was served and it has returned back. Then, my lord, kindly see, my lord, on order number 4, my lord, kindly see the last time PO was absent and it 18/9/2023 was fixed for SR and AD. Then, my lord, kindly see, my lord, another very important order, order number 5. Today is fixed for SR and AD. Hajira has been.
SR/AD must be, it was directly served both ways, probably the one of the.
I'll show, my lord, how fraud was committed. My lord, kindly see, my lord, Hajira has been filed today on behalf of the petitioner. One AD is received along with sealed envelope with a postal remark unclaimed. Therefore, unclaimed. I have not received this summons. I have refused summons, or I have not refused to accept summons. Upon perusal of the case, it appears that SR through the court process is lying on case record.
That was the previous one.
Wherefrom it appears that the addressee has refused to sign on it. Milord, the SR Milord has given. I'll also place the report of the SR. Milord, this is how, and ultimately on 16th October, order number 7, October 2023, Milord, an ex parte judgment was passed. Milord, saying that since uncontroverted evidence, husband has proved his case, I am granting a decree for divorce. Therefore, Milord, 3 dates, Milord, are very relevant in this case. One is, Milord, 29th May 2023, 17th July 2023, and 19th September 2023. Order number, Milord, 2, 3, and 5. Now, Milord, kindly takes up, Milord, first. Yes, kindly comes to, Milord, page 46. This is, Milord, they say, Milord, the section 5 of the Can 1, Milord, Can 1, page 46 of Can 1, annexure G. This is the summons which the process server has, Milord, gone. He shouted by my name. I came out from my house and I refused to sign.
He says he has shouted it.
Yes, kindly see, Milord, page 49, the report. Kindly see page 49. Nivedon AJ, Oddo, kindly marks 24/6/2023.
Between that period.
Between that period. 24/6/2023. I'm coming, Tarike, Diva অনুমান একটার সময় পরোয়ানা লিখিত শিক্ষিত শাকিনে আসিয়া নিজ সন্ধানে ও স্থানীয় লোকজনদের দ্বারা সন্ধানে মোকাবিলা প্রতিনিধির নাম ধরিয়া হাঁক ডাক করায় এক ভদ্র মহিলা মুখে মাস্ক পরিহিত, মানে কাইন্ডলি সি দ্য স্টোরি, মুখে মাস্ক পরিহিত, we have crossed the COVID period long back. মুখে মাস্ক পরিহিত নিজে,
might be she was playing with a child.
Child was not born then.
That's why we are a child after the
child. That's not serious actually. Yes.
পরিহিত নিজেকে প্রতিবাদী বলিয়া পরিচয় দেন.
Even if she did not have the mask, the process server might not have recognized her.
Then, Milord, the surprising part, Milord, comes later. Milord, kindly see, Milord. নিজেকে প্রতিবাদী বলিয়া পরিচয় দেওয়া এবং পাশের লোকজন, আশেপাশের লোকজনকে কহেন ইনি প্রতিবাদিনী আছেন, তৎসময় তাহাকে অত্র পরোয়ানা মর্ম অবগত করিয়া রসিদ প্রদানে যাহা গ্রহণ করিতে বলায় তিনি অত্র সমনাদি দেখিয়া বুঝিয়া নিজ স্বাক্ষর করিয়া পরোয়ানা গ্রহণ করিতে অস্বীকার করেন। Therefore, I refused. তিনি কহেন আমি কোনো স্বাক্ষর করিব না, এমতো অবস্থায় প্রতিবাদী তাহার পক্ষে অত্র পরোয়ানা স্বাক্ষর করিয়া গ্রহণ করিতে অস্বীকার করে ও পরোয়ানা প্রতিবাদী দরজায় গ্রহীত লটকাইয়া জারি করিল। This is the standard. Now, my lord, what is the date? 24 June 2023. This is the date. Now, my lord would kind enough to come to page 52. Kindly see, Milord, the parties, Milord, when the matrimonial suit was filed, the parties were residing at Dubai. Kindly see, my lord, this is Priyam Jatua's mother wife's, my lord, passport.
Raghunathpur, West Bengal, yes.
Yes.
Dubai, how do you know?
I'm showing, my lord,
Ah, sir.
both the parts. Yes, my lord.
Yes.
Kindly comes to page 53.
Yes. Raghunathpur is your matrimonial home?
Matrimonial home. I'll also show that. I'll also, page 53. Kindly see, my lord, on the right hand side, my lord, there is a, my lord, immigration seal given arrival 11 July 2022 on the right hand side of the page. The round seal, my lord.
53, yes.
Page 53, 11 July 2022.
Yes.
And just on the left hand side, kindly see 28 October 2022. There is a square. And before that, my lord, kindly see its the departure. Just above 28 October 2022, there is a remark departure. Therefore, I came to India on 11 July 2022 and left India on 28 October 2022. Then, my lord, kindly see just above that.
You have the original of these documents also?
Yes, exactly. My lord, then, my lord, kindly see above that. Kindly see on 19th September 2023, I again came to India. And on 28th October 2023.
No, 19th September.
2022.
In between, you must have left on 11th July 2022, you arrived.
2022. No, a departure. 11th, I arrived in India.
11th, you arrived.
And on 20.
Arrival is on 19th September 2023 again.
That is 2023. I am on 11th July.
But 28th October is after 19th September.
Yes, no. Kindly see, my lord, on 11 July 2022, I came to India. This one, my lord, this one.
Yes.
On 11 July, I came to India.
Yes.
Then I went back from India to Dubai on 28th October 2022.
Oh, yes.
Departure.
2022, right.
Then, my lord,
both dates are 28th October, so I confused.
Right. Yes. Then,
28th October 2022, yes. You
yes. Then, my lord, kindly see the above, my lord, round seal. I again came to India on 19th September 2023, arrival.
Yes.
And went back on 28th October.
Right.
Therefore, my arrival in 2023 in only is on 19th September and 28th October. I came to India.
Between this period.
I was in India. Therefore, this process server could not have said, my lord, on 24th June 2023. He went there. He called by my name. I I came out with a mask and I refused to sign. This is the first, my lord, fraud played on the
court. Is it your case? And there is any other lady living in that house?
Yes, exactly. Now, my lord, kindly see, my lord, the plaint. Kindly see the plaint. And this is my submission with regard to, my lord, ID card.
Regarding ID card.
ID card. This is my same submission because ID card could not have been, my lord, the summons by post could not have been served between, my lord, 25th May and 17th July. Order lordship would kindly have to recollect, my lord, order number 3 and order number 5. Now, my lord, kindly takes up page 19, the plaint. Kindly see, my lord, what was the, my lord, address given at page 20. Kindly see, my lord, Priyam Malik Ni Jatua, wife of Biplab Malik, daughter of Anando Jatua, residing at 13 Rajani Kumar Kanto Shen Lane, PS District and Howrah. Well, this is the place where, my lord, admittedly the summons were served by postal receipt, allegedly served, and also where, my lord, the process server had also gone. This is, my lord, the address which was given in the plaint. Now, my lord, kindly takes up, I have made specific, my lord, averment in the revisional, in this section 5 application, my lord, kindly comes to, I have given, my lord, documents. Kindly comes to, my lord, page 60. And page 59, page 59. Page 59. My lord, kindly see, this is the last page of my passport. Kindly see, AB 335, Shomorpolli, Milan Bazar, PO Krishnapur, North 24 Parganas, PIN 70010 West Bengal. This was my lord, paternal house. This is my address of my paternal house.
So what was there in Howrah?
Nothing.
No, you say that your Raghunathpur or Raghunathganj, there you are staying, that was your matrimonial home, and this is your paternal home. Nothing was there.
My paternal home, my lord, is the address which, my lord, the husband has given, my lord, page 19 at the plaint.
Page 20, that is the paternal address.
Page 20 now.
No, page 19. Page 19. Husband's address is the paternal address. Is the matrimonial address. Husband's address is
Say that matrimonial.
Yes, I'm sorry, my lord. Yes.
So 13 Rajani Kumar Kantolin
is not any way connected to me. Kindly see, my lord, page 60. Page 60. This is my Aadhaar card, my lord. Kindly see, my lord. Same AB 335, Somorpolli, Milan Bazar, Rajarhat, Gopalpur.
So Somorpolli Milan Bazar, this was your, this is your paternal.
Paternal. Then, my lord, kindly comes to page 61. This is page 61. This is, my lord, Khaddo Surokkha, my lord, Jojona ration card. Address. Kindly see, my lord, the address just above the barcode.
Dealer address.
Kestopur.
No, এটা নিচেরটা, sorry, এটা dealer address.
Oh, kindly see just below the barcode, just below the address AB 335, Somorpolli,
Yes,
Milan. Then, my lord, kindly see, my lord,
Somorpolli, yes.
Yes, page 62. Page 62.
But these were before your marriage.
These were before your marriage, all throughout, till now. Till now. And, my lord, when the, my lord, as matrimonial suit was filed, both the parties, my lord, were residing, my lord, at Dubai. Even, my lord, I'm surprised. My lord, এটা দাও বাচ্চার birth certificate annexure দাও. Which number?
The marriage certificate at 40, birth certificate.
Page?
Second, এটা তো page number দেওয়া নেই.
Yes.
Marriage certificate at 40.
Kindly see, my lord, yes, page 31. This is the birth certificate of the child.
How old is the child?
A child was born on 14th March 2025. Not even 1 year. My lord, that is another ground for condonation. My lord, by this time I was, my lord, looking after the, my lord, and still, my lord, 2025, 8 months old. That is another. My lord, kindly see name of the father. Father is applying for birth certificate. Name given Biplab Mollik, still not informing her that by that time, my lord, expertise degree has been passed. She was present in India when the child was born.
When was the degree passed?
Degree was
2023, your lord.
2023. We were not aware of anything.
October 2023.
16th October 2023. Father was present.
How do you know the father was present?
My lord, name is name of the father. My lord, kindly see 31.
Name of the father you might have given.
My lord, my instruction is that, and my lord, kindly see paragraph 35
of the father
my.
Depends on the mother has to be there.
Yes.
If a child is born, but
Yes.
father might not have been there.
Yes. Kindly comes to, my lord, page 14, para 35.
What address are we?
And page 13, para 30.
How do they explain? Does the husband say in his plaint that you had shifted to this 13 Rajani Kumar Kantole?
I could not.
Anything of that sort?
My lord, kindly see, my lord, jurisdiction.
Yes, para 14, page 25. Started to live with her boyfriend at his house at such and such. That is the allegation.
That is not the allegation, but, my lord, adultery.
But Mr. Bhattacharya, what you are driving at is not to poke fun at your client. What we are driving at is maybe your matrimonial home was somewhere else and Dubai is another aspect. Matrimonial home is somewhere else, Somorpolli. Sorry, the other place, Howrah. Paternal home at Somorpolli. You might have been residing in a third place, which is 13 Rajanikanth.
No, we kindly appreciate.
But if you're in Dubai, that's a different ball game altogether.
Exactly. We were living together at that point of time. He came here, my lord, he filed a suit, my lord, fictitious address, and my lord, kindly see who are the persons. And my lord, I will also be placing, my lord, order 5, rule 17 and 19.
But even then, at 13 Rajanikanth, before the expedited degree, any evidence must have been laid by the husband.
My lord, order sheet says, my lord, kindly see, my lord, the order sheets, my lord, 13th October 2023 order, my lord, from the memorandum of appeal.
What does it say? You have annexed the entire order sheet.
All 13th October, my lord, order number 6.
বয়ফ্রেন্ডের বাড়িতে পাঠালো সেই বয়ফ্রেন্ড ওখানে এসে নিল রিফিউজ করলো
My lord, jurisdiction cannot be, because Hindu Marriage Act says either where the husband resides or wife resides, or where
no
both of them.
still it's Howrah. That is also Howrah.
That is also
The jurisdiction is Howrah.
Howrah. Or where both of them will not permanently residing together.
Yes, matrimonial home is the last part. So therefore jurisdictionally it's correct.
No, lastly resided together in Dubai.
Suit has to be filed in Dubai.
My lord,
No.
Special Marriage Act.
Dubai, you went there. You did not go with the intention of permanently settling there.
No, both
Last
both,
decided there has to
both
be
the parties were working.
an element of permanence has to be there.
Yes.
That is settled now.
That is it. Kindly see, my lord, 13th October 2023. And my lord, another thing, order 5 rule 17 tobacco.
No, but this requires some hearing, Mr. Bhattacharya.
Your
This is
lordship,
the,
will we decide about the limitation first?
We are deciding on the limitation only.
No, no,
They are trying to say that there was no service, therefore they did not know about this.
there is till from the date they came to know.
We are not deciding on the appeal, ma'am. We are deciding on the section 5. His point is that he never received that summons. You duped him and you obtained that expertise degree without serving summons. That is German in the section 5 also. That is his case.
What my
So we are hearing the section 5, not the appeal.
and my lord, before my learned friend starts.
But they are entitled to an opposition, we say.
Definitely, my lord.
What have you brought out?
My lord, order 5.
Obviously,
Order 5 rule 17, 19 mandatorily has to be complied with. Not
that is a stock argument in all the experts.
Your lordship, what I'm
it
submitting.
has to be complied with, because there is a Calcutta amendment now.
Your lordship, what I'm submitting is they have came to know about the let us suppose that they have no knowledge, allegedly, that they didn't know about the case or something. They came to know, it is from their submission. They came to know about the case on 20th of September 2024. From she came to know from that. In paragraph number 13, your lordship, you will see that when she got pregnant, since she had a miscarriage, her doctor has advised her not to travel long distance. That is why she never gone back to Dubai. She had, I have prepared the date. She had gone to Dubai on 14th of September 2024 when she had no knowledge, allegedly. Her parents came to know about the divorce, and on 20th of September 2024. She came back on 23rd of September 2024, and since then she has not taken any step. The matter is filed on 23rd of May 2025.
No, when do they say? Where do they say they came to know of the divorce decree?
It is from
Paragraph?
Yes, your lordship.
Which paragraph?
Yes, kindly comes to page 14, para 36 onwards. I'll be placing that. Your petitioner states that thereafter it appears from that the plaintiff opposite party had made all attempts to get the ex parte decree by not serving the summons upon the defendant petitioner herein. 37, your petitioner states that although your petitioner had come to know the aforesaid fact from record of the trial court in the month of October 2024, it was impossible for your petitioner to take immediate steps before the court of law due to advanced stage of pregnancy of your petitioner and the subsequent birth of the male child on 14 May 2025. Your petitioner states that after the birth of the male child of your petitioner on 14 May 2025, your petition 14 March, not May, March, your petitioner was busy taking care of the infant, and as a result of which it was not possible for your petitioner to take immediate steps in this regard, leaving behind the said baby alone at home. It was only on 19th May 2025 your petitioner contacted.
But this is plausible.
Your lordship, in
8
paragraph
months, as of today, 8
19,
months old.
If they did not have knowledge of the suit, this is quite plausible.
In
She was carrying and the baby was born on 14th of.
Came back on 23rd of September, your lordship, from Dubai. She came back from Dubai on 23rd of September when it's a first trimester. She traveled from that distance. It's not plausible, your lordship, and she couldn't take any step in Howrah, staying in Howrah.
We don't understand. Please repeat.
On 20th of September 2000, it's paragraph number 19, your lordship, page 9.
Yes.
On 20th of September, her parents get to know that a suit has been filed, decree has been passed of divorce.
Paragraph 19.
Paragraph 19, page 9. May I read it, your lordship?
Yes.
Your petitioner states that the learned advocate, after conducting thorough searches in the record department of the Howrah court,
Yes, yes.
intimidated the father of your petitioner on 28th of September 2024 that the opposite party had filed a suit for dissolution of marriage, being matrimonial suit number this and this, before the Court of Additional District Judge First Court at Howrah on 18th May 2023 and had obtained an dictum on 16th of October 2023. The date is 20th of September 2024. She came to know. She came back to India, traveled from Dubai on 23rd of September 2024. Kindly turn to page number 54.
So you say that she could travel from Dubai to India on 23rd of September
Yes,
2020.
3 days. Only after having knowledge, 3 days. She came flying miles and couldn't take taking step after 8 months. Even the child has born on has been birthed on March. They're taking step on me. This limitation is not plausible, Your Lordship. The grounds.
Admittedly, you had knowledge on 20th of September.
Yes, sir.
Yes, my lord. I could not have, my lord.
You flew from Dubai to
Yes.
India 3 days after that.
Yes.
And you could not take steps in
I
the
could
suit.
not, because that was at the advanced stage of pregnancy. Then, my lord, I have
Stage of pregnancy, you could fly to Dubai, you could come back from Dubai. What is
yes,
this?
yes, kindly, yes.
3 days after that.
Yes. I'll kindly
You come back from Dubai on flight, and after about that's September, so 6 months after that, the baby is born.
Yes.
So for 6 months, you are in such an advanced stage of pregnancy that you could not
This
take
was
steps in the suit.
kindly comes to, my lord, paragraph 13 and 14.
And if you're actually your parents could get that information through advocate, they could also take steps on your behalf for filing the suit.
That is there, my lord.
Get the
but
Vakalatnama signed and file the suit.
But yes, that is there, my lord. But admittedly, my lord, summons
6 months you have no explanation actually.
There is no explanation because I
Have you remarried?
No, Your Lordship.
Yes, my lord.
Don't marry.
They have
file your
posted-
opposition.
Lord, they have already
We
posted.
put that in our order.
Your Lordship, what I'm submitting is they have already filed an Order 9, Rule 13 for setting aside the expertise order at Howrah. Let them fight there. If they do not get the order of what they want, they can still file an appeal here. Then there will be no
Scope is a
limitation.
bit different. They can conduct to both at the same time.
Yes.
There's no bar.
What I'm asking is,
And I'm ready, my lord, with answer, my lord, on that point, my lord.
No, she's not taking that point. She says yes.
I'm saying yes, you can. I'm
But
asking
the
that
remedies can be concurrent remedies can be availed.
what I'm
Do you like to use an opposition, or should we decide this without opposition? Whatever you choose.
like to file an opposition, Your Lordship.
Do it within a fortnight.
But he is at Dubai, Your Lordship. If it is in opposition, he has.
Oh.
Your Lordship grant you 1 month of time.
But you have to restrain him from remarrying in the meantime.
Yes, Your Lordship, you restrain him from remarrying. He is not.
So
going to
what is the reasonable time for you to tell us?
1 month, Your Lordship. Or
1 month will give you 1 month. If you restrain you, then we'll give you 1 month. Learned counsel for the respondent, heard learned counsel for the petitioner on the application for condonation of delay in preferring the appeal at length. Full stop. At this juncture, comma, it transpires that since certain serious factual allegations have been leveled in the application, comma, the respondent, the respondent husband seeks to use an affidavit in opposition to the condonation application. Full stop. Accordingly, the respondent is directed to file his affidavit in opposition to this is can 2 or 1?
Can 1.
Can TO2 can 1 of 2025 by November 21, 2025. Reply, if any, shall be filed.
December, Your Lordship. That date.
No. Today we are on 28th of October. We are granting you till 21st of November, 1 month, almost one. He'll not be coming back in.
I have no knowledge. I have to inform him. He has to come back.
Tell him about the injunction order. He'll come back. We will giving you till the end of November.
Yes, sir.
By November 28, 2025. Reply, if any, 2 weeks.
Yes.
Reply, if any, shall be filed by December 12, 2025. The application shall next be listed on December 15, 2025. The respondent shall not contract any marriage with a third party in the meantime, during pendency of the application.
Item number 46.
অপোজিশনে কি বলে দেখি
রেসপন্স অরিজিনালি তো এতে ছিল ওরা রিভিউ ফাইল করেছে
শুধু যদি মিস মানে অ্যাডভান্স স্টেজ হয় তাহলে মুশকিল আছে 6 মাস আগে থেকে advance stage একটু বড় চাপ একটু প্লেনে করে ফিরছো
না বলে দিন
The review has been filed by the respondents against your lordship's order.
review has been this is a review application.
Yes. Your lordships have passed an order that the tribunal should direct that I be put in possession of the property.
with police help.
With police help. Now, they've come up with a review application. And when we place this order before the tribunal, they wanted to file an affidavit in opposition against the order of your lordships. And it was adjourned on 2 days.
The affidavit in opposition to what?
To our application, which had set down your lordship's order. In fact, it was an affidavit in opposition against your lordship's order.
No, not
And that was allowed. That it was adjourned. So the affidavit is filed. Till date, they have not filed the application, of course, before the.
So review, is there review application? Let us hear them. Yes, what
No,
is it?
this not is that.
No, my lord, I am for the state in this matter.
Oh,
Mr. Ghosh has filed, Mr. Ghosh's client has.
Mr. Ghosh means which Mr.
Mrinal Ghosh.
Minal Gandhi Ghosh.
Mr. Miral Kanti Ghosh. If your lordship kindly takes it up after the 5th, my lord.
After 5th?
Yes, after the 5th.
None appears for the review applicant at the time of call, although the respondents are represented through counsel. Push up. In view, learned counsel for the private respondent submits.
No, I am for the petition. Basically, I am for the petition.
Now, in the review application,
Yes.
private respondent in the review application submits that he will be in some difficulty prior to November 5, 2025. Push up. Accordingly, let the matter stand adjourned till November 6, 2025. 6 now.
November 6th.
Item number 47.
47, my lord, I'm appealing for the appellant petition.
Yes.
Lord, my application is for injunction, where I pray, my lord, not to alienate or encumber the property.
What is the appeal arises
Yes.
out of?
My lord, the appeal arises out of a decree, my lord, passed against me, my lord, my suit has been dismissed. My lord, where, my lord, I pray for specific performance. Now, my lord, the ground, my lord, for which the suit stood dismissed is, my lord, that I have not been able to show, my lord, I am the vendee, my lord, I have not been able to show the title of the vendor. Now, my lord, yes. Now, my lord, what happened, my lord, here, my lord? My lord,
Title of the vendor.
yes.
You have not been able to show the title.
Because I have filed specific performance of suit against the vendor, my lord, to contract sale in favor of me, my lord. To execute, my lord, the sale in favor.
Oh, right.
Now, my lord, the question, my lord, it was ex parte. My lord, they did not choose to neither contradict my stand which I have taken in my plane.
Did they never appear in the suit or?
Never appeared. Never appeared. Now, my lord, the very, very critical issue, my lord, here is, my lord, the vendor who happens to be, my lord, the guardian appointed by the court with regard to the both minor body and the property. The minor, my lord, after being appointed.
It was a minor's property.
It was a minor's property.
So he took leave from the court.
Now, my lord, tell your lordship, my lord, he was appointed on 1966. My lord, the minor went missing in 1975.
Mr. Chatterjee will decide, take it up tomorrow. We will not pass orders like this. This will take some time.
It will take some time.
I'm sorry to bother.
Yes.
My lord, item 25 was dismissed. My junior has failed to mention it was a legal aid matter and he could not be allotted the brief, my lord.
Ms. Bose, we dismissed the matter because your junior was very arrogant.
My lord, I apologize on his
We
behalf, my
told
lord.
him specifically, he
I understand, my lord.
insisted twice. He insists, is he here in court? Please bring him because we want him to know why we dismissed it. He's still in his early years, Ms. Bose. We were never intending to dismiss it.
My lord, I have
He
got the
insisted,
prescription also for my verdict.
we are
my
not
lord.
disbelieving you at any point of time, but he said categorically that
I apologize for his miscommunication.
he insisted that yesterday he had asked for a, not this week,
That was very
but
wrong, my
but
lord.
we granted him 1 day's accommodation. We said that yes, you paid for that. We had given you 1 day's accommodation.
He had
Today he says
declared
yes, I'm today also asking for that. He was very arrogant and
My lord,
he's quite in his early years. So
I
he
tender
should
my
know why
apology,
it
my
was
lord.
dismissed.
I tender my apology, my lord.
But that order has been passed in open court. Now it's later part of the day, somebody might have been watching. We'll put it as to be mentioned tomorrow, but we cannot do anything. To be mentioned also won't do, because that order was passed in the morning, Ms. Bose.
My lord, I could not, my lord, I'm in medication, my lord. Whenever I have to come, I have to take a medication before that, my
No, you
lord.
need not come, but
I have worked very hard for this matter, my lord. It's a legal aid matter. Widow has been displaced from.
which is the item number?
Item 25, my lord.
25 কালকে to be mentioned দিয়ে দিন। অর্ডারটা হবে ওপেন কোর্টে অর্ডার হয়েছে, অর্ডার থাকবে, অর্ডার কিছু করার নেই। Order was passed in open court, Ms. Bose. It will be there. Tomorrow we'll recall that order. But tomorrow, if it's difficult for you to come, ask somebody else from the.
Just a medication, my lord. If I have it early in the evening, I can come early morning. It's the vertigo is not happening continuously. It's happening suddenly.
But if it happens when you come to court, then we'll be liable.
My lord, I'll have the
Send
medication.
somebody else from the legal aid.
My lord,
Somebody
my lord, I'll do it myself.
ask him or her to remind us that you had mentioned them at this afternoon.
My lord, I'll do it myself, my lord. I'll come.
Tomorrow to be mentioned first thing in the morning. ওই আইটেমটা থাকবে। আজকের অর্ডার যেরকম আপলোড হচ্ছে হবে।